Comme il est 11h05,
Given it is 11:05, the Chamber will now address private members' business according to the order on the notice paper today.
Members' business, resuming debate at third reading of Bill S-236, recognition of Charlottetown as the birthplace of Confederation Act, standing in the name of Mr. Easter.
the Honorable... Well, actually, I was going to say that someone had 5.5 minutes remaining in their speech, but that's that opportunity. Oh, we can't go forward with that right now. So I'll go on to the next speaker, the Honorable Member for Simcoe Grey.
Thank you very much, Mr. Speaker, and it gives me great pleasure this morning to rise today and speak to S-236, an act to recognize Charlottetown as the birthplace of Confederation. Confederation is an important event for Canadians, but especially for Conservatives, since two Conservatives, Sir John A. Macdonald, our first Prime Minister, and Georges-Étienne Cartier, a Minister and Quebec Lieutenant, were involved in making sure that this country came together. Sir John A. Macdonald, as our first Prime Minister, was at the Charlottetown Conference that took place between September the 1st and 7th of 1864, which changed the course of Canadian, North American, and world history. For what would Canada be if not for Sir John A., a man with a vision of a Canada from coast to coast, and of delegates in Charlottetown recognizing that we would actually be stronger together? On how would the manifest destiny so loudly proclaimed by our southern neighbours have turned out? They had tried invasion once before, only to be foiled by a combination of British redcoats, English and French-speaking Canadian militia, and loyal Indigenous warriors who worked together to bravely keep the invading Americans at bay. We managed in that campaign to occupy Detroit and burn down half the White House, but that's another story. While we had repelled the Americans once before, many here in British North America at that time were very worried about a potentially victorious Union Army turning its Civil War guns north and taking our territory. They had already taken a good chunk of Mexico only 20 years earlier. Many of our early leaders thought that we would be stronger together than we would be apart. And they were most certainly correct. We cannot say for sure if Confederation kept the Americans from launching a second invasion, but it certainly didn't hurt. Since Confederation, what about the contributions that Canadians have made to the world? In sports, medicine, industry, science, and our brave contribution to numerous wars, conflicts, and peacekeeping operations where Canadians have always punched above their weight. These contributions were certainly aided by an optimistic and forward-looking country that continues to defy the odds. Just think, if Canada did not form as one, if each region of our nation was its own entity, would different parts of Canada have the same voice internationally as our United Canada has had throughout our history? I would say likely not. We would not be in the G7. We would not have the same sporting record, particularly Team Canada, women and men internationally on the international stage, and we would not have the envy of a list of inventors like Sir Charles Banting, who is from my riding of Simcoe Grey, and we would not have come together in that meeting. We would not have had that opportunity in Charlottetown in 1864. Charlottetown was in many ways the ideal location for such a conference, not involved in the daily tug-of-war amongst the provinces of Canada, nor the larger maritime partners of New Brunswick and Nova Scotia. Charlottetown and Prince Edward Island were a neutral ground where all players could speak freely. And did you know that at that conference, The delegates from the regions that now represent Quebec and Ontario were actually not even invited to begin with. The original conference was to discuss a maritime union, one between New Brunswick, Nova Scotia, and Prince Edward Island. When the province of Canada heard about the conference, they invited themselves. An invitation to pitch a full union between the Maritimes and the province of Canada. While welcome, their arrival did not stir much excitement. And why is that? Quite literally, because a circus had come to Charlottetown for the first time in 20 years, and the whole town was occupied with those sights and sounds, not something else. Now, having been recently at my own party's leadership convention, I can tell you that it was right beside an anime convention. I have a pretty good idea what was going on in Charlottetown that day. Despite the lackluster start, meetings proceeded over the next few days with great success. And what was even more successful were the relationships forged between individuals from across our then fledgling country. And I'm sure that the welcoming and friendly atmosphere still present today had something to do with building those friendships in Charlottetown. And I'm also quite certain that the boatload of champagne that today would cost about $200,000 contributed just a tad to making sure people got along. That is Charlottetown, Mr. Speaker, Madam Speaker. Each time that I have visited, I've felt the warmth of its presence. And in fact, for myself and my family, just in the last year, this past February, I learned of our own family farmstead, the Conway Farmstead on Prince Edward Island. Charlottetown is friendly. Friendships are easily made. Charlottetown stays in your memory. There is no place in Canada that I could think would have been a better place to host the leaders of the Maritimes and the province of Canada. And it certainly worked. Charlottetown, aided by a little bit of champagne, charmed the delegates into a unanimous support of creation of a united Canada based on the values that we hold dear today. There were a number of steps afterwards that led to the creation of Canada and what we would be known to become on the international stage. Quebec, a month later, nailed down the final details, then meetings in all the colonies to approve the Union, and then finally in London in 1866, the approval of Her Majesty, Queen Victoria. But Charlottetown is where it started. And for this, Madam Speaker, I am happy to say that Charlottetown is the birthplace of Confederation. It's also why I'm happy to support this bill. Thank you very much. Merci.
Resuming debate, reprise de débat, the honourable member for Egmont.
Thank you, Mr. Speaker. Madam Speaker, my apologies. Madam Speaker, I'm pleased to rise in the House today and speak in support of Bill S-236 that was introduced by my colleague, the Member of Parliament from Malpak. And actually, it was interesting listening to my colleague, the Member of Parliament for the Opposition Party, speak about the recognition that indeed Charlottetown is the birthplace of Confederation and the birthplace of this wonderful country that we still call Canada. Why, Madam Speaker, I wanted to speak in support of the bill today is because my political career began in the Legislative Assembly of Prince Edward Island, and I will be the only member that will be voting in support of this piece of legislation that will have been, that have actually sat in the chamber of the Legislative Assembly of Prince Edward Island, where I hope this House will recognize it as the birthplace of this wonderful country. And to that, Madam Speaker, I take a great deal of honor of having sat in that assembly and now being here in the House of Commons when this bill is being debated on the floor here. Madam Speaker, I want to, rather than go into the history of how the meeting came about, and history documents that well, that it was a meeting organized by maritime colonies to consider a union amongst maritime colonies, and then the Upper Canadian colonies invited themselves literally to attend the conference. And from that, it is documented in history that through that conference, it was created a shared vision of a union of the British North American colonies and the creation of this new country. And Madam Speaker, when you look at Canada today as being a beacon in the world for people that are fleeing oppression, war, various other atrocities that are occurring across the world. We look at the creation of this country, and what I'm particularly proud of as a parliamentarian today, sitting in the House of Commons, is the diversity of the people that now represent this country sitting here in the House of Commons, and the backgrounds which they have come from. In my own case, Madam Speaker, on my father's side, my ancestry is Irish, and we all know the Irish fled Ireland in the Great Famines to come to a new world for new opportunities, and they found that in Canada. They found it in Prince Edward Island. And on my mother's side, Madam Speaker, my ancestry is French-Acadian, and my ancestry fled the expulsion at Grand Pre in Nova Scotia. So they were fleeing strife and war, and they found a welcoming environment in Prince Edward Island. And to this day, Madam Speaker, this country still reaches out to people that are fleeing various oppressions, fleeing war, and fleeing a number of atrocities from across the world. And that's what Canada is all about, and that's why I'm proud to be a parliamentarian and stand for those freedoms and rights. And we cannot forget, Madam Speaker, that it was our Indigenous people that welcomed us, regardless of our cultural background, welcomed us here. And in Prince Edward Island, it was the Mi'kmaq of Prince Edward Island that welcomed the Acadians as they were being expelled by the British from Grand Pre in Nova Scotia. And they welcomed the Irish as they were forced to flee Ireland for famine. So today have the opportunity to speak in support of Bill S-236 that would recognize Charlottetown as the birthplace of Confederation is indeed an honor for me. As I indicated, having served in the Legislative Assembly of Prince Edward Island for 18 years, and when I can recall the first time I took my seat in the Legislative Assembly of Prince Edward Island and looked around and recognized the history of that chamber, although small, but the history that that chamber had with it. And from that meeting in that chamber, then this wonderful country, this great nation called Canada came about. And so we owe to our forefathers who had the vision at that time to recognize that we had to overcome a number of obstacles and disagreements to come up with a shared vision. And that shared vision continues. It's debated from time to time, and each new parliament adds a dimension to that vision as Canada evolves as a nation on the world stage. But from where we are today, it all began in Charlottetown, Prince Edward Island. So, Madam Speaker, that's why I'm pleased to speak in the House of Commons here today, now as a Member of Parliament from Prince Edward Island, in support of Bill S-236 that will recognize Charlottetown as the birthplace of Confederation. Thank you, Madam Speaker.
Resuming debate. Reprise de débat. Excuse. C'est McKinnon, Gatineau. L'honorable député de Gatineau.
The Honourable Member for Gatineau. Thank you, Madam Speaker. I rise in this House to support Bill S-236, which is before us today.
Considerable pride as I join my colleagues who represent the great people of Prince Edward Island. I do so as a proud native of the city of Charlottetown and a proud son of Prince Edward Island. The fact is that this bill, as necessary as it has now become, is really just a statement of historical fact. In 1864, the Fathers of Confederation came together on Great George Street in Charlottetown to lay the foundation and lay the principles of what has become today a great nation. And the people of Charlottetown and the people of Prince Edward Island throughout my lifetime and before have always celebrated the fact with great pride and distinction that it is there in Prince Edward Island that this country was born, that those who have founded this great country have put the principles and the compromises in place that made Canada what it is today. So very briefly, Madam Speaker, I wanted to, again, as a son of Prince Edward Island, add my voice and my support and my thanks to my colleagues from Prince Edward Island, to the member from Malpeque, who I've known for many decades, the member from Egmont, who I've known for many decades, and all of the great people of Prince Edward Island. I express with considerable pride and with considerable passion my support for the bill before this House. Thank you very much.
Resuming debate, reprise de débat. The honourable member for Malpeque has the right to reply for 5 minutes.
Thank you, Madam Speaker. This is the moment we've been waiting for, and I will conclude with many thanks to all colleagues who have contributed to the debate and the discussion of Bill S-236, an act to recognize Charlottetown as the birthplace of Confederation, including especially those who took the time during third reading to express their vision for Canada's future. And I want to just re-quote 3 members from each of the parties. The member for Carleton Trail, Eagle Creek, with the official opposition, she said this, quote, "This bill gives us the wonderful opportunity to remember and honor our national history, to recall the humble beginnings and soaring dreams of the first of our leaders who dreamed of a united Canada." She went on to say, "I cannot think of a better way or a better time for us to celebrate our accomplishments both at home and around the world than by passing this bill in this, she didn't use the word 150th year, but that's what she meant." The member from Victoria with the third party, he said, quote, "Being proud of a country's heritage and commemorating important historical events is worthwhile for most countries, but I think it is especially so for Canada. We should feel proud of our accomplishments. We are a country comprising remarkable diverse regions and remarkable diverse people." As Canada went on to say, as Canada moves forward to the next 150 years of nationhood, I hope we can strive to be more inclusive of other voices and cultural narratives so that they might also be celebrated and acknowledged. End of quote. And the member for Charlottetown, he said, quote, "As we celebrate the 150th anniversary of Confederation, we can see the evolution of our country, our democracy, and our values. Our very roots, as evidenced by what took place in Charlottetown, were not about conflict or war. They were about finding mutual ground and working out our differences," end of quote. So, Madam Speaker, I think those 3 quotes from 3 different parties in this House sums up to a great extent what Canada is all about. The passing of this bill means a great deal to Prince Edward Island and to our provincial legislature, who passed an unanimous motion encouraging the support of parliamentarians, and to the Atlantic region as we share and develop the Confederation story. For Canada, this has been a chance to recognize and honour Confederation and reflect on important ways in which we must work to shape the future of our country. And Madam Speaker, to close, you know, it's the character of Canada. It's that vision that was founded in 1864, some of the things coming out of that meeting, that we are a country that works by negotiation. and we're seen on the world stage in that light as well. It's that idea of coming together in common cause that has shaped our history since its founding. The Charlottetown Conference certainly may be viewed as the watershed moment in the story of Confederation, the point at which Confederation turned from idea into prospect. This is what Bill S-236 is all about: recognition of Charlottetown as the birthplace of Confederation. I and my colleagues humbly ask for this House support in this year of Canada's 150th celebration. It seems quite appropriate to do it at this time. Simply put, I ask the House, let's get it done and pass Bill S-236. Thank you, Madam Speaker.
The question is as follows. Mr. Easter, seconded by Mr. Morrissey, moved that Bill S-236, an act to recognize Charlottetown as the birthplace of Confederation, be now read a third time and do pass. Plaît-il à la Chambre d'adopter?
Is it the pleasure of the House to adopt the motion?
Que tous ceux qui appuient la motion...
All those in favor of the motion will please say yay.
Que tous ceux qui s'y opposent...
All those opposed will please say nay.
In my opinion, the yeas have it, of course. I declare the motion carried.
Third reading of this bill. Conseil d'adoption de ce projet de loi.
En conséquence, le projet de loi est
Bill S-236.
Okay. Accordingly, the House is now suspended until noon. Orders of the day, ordre du jour.
Orders of the day. This is Bill C-51, an act to amend the Criminal Code and the Department of Justice Act and to make consequential amendments to another act.
We'll now proceed without debate to the putting of the question on the motion to concur in the bill at report stage. Ms. Bennett for Ms. Wilson-Raybould, seconded by Mr. Sajjan, moves that Bill C-51, an act to amend the Criminal Code and the Department of Justice Act and to make consequential amendments to another act as amended, be concurred in that report stage. Plaît-il à la Chambre d'adopter cette motion? Oui! Carried. Quand ce projet de loi sera-t-il lu une...
When will this bill be ready third time? Now.
Ms. Bennett for Ms. Wilson-Raybould, seconded by Mr. Sajjan, moves that Bill C-51, an act to amend the Criminal Code and the Department of Justice Act and to make consequential amendments to another act, be now read a third time and due passed. Debate. The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Merci, Madame la Présidente.
Thank you, Madam Speaker.
Introduced Bill C-51 on June 6, 2017. That day marked an important milestone in our ongoing efforts to make the criminal law fairer, clearer, more relevant, accessible, and compassionate. Since that time, Bill C-51 has been the subject of extensive and compelling debate both at the second reading stage and during its study by the House of Commons Standing Committee on Justice and Human Rights. I want to offer my thanks to the many members who have participated in these debates and to the members of the Standing Committee in particular whose deliberations have strengthened Bill C-51 through amendments which seek to further the objectives we identified when we introduced this important legislation. J'aimerais aussi exprimer
I would also like to extend my great appreciation to the many witnesses who took the time to examine the bill and appear before the committee, the Standing Committee on Justice and Human Rights. Although I may not agree with all of the points that were made by the witnesses who spoke to Bill C-51, I do recognize the importance of their contributions because they have allowed Parliament to have a rich and thorough discussion on Bill C-51.
I want to walk through the changes that are included in Bill C-51. These have received broad support in this House, at committee, and amongst key stakeholders. First, Bill C-51 seeks to address sexual assault, an issue which could scarcely be more relevant given the present Canadian and international discourse on this important subject. Survivors of sexual assault and other forms of sexual misconduct are standing up and speaking out as never before, Madam Speaker. I am proud to say that our government stands behind survivors and that we are adding our voice to theirs by bringing change on numerous fronts, including through the reforms set out in C-51. The bill proposes amendments that build upon an already robust legal framework that has been consistently regarded as one of the best sexual assault regimes in the world. However, despite its explicit acknowledgement that outdated myths about a victim's sexual history should have no bearing on whether she should be believed, and despite the clear rules about when consent is or is not valid in law, challenges remain. What are those challenges? First, we know that sexual assaults continue to occur far too often in Canada. According to Statistics Canada, there were approximately 21,000 police-reported sexual assaults in Canada in 2016. That is an average of 57 sexual assaults every day in Canada. That number is staggering, but when, according to the General Social Survey on Victimization, only 5% of sexual assaults experienced by Canadians over 15 are reported to the police, the likely number of actual sexual assaults that occur every day in Canada becomes unfathomable and could well be over 1,000 incidents every day. When thinking about those numbers and the fact that so many cases of sexual assault go unreported, we must think about what we can do to not only reduce the incidence of sexual assault in Canada, but also to ensure that more victims, and let's be clear, that this is a gender-based crime that disproportionately targets women and girls, that they feel encouraged to come forward to report their experiences to the police and to law enforcement. One way we can, at the federal level, help encourage women to come forward is through law reform that increases the likelihood that our laws will be applied as they were intended, and in so doing, reduce the potential for unnecessary distress experienced by victims who participate in the criminal justice process. That is what Bill C-51 proposes to do. As introduced, it makes important changes to clarify the law, including by making clear that consent must be affirmatively expressed by words or actively expressed through conduct. This principle codifies the Supreme Court of Canada's 1999 Ewanchuk decision and makes clear that there is no consent unless the complainant said yes through words or through conduct. Passivity is not consent. Nous proposons également de
We've also codified the principle set down by the court in its 2011 decision in JA, where the court held that a person cannot consent in advance to a sexual activity that occurs while they are unconscious.
Committee on Justice and Human Rights heard a number of witnesses on this particular amendment. Some witnesses expressed their support for this codification, but others argued it did not entirely or accurately codify the court's findings in JA. Those witnesses argued that JA stands for a broader proposition. They noted that the court held that our consent law requires ongoing, conscious consent and that partners have to be capable of asking their partners to stop at any point. Our government was listening carefully to witnesses and members, and we are pleased to support the committee's amendment to C-51 that codifies this broader principle from JA. Doing so is in keeping with the objectives of the bill, including to ensure that the criminal code is clear and reflects the law as applied by the courts, Madam Speaker. Madame la Présidente, les modifications...
Madam Speaker, Bill C-51's proposed sexual assault reforms do more, however, than simply codify key Supreme Court decisions. They will also create a new regime governing the admissibility of evidence in the hands of an accused person where that evidence is a complainant's private record. At its core, this regime is anchored in the following key principles. First, it respects the fair trial rights of the accused in that it does not prevent relevant evidence from being used in court. The Supreme Court has already recognized that an accused does not have a right to defense by ambush or other such procedures.
Second, it acknowledges the privacy interests of a complainant. While their privacy interests do not trump all else, the regime seeks to acknowledge that victims of sexual assault and other related crime, even when participating in a trial, have a right to have their privacy considered and respected to the greatest extent possible. Finally, the regime seeks to facilitate the truth-seeking function of the courts by ensuring that evidence that is clearly irrelevant to an issue at trial is not put before the courts with its potential to obfuscate and distract the trier of fact. These are important changes and ones that have been called for by Parliament. In their 2012 report on the third-party records regime in sexual assault proceedings, the Senate Standing Committee on Legal and Constitutional Affairs recommended the enactment of a regime governing the admissibility of a complainant's private records in the hands of an accused, and I am pleased that we are doing so as part of Bill C-51. The second major aspect of Bill C-51 is its proposal to clean up the criminal code by removing offences that are no longer relevant because they address conduct that is not inherently blameworthy, because the criminal law should not be used to target such conduct, or because the conduct is addressed by other offences of general application. To be clear, a foundational principle upon which our criminal law is based on that of restraint. This means that we as parliamentarians should ensure that criminal offences, with all of the attendant stigma and consequences associated with being called a criminal, are only used to address conduct that cannot or should not be addressed through other mechanisms. Bill C-51 reflects this principle by removing offences such as the prohibition on advertising the return for stolen property, quote, the no questions asked provision under Section 143, making crime comics, challenging someone to a duel, and impersonating someone during a university exam. Je suis confiant que le retrait de...
I am confident that removing these offenses will have no adverse consequences and will help to make our criminal law more reflective of the values that Canadians hold dear in 2017.
Bill C-51 makes other important changes to remove offences that are no longer pertinent in today's society. One such example is the removal of the offence of blasphemous libel under currently Section 296. This old offence, with its English origins in the 1600s, has as its purpose the suppression of criticisms directed at God, the King, and government. Such an offence is a historical holdover and has no place in a liberal democracy where freedom of expression is enshrined as a constitutionally protected right. In so removing this offence, we follow the example of the United Kingdom, which repealed its analogous offence almost a decade ago in 2008. Now, during the committee proceedings on Bill C-51, we heard testimony from the Centre of Free Expression that we should go further and that, in addition to repealing blasphemous libel, our government should be repealing the offences targeting seditious and defamatory libel as well. Although such amendments would have been outside of the scope of the bill, these are interesting suggestions and they do indeed warrant further discussion. I know, for example, that England abolished its seditious libel offences in 2009. I also know that there are divergent opinions on whether or not defamatory libel should be criminal. We have all benefited from the discussion on these proposals, and our government will take them under advisement as we continue to examine ways to make our criminal law and criminal justice system more reflective and responsive to the realities of Canada today. Before moving on, let me talk briefly about the amendments made by the Standing Committee to Bill C-51 and which is supported by our government that seeks to retain Section 176, the offence of interfering with religious services. As the Minister said when she appeared before the committee to discuss the bill, the repeal of Section 176 would in fact not leave a gap in the criminal law's ability to meaningfully respond to the conduct that is captured by this offence. She also said that its removal would not in any way undermine the ability of Canadians to practice their faith freely and free from violence. Both statements remain true today, Madam Speaker. At the same time, we appreciate and acknowledge that for many stakeholders, the removal of the offence would send the wrong message, and that in an era where xenophobia and religious intolerance and discrimination are all too frequent, Parliament has a responsibility to ensure that its actions do not, directly or indirectly, provide opportunities for the promotion of such intolerance. Our government was listening carefully to members of the religious community, and I am pleased to say that we will support not only the retention of Section 176, but an expansion of that section to ensure maximum inclusivity. J'aimerais noter ce qu'ici.
I would note in closing on this point, religious intolerance of any kind is simply unacceptable, and I know that the vast majority of Canadians, even when they may not share the same religious convictions as their neighbours, will conduct themselves in a manner that is respectful and welcoming. Intolerance that leads to threats or violence must be swiftly addressed by the police, and I know that the criminal law provides them with a broad range of tools to effectively respond to such conduct.
Bill C-51 also reflects our government's unwavering commitment to respect the Charter of Rights and Freedoms. It does so in a number of ways. First, Bill C-51 proposes to amend provisions that have been found unconstitutional by our courts. À cette fin, le projet de loi
In this vein, Bill C-51 builds on the work we started with Bill C-39, which we introduced on March 8th. Bill C-39, which would repeal provisions found unconstitutional by the Supreme Court of Canada, as well as the prohibition against anal intercourse that has been found unconstitutional by numerous courts of appeal.
Seeks to repeal provisions found unconstitutional by appeal courts and in some cases trial courts in circumstances where there can be little doubt as to their unconstitutionality. For example, Bill C-51 seeks to repeal the rule that prevents judges from giving enhanced credit for pre-sentence custody for offenders who were detained due to a bail breach. This rule has been found unconstitutional by the Manitoba Court of Appeal and creates a situation where similarly situated offenders can receive substantially different credit for pre-sentence custody, which can undermine public confidence in the administration of justice. Bill C-51 also proposes to amend a number of provisions that could result in an accused being convicted for an offence, even though they raised a reasonable doubt as to their guilt. Such an outcome is at odds with the most basic rules and fundamental principles upon which our criminal law is based, not to mention our charter rights. These changes are important, and we are not waiting for costly, unnecessary charter litigation to tell us that these rules are unconstitutional. Making these changes will ensure our criminal justice system is more efficient and continues to hold offenders to account while reinforcing the fundamental principle that it is the state which bears the responsibility of proving offences beyond a reasonable doubt. Our respect for the Charter, Madam Speaker, is also evident in the changes we are proposing to the Department of Justice Act. Although these changes have not been the subject of significant debate or commentary, a number of witnesses who testified before the Justice Committee welcomed this innovation in our law. Les amendements proposés par le
The amendments under C-51 will require our government and all future governments to table in Parliament a statement outlining the potential charter effects of all government legislation. The Minister of Justice has been doing this already as a matter of practice, but with Bill C-51 it will become an obligation. These charter statements provide information to Parliament, stakeholders, and the public writ large about the charter rights and freedoms that are potentially engaged by a bill and set out how they may be engaged.
Statement for Bill C-51, for example, the sexual assault reforms are discussed and an explanation is provided on how they interact with an accused's section right to life, liberty, and security of the person. The Charter Statement further notes how a failure to remove unconstitutional laws can undermine the rule of law, create confusion, and make our criminal code less accessible. I am proud of these reforms and believe that charter statements will quickly become a critical resource for justice system participants, parliamentarians, and the members of the public who are interested in learning more about how our laws may engage the Charter. Let me conclude by again thanking all members for their excellent deliberations on Bill C-51. The widespread support it has received is a testament to its importance and the need to move forward with these changes. I look forward to continuing to follow Bill C-51's passage through Parliament and will continue to work diligently to bring forward the kinds of changes needed to address the most pressing challenges facing our criminal justice system today. Merci, Madame la Présidente.
Thank you, Madam Speaker.
Questions and comments? Questions et commentaires? The honourable member for... I just drew a blank. Elmwood Transcona.
Thank you very much, Madam Speaker, and thank you to my colleague for his speech. It demonstrates the kind of breadth and scope of issues that are being addressed in Bill C-51. One of the ones that he addressed in his speech had to do with the modification of language around consent and what exactly that means, and trying to codify some of the jurisprudence on the issue in the law. My understanding is that there's a number of stakeholders. I had got to sit in briefly on some of the committee meetings having to do with C-51, and there was a lot of concern by stakeholders around the not the language of unconsciousness in itself and the inability to provide consent while unconscious, but the fact that the emphasis might be interpreted, or it might be argued by some, that the emphasis on unconsciousness might rule out some of the other very real barriers to providing consent being seen to be protected under the law. I know that our party and the Green Party both suggested amendments that might help belay some of those concerns, and they were defeated. The honourable member did mention some amendments having been accepted. Were there amendments accepted from the governing party on that particular issue, and if so, how do they address those concerns specifically?
The Honourable Parliamentary Secretary to the Minister of Justice.
Well, I want to begin by thanking my honourable colleague for his question. I thought it was very thoughtful and articulate, and I agree with him that Bill C-51 in its section that deals with reforming sexual laws is precisely about clarifying the law. It's about ensuring that we are sensitive to the long-held and inappropriately held myths when it comes to those victims and survivors who have the courage to step forward. So by passing this law, we are going to be reducing the systemic barriers which for far too long have afflicted the criminal justice system and have prevented women and girls from stepping forward. With respect to the rape shield laws, I want to assure my honourable colleague that all of the amendments were carefully debated at committee. We're grateful to the committee for all of its work and for bringing forward those amendments which have been adopted by the government. The rape shield provisions are tested in the law. They are about clarifying when consent is available, when it has been lawfully provided and when it is not. And I'm encouraged that this bill will ensure more certainty, more clarity on this important subject. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires? The Honourable Parliamentary Secretary to the Minister of International Trade.
Thank you, Madam Speaker, and I'd like to thank my colleague for his very thorough and very thought-out remarks. Madam Speaker, many people in my riding of Whitby, and I'm sure my colleagues' riding of Eglinton and across the country, were very much seized with the Me Too campaign and the notion of women coming forward and having a number of their complaints either not followed through or them not receiving the adequate justice that they need. I'm wondering if my honourable colleague could explain to constituents in my riding as well as his and to all Canadians how this piece of legislation and the amendments brought forward can strengthen our current legislation and allow women to feel that they will have justice at the end of the day.
The Honourable Parliamentary Secretary to the Minister of Justice.
Well, again, I want to thank my colleague for her question, and I have the privilege of working with her very closely on this important file. In fact, she joined me very recently in my riding of Eglinton Lawrence, where we talked about criminal justice reform. But to answer her question, this bill will enable and empower women and survivors to step forward in a number of important ways. Number one, it is going to clarify our sexual assault laws, and it's very important that women know that they have the support that they need from law enforcement, from our laws, from all stakeholders in the criminal justice system. So it will do that. It will clarify the laws around consent. It will ensure that if an accused who is charged with this crime cannot rely on evidence of propensity, which is far too prejudicial and which we know far too often depends on old, outdated myths and stigma. The law, Bill C-51, is all about reducing those systemic barriers, and I want to applaud my honourable colleague for all the work that she does in supporting women and survivors on this important file. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires? The honourable member for Parry Sound, Muskoka.
Thank you, Madam Speaker. And I want to follow up on that very same question because in Muskoka and Parry Sound, the number of so-called drop cases was amongst the highest in the nation. And we have been working very closely with the OPP in Muskoka and Parry Sound based on a Swedish model where there's accountability, there's transparency, there's proper training, and there's a respect for the victims who have come forward. Would the honourable member agree that it's that kind of holistic solution, not only in legislation, but the police services working with the community, not only with the general community, but the community of people dealing with sexual assault cases that can bring these issues to better justice?
The Honourable Parliamentary Secretary to the Minister of Justice.
I would indeed agree with those sentiments, and I thank my honourable colleague for the way in which he carefully articulated them. In addition to the reforms that Bill C-51 are going to be implementing to clarify the law around sexual assault, consent, I want to point out a number of important initiatives which this government has supported to support victims and survivors of sexual assault. Number one, we have provided additional funding and resources to legal aid. In addition to that, we have pointed out, we have also implemented a pilot project in Ontario and Newfoundland and most recently in Nova Scotia to provide legal aid services for free for a certain number of hours for those victims who step forward, who have serious allegations of sexual assault, who have any allegation of sexual assault, and that is the kind of enhancing of access to justice which I know my honourable colleague supports indeed. Thank you, Madam Speaker.
Questions and comments? The honourable member for Elmwood Transcona.
Thank you very much, Madam Speaker. I want to come back to my previous question because I didn't hear in the answer of the Parliamentary Secretary reference to any particular amendment that had been adopted to address some of the concerns that have been raised about what Bill C-51 might mean for the consent regime. So I take his point that the goal of government is to provide greater clarity. There have been concerns raised by people who work with victims of sexual violence that the government's best intentions notwithstanding, that they might inadvertently be raising the or changing the threshold for consent by tying it too closely to consciousness. And the law currently recognizes a lot of other barriers to consent that you don't have to be unconscious for, but you can be conscious and have other reasons why consent wouldn't be valid. There was language suggested through amendments by our party in order to try and provide greater clarity and ensure that those existing protections under the law aren't inadvertently voided by Bill C-51. The government did not take the opportunity to use that language. I didn't hear reference to amendments in his previous answer. I'm wondering why the government passed up that opportunity to provide clarity, greater clarity, which of course, according to the Parliamentary Secretary himself, is the purpose of Bill C-51.
The Honourable Parliamentary Secretary, the Minister of Justice.
Thank you, Madam Speaker. And what Bill C-51 does indeed do is clarify that there are two separate sets of circumstances in which consent to sexual activity cannot be obtained. First, where the complainant is unconscious, or second, where the complainant is incapable of consenting for any other reason. And this is entirely consistent with the Supreme Court of Canada's decision in J.A. It's backed by the experts who testified before the committee. The committee heard that evidence, it carefully debated it, and it has referred all of its deliberations back to this House with the adoption of the amendments which have been put forward. So I appreciate my colleague's question, but I want to assure him and all members of the House that Bill C-51 codifies carefully enunciated principles by the Supreme Court of Canada in the decision of J.A., which clarify when consent is provided and, most importantly, when it is not. Thank you, Madam Speaker.
Resuming debate, reprise de débat, the honourable member for Niagara Falls.
Well, thank you very much, Madam Speaker. I'm pleased to rise in the House today to speak to Bill C-51. The stated purpose of this bill is to streamline the Criminal Code of Canada by removing certain provisions that no longer have any relevance in contemporary society. That being said, Madam Speaker, I agree that many of the revisions, such as the removal of Clause 41 of 365 of the Criminal Code, which states that everyone who fraudulently pretends to exercise or use any kind of witchcraft, sorcery, enchantment, or conjuration, and Clause 4 to the removal of Section 71 pertaining to dueling in the streets, challenges or attempts by any means to provoke another person to fight a duel, attempts to provoke a person to challenge another person to fight a duel, or accepts a challenge to fight a duel. Mr. Speaker, these are a number of the provisions that have been removed, and I suppose that you could argue, the government may argue, that the provisions against dueling have worked because it's disappeared off our streets. So people certainly got the message a long, long time ago. But, Madam Speaker, witchcraft and neighborhood dueling no longer have any bearing, of course, in our society today. And so that's, I think, one of the points that we all agreed on. The Conservative Party is also aligned with the strengthening of the provisions of the sexual assault legislation. And indeed, we have led the way for supporting victims of sexual assaults by, among other things, the bill by my former Conservative leader, Rona Ambrose, her private member's bill, C-337. This bill makes it mandatory for judges to participate in sexual assault training to ensure awareness in the judiciary, in addition to education about the challenges that sexual assault victims face. Her act was designed to hold the Canadian judiciary responsible for the ongoing training of judges and the application of law in sexual assault trials. Essentially, Bill C-337 ensures the following. It requires that lawyers receive training in sexual assault as a criterion of eligibility for a federally appointed judicial position. It requires the Canadian Judicial Council to provide an annual report to Parliament on the details of the type of sexual assault trainings offered and judicial attendance at those trainings, as well as the number of sexual assault cases heard by a judge before having received adequate sexual assault training, and it requires judge to provide written reasons on decisions with regard to sexual assault. As you know, Madam Speaker, you will remember this was passed in the House of Commons, and we were all very grateful to see it passed, and it's now in the Senate, and I'm hoping that the Senate will get the message and move forward on this that has the support of this chamber and I believe the support of Canadians across this country. Now, Madam Speaker, we are pleased that the Liberals have followed our lead with regard to strengthening sexual assault provisions in the Criminal Code surrounding consent, legal representation, and expanding the rape shield provisions. The Conservative Party always stands up for the rights of victims of crime and have done so consistently, among other things, including the Victims' Bill of Rights that was passed in 2015. That bill, or the bill, will amend, among other things, the bill that we have before Parliament here, will amend 273.1 to clarify that an unconscious person is incapable of consenting. Now, this is, again, as my colleague pointed out, is a reflection of the Supreme Court of Canada's decision in Regina versus IA. And it will amend Section 273.2 to clarify the defense of mistaken belief if consent is not available, and if the mistake is based on a mistake of law. For example, if the accused believed that the complainant's failure to resist or protest meant the complainant consented. Now this, as was pointed out in the earlier speech of the Parliamentary Secretary, codifies a number of aspects of the Supreme Court of Canada's decision in R v. Ewanchuk from 1999. As well, this bill expands the rape shield provisions to include communications of a sexual nature or communications for a sexual purpose. These provisions provide that evidence of a complainant's prior sexual history cannot be used to support the inference that the complainant was more likely to have consented to the sexual activity in issue, or that the complainant is less worthy of belief. In addition, this bill will provide that a complainant has a right to legal representation in rape shield cases, which I believe is very, very important. It'll create a regime to determine whether an accused can introduce a complainant's private records at trial that are in their possession. This would complement the existing regime governing an accused's ability to obtain a complainant's private records when those records are in the hands of a third party. Now, as I mentioned at the outset, Madam Speaker, there are some proposed changes that we were adamantly against. And as it turns out, thousands of Canadians were also adamantly against the removal of Section 176 of the Criminal Code. The section of the Criminal Code that provides protection for religious services. I don't know when, I would be hard-pressed, Madam Speaker, in my career to know when I have received more emails or more petitions and correspondence on this particular section. But I would like to note that when Bill C-51 was first introduced, the government, interestingly enough, made no mention whatsoever of the fact that they were removing the section that directly protects the religious services and those who perform those services. So I was a little bit taken aback when I had a look at the legislation and I saw they're removing Section 176. And even though I have practiced some criminal law in my career, I had to make sure check to see exactly what section we were talking about. And indeed, this was the section that said, among other things, that everyone who by threats or force unlawfully obstructs or prevents or endeavors to obstruct or prevent a clergyman or minister from celebrating divine service or performing any other function in connection with his calling, or knowing that a clergyman or minister is about to perform, is on his way to perform, or is returning from the performance of any duties or function mentioned in Section A, assaults or offers any violence to him, or arrests him on a civil process or under the presence of executing a civil process, is guilty of an indictable offense and liable to imprisonment for a term of not exceeding 2 years. And everyone who willfully disturbs or interrupts an assemblage of persons meant for religious worship or for a moral, social, or benevolent purpose is guilty of an offense punishable on summary conviction. And everyone who, or at a meeting referred to in Section 2, does anything that disturbs the order or solemnity of that meeting is guilty of an offense punishable on summary conviction. Well, Madam Speaker, when the government didn't mention that this is what they were going to be repealing or removing, I remember very clearly saying to my colleagues that when this first came up for second reading debate, it was in June, and I said to them, I said, go talk to your constituents. Ask them, do they think it's a good idea to remove the section of the criminal code that directly protects religious services? Tell them if they think, were they aware of the fact that the government now wants to remove the special protection that members of the clergy have? And see what the response is. And I think, Madam Speaker, that my colleagues in the Liberal Party, they must have got the message here, because they would have heard the same things that I heard when we and our side brought this to everyone's attention, that just making a disturbance or interrupting a religious service is not the same as a scuffle or yelling at a hockey game or a disruption of a meeting. It's not the same. I think even people who do not attend religious services would agree that this is something more serious. And this is the message that I certainly was hoping that the Liberals would get, that this section was and remains critical, that removing this section would have eliminated the provision that completely protected the rights of individuals to freely practice their religion, whatever that religion may be. And ironically enough, during the very week that the Justice Committee was reviewing the government's plans to remove this, the worst mass shooting in Texas history struck an otherwise quaint small town in that state. Gunman Devin Kelly stormed the First Baptist Church in Sutherland Springs and killed more than 24 people. And the following Sunday, our funeral service was held at the church, and the original plan was to hold a small service, but so many people were outraged and moved by this horrible incident that it turned out hundreds and hundreds of people came out to show their support for the people of that community. And so, Madam Speaker, it reiterates the fact that religious freedom is part of the Constitution of the United States, and that is contained in their First Amendment. And in Canada, our religious freedoms are protected, and Section 176 is part of that protection. And religious freedoms are fundamental to Canadians as well, and Conservatives are proud to be among the first to stand up and support religious freedoms for all faiths. Now, Faisal Mirza, the chair of the Canadian Muslim Lawyers Association, made a valid point when he appeared before the committee. He said, "We cannot be blind that the current climate of increased incidents of hate, specifically at places of worship, supports that religious leaders may be in need of more, not less, focused protection," he said. He, of course, was referring to the deadly shooting at a Quebec mosque in January, when the lives of 6 people came to a violent end. And among the victims were parents, civil servants, academics, people who had left their countries of origin seeking a better life in Canada. Religious crime knows no borders and is no respecter of persons. This is why I am pleased to say that after hearing testimony from faith communities from across this country, the Justice Committee members voted to keep Section 176 of the Criminal Code in place. So I would like to thank, Madam Speaker, those thousands of Canadians who wrote, emailed their respective members of Parliament. I indicated in my opening comments that I don't remember receiving as much feedback on this. And I think all members have experienced the same kind of pushback on this, that the protections provided in Section 176 are there for a particular purpose. And again, I disagreed with the comments that my colleague, the parliamentary secretary, when he pointed out the Minister of Justice said, well, these things are still offenses under the criminal code. It's not the same thing. Disrupting a religious service is not the same as creating mischief somewhere. And it's not the same as causing a disruption at a hockey game. I think most Canadians would agree with us on this side of the House that this is more serious and that it should be and continue to have protection within the criminal code. And again, I find it irony that when this bill was presented to the public, there wasn't one single mention. They did mention dueling, they did mention witchcraft, but they didn't mention the fact that they were removing the specific protection that religious services and religious officials have. While I have a minute, Madam Speaker, there was one other section of the criminal code I didn't agree with them removing, and this is the section of the criminal code that has specific protection if someone attempts to attack the Queen. And some of my colleagues pointed out, they said, well, these sections aren't used very often, or one of my colleagues said the Queen isn't going to be visiting here very much in the future. Again, this, I believe, was a bad idea. I always remember at the University of Windsor, one of my law professors pointed out the sections with respect to treason in the criminal code. And he says, you know, it's great that this section is very seldom ever used in Canada, but it doesn't mean it should be removed. I don't go along with the thinking, say, well, okay, if nobody's committing treason, we better get rid of that one out of the criminal code. No, 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 no. That's not how it works. This is still a very, very serious crime. And again, if anyone attempts to attack the Queen as Canada's head of state, again, in my opinion, it's not the same as getting into a fist fight in a bar some night. This is important, that it has significant aspects. And I have to point out to them that the timing of this was terrible. This is the 65th anniversary of the Queen on the throne. Nobody has a better record anywhere of public service in this world today that she has, that has been consistently going on since before she assumed her reign in 1952, her service during World War II. That is what she has done. And again, this is the year the Liberals have decided they will remove this specific protection against someone who is attempting to attack her. So, Madam Speaker, that being said, I am pleased that the government caved on the 176. I am very pleased with respect to the clarifications with respect to the sexual consent. I am very pleased as well that a number of the sections that are taking up space in the criminal code that no longer have any particular relevance are being removed. But one of the things that something like this has taught us on this side, we have to be very careful. And this is the lawyer in me. You have to read the fine print. And the fine print removing the protection for religious services and for those who religious officials is something that we have to be very, very aware. And so I can assure my colleagues on the other side that we will look at all legislation to see if there are what are supposed to be unintended consequences are in fact consequences of a very serious nature. But again, my heartfelt thanks goes out to all those religious institutions, all those Canadians, all those individuals who spoke up in support of Section 176. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of International Development.
Thank you, Madam Speaker, and I'd like to thank my honourable colleague for his very poignant remarks. Madam Speaker, the honourable member spoke to the fact that specifically with Section 176 that the opposition and Canadians at large pushed to ensure that this section was kept. And not only was it kept, it was expanded to not just include clergymen, but the officiant, to include other spiritual leaders. So I'm wondering, if, Madam Speaker, if the honourable colleague could speak to the fact that, yeah, even though this place might seem very contentious and that we might duel in here quite often, that we are very much amenable to taking advice from opposition and being a government that's very open to listening to great advice from our opposition as well as from all Canadians.
The honourable member for Niagara Falls.
Well, I do have to admit the Liberals certainly got the message on this one. Here, I mean, I remember raising this last June and when the committee hearing, and all I kept hearing was they said, oh, well, you know, if it's mischief or if you try and attack a member of the clergy, that's still within the criminal code. But again, I think it was not just our opposition, the Conservatives, who, discovering this, made the push for this. I think, as I pointed out in my speech, it was all those constituents of theirs that said to them, say, why are you removing these sections? But I will give some credit to the government. I've seen them scoop up ideas from opposition members and incorporate them into government legislation. The private members bill that, with respect to shipwrecks, there was a private members bill from the NDP, and so the Liberals get the message, this is not a bad idea. They put it into government legislation, and then I guess we're supposed to say they should take all the credit for it. But I will concede that to the honourable member that when they see an amendment or if they see a private member's bill that they ultimately feel that they have no choice but to support, I can say very often they will incorporate that into either government legislation or make some minor changes so that they can presumably take the credit for it.
Questions and comments? The honourable member for Victoria.
Thank you, Madam Speaker. I'd like to thank my friend and colleague from Niagara Falls for his thoughtful presentation today. More on Section 176, though. The Liberals would like to take credit for accepting this, and although I'm not a member of the Justice Committee that was dealing with this issue, I know he was, and I understood that the Conservatives brought in amendments to Section 176, and they were defeated by the Liberals, but then the Conservatives came for. The Liberals then came back almost a few moments later to simply make, I think, the language a little bit more gender neutral, and then that was accepted. So the Conservatives brought in an amendment to fix it. It was defeated. Moments later, the Liberals, because it has to be their idea, brought it forward, and it was fixed. I wonder if my colleague could confirm that that's how it went down.
The honourable member for Niagara Falls.
That's a very good summation of exactly what happened, Madam Speaker, and certainly I appreciate that. The interpretation of that section is gender neutral and is not specific to any religious organization or group. And that's been its interpretation by government departments and throughout the years. And what we suggested was that you could call this person a religious official. But I know the Liberals, because as a minister, one of the bureaucratic suggestions made to me one time was that we should call these people officiants. And I pointed out to them, I said, I'm not quite sure how many Canadians would know what an officiant is. Well, let's call them religious officials. But I hadn't thought of or even heard about that name for a couple of years until I saw the Liberals come forward. They said, oh, we don't want to be calling these people religious officials. We call them officiants. I said, whatever. You know, in the end, you know, they got the message on 176, and I think we're all better off for continuing religious protection in this country.
Questions and comments? The honourable member for Barrie and Nisville.
Thank you, Madam Speaker. And I'm not sure that I have a question more than a comment. And I want to thank the honourable member from Niagara Falls for the work that he did, specifically with Section 176. And I know for myself, Madam Speaker, I notified over 30 churches within our riding of Barrie Innisfil, and many of them were grateful for the fact that I did notify them on the urging of the honourable member from Niagara Falls, because many of them were not aware of the changes that were indicated in Bill C-51, specifically as it relates to religious services and religious officials. So I do want to thank the honourable member for that. I'm not sure that I have a question, but I know he's a humble man and he wouldn't want to accept any level of thanks for the work that he did in bringing this to light and making sure that all members of Parliament were able to bring it to their religious officials within their ridings as well. Thank you.
For Niagara Falls.
Thank you very much. Madam Speaker, I think it was actually perfectly understandable that so few people saw this, because I did reach out to a number of religious institutions and they were completely unaware. And if you look very carefully at the press releases, the speeches from the Liberals when they tabled this bill, they made no reference to it whatsoever. They only wanted to talk about dueling, witchcraft, sorcery, that kind of thing, okay? Those were the sections that they wanted to remove from the criminal code, and there was no suggestion whatsoever with respect to removing the protection for religious services and religious officials. And so it was our job, and I think that is our job as members of the opposition, is to make sure people know. And the honourable member from Barrie Innisfil did exactly that. He reached out to all those religious communities within his riding and let them know. And then again, it wasn't a case that we had to twist their arm or you make long arguments or something. They got it. They understood that in this day and age, you must and should continue to have those religious protections. So I want to thank him and indeed all my colleagues and all those who got the message here and kept that section in.
Questions and comments? The honourable member for Mount Royal.
I want to thank my honourable colleague for Niagara Falls, my colleague on the Justice Committee for his speech. And it's funny because I like to look at things in a nonpartisan way, and I thought the way the committee actually handled that issue of 176 was quite nonpartisan, where we heard witnesses and all of the members of the committee who are not the government, from the governing side, listened to it and said, yes, we agree that section should be reinstated, and we did. However, listening to the questions, it sounds like we were playing games with it. Contrary to what my friend from Victoria said, there were amendments put forward by the Liberals at the very time that the Conservatives put forward amendments before the meeting. It's not that one amendment was put forward before the other. It's just that the Conservative one came up first, was voted on, and it was slightly different than the Liberal one, and it was defeated, and the Liberal one was adopted. It wasn't as partisan as being made out to be. So I want to congratulate my friend from Niagara Falls on what he did, because he did raise this issue first. He deserves all full credit. But I think it was a much more nonpartisan exercise than was being made out to be. I don't want our committee to be mocked for that, and I'm sure my friend from Niagara Falls would agree.
The honourable member for Niagara Falls.
I generally always agree with the chairman of the Justice Committee, Madam Chair. We work very well on that committee, and we do deal with a lot of very serious subjects. And much of what this bill does is, quite apart from all the discussion with respect to 176, which of course is very important to me, but updating the criminal code so that it better reflects what has been taking place in courts, what we have been hearing with respect to a number of these offences, and making sure that the criminal code is up to date. I mean, that's the job that we have as parliamentarians and members of the Justice Committee or the Justice Department, is to continuously look at those sections of the criminal code to make sure they reflect what's actually happening out there, or what should happen there. The honourable member would remember we just had before our committee here last week the Right Honourable Kim Campbell, and she was pointing out, she was bringing in the first rape shield sections of the criminal code. Now, I mean, we're talking now a good 25, 28 years ago, and again, that was a time to make sure the criminal code properly reflects what's actually happening out there and the challenges that victims have. And so these are the kinds of things that we have to continue to work on at the Justice Committee, and I know that we'll continue to do that.
Resuming debate. Reprise de débat, the honourable member for Victoria.
Well, thank you very much, Madam Speaker. It's an honour to rise and speak to C-51 today. I want to begin by, I suppose, apologizing to my colleague from Mount Royal, who is the excellent chair of the Justice and Human Rights Committee, and I think runs it in a fashion that is nonpartisan and to his credit. However, I can say that from the perspective of an opposition member, it is passing strange, Madam Speaker, that amendments from our side are so rarely taken up by any committee in this place. On C-58, the bill that they call the Access to Information Bill, I call it the Denying Access to Information Bill, I brought forth 20 amendments, each and every one that was rejected. And in this case, of course, the chronology is as my friend suggested and correctly stated, but each of the amendments from the opposition were defeated, and I think each of the amendments from the Liberals were accepted on this particular bill. So that is the way it works in committees. I think Canadians should know that. I find it disappointing. On the merits of it and on the collegiality of how the committee proceeds, I am grateful to the member from Mount Royal for the way in which he runs this committee, and it's exemplary, and I salute him for it. This is a nonpartisan issue, and if I got off on the wrong footing by suggesting anything to the contrary, I owe this place an apology. This reform of the criminal law for all Canadians cannot be partisan. We have to get it right. We have to get the balance between the rights of the accused and the rights of victims, have to get it correct, because the law is constantly evolving, as technology, for example, is constantly evolving. I'll have more to say about that in a moment in respect of sexual assault provisions. But it is to the government's credit that they are taking a number of sections of this very long criminal code and trying to update it in light of what the courts have done and in light of where society is going, and that's as it should be. So the NDP wants to say at the outset of this debate that we are entirely in support of this bill and will be voting for it without hesitation. And therefore, I want to say a few things just for those who might be listening about what the nature of this bill is. Some have called it an omnibus bill. I think that one of the Conservative speakers in June, when it was on second reading, termed it that. I don't think it's that way. I think it's a comprehensive reform initiative to do, I think, 4 types of things. First, to clarify the laws on sexual assault, because there's been a lot of Supreme Court jurisprudence that requires us to restate the law to make sure we are keeping up with the times. Secondly, the bill would remove or amend provisions that have been found unconstitutional by the courts, and that obviously has to be done. Thirdly, a number of obsolete or duplicative offenses would be removed. And finally, there's another bill that is amended, the Department of Justice Act, that would create a new statutory duty for the Minister of Justice to table a charter statement for every government bill. I'll say at the outset, and I'll say more later, that that fourth issue is, I suppose, laudatory, but really quite ineffective. And the fact that the government tables a few sentences about why a finance initiative is consistent with the charter seems to me to be much ado about nothing. I'm not sure it's of any relevance in a court of law, and I think this House can assume, without having a statement, that government bills will, in fact, be consistent with the Charter. We hardly need a statement to do that, and indeed the Charter statements that the Minister of Justice has been releasing to date add very little, in my judgment, to the issues before this House. But I suppose one can never fault too much information, even information that is of dubious utility. I want to start with the most significant number of amendments to this bill, which is sexual assault. But before doing that, I want to put it in the context of an excellent summary of this bill that was provided in the Canadian Bar Association's journal, The National, that was done by one Omar Ha Redeye in the fall just a few weeks ago. And I think it's quite amusing how the author starts in describing this bill. He says this: the federal government is finally doing some housekeeping of the criminal code with Bill C-51. It may find some hidden cobwebs, and according to some, there may even be monsters under the bed. The criminal code is a place where old, obsolete, and even unconstitutional laws languish in purgatory. Most governments have been content to simply ignore these outdated provisions, knowing that most would never actually be used. The result is a long, rambling, and sometimes unnecessarily confusing statute. Amen to that, Madam Speaker. Sometimes the code is sufficiently complicated to confuse even the judges. And this is where I pause to talk about poor Mr. Justice Denny Thomas of the Alberta Court of Queen's Bench, who a few years ago convicted a gentleman named Travis Vader of second-degree murder. And he relied on Section 230 of the Criminal Code, which had a provision called culpable homicide that was introduced way back in 1892. Unfortunately, the judge wasn't made aware of the fact that the Supreme Court of Canada had previously repealed a part of that provision in a 1987 decision. And then it had ruled in another decision that the section was contrary to the Charter and couldn't be saved under Section 1. So that allowed the fact that the judge convicted this individual required that there be a conviction for murder without the requirement for proof of subjective foresight of the mental element of moral blameworthiness. And there it was, gathering dust, Section 230 in the Criminal Code. They had to do the whole trial again, an unknown cost, both psychological and financial, to the system of justice in the province of Alberta, and bringing the criminal code, frankly, into disrepute as a consequence. So one has to salute the government for its efforts to bring it up to date and sweep away these cobwebs, as the author so correctly said. And then there are provisions in here that are simply obsolete for other reasons, those relating to witchcraft, prohibition on duels. You'll be pleased to know, Madam Speaker, that's no longer a problem under the Criminal Code. Pretending to practice witchcraft, offenses dealing with trading stamps, archaic sections that really no longer serve the needs of contemporary Canada. So again, the government correctly is trying to remove these cobwebs from our criminal law. And that, Madam Speaker, takes me to the main event, if I can call it that. There's a number of others I'll come to, but that is the sections dealing with reform of the sexual assault provisions of the code. The minister talked about making it more compassionate toward complainants in sexual assault matters. And many of the sections that are in the code address changes that the courts have made using the Charter to address problems that they saw with these provisions. It expands, these sections expand the code's rape shield provisions to expressly include communications for a sexual purpose or of a sexual nature. The rape shield provisions that were introduced after the Seaboyer case in 1991 limit the types of questions that defense counsel can pose and evidence it can adduce concerning a complainant's sexual history. This information had sadly been used in our legal system to promote a stereotype that a complainant is more likely to have consented or is less credible because of past sexual history. In 2000, the court upheld the rape shield provisions as being constitutional. So the new changes that are in this bill appear to stem from criticism arising in the famous Gian Ghomeshi case, which attracted a lot of media attention and dealt with societal discussions about sexual assault prosecutions in Canada. As you may recall, that case involved text messages and social media content by the complainants. Some defense counsel are concerned that this bill will limit the evidence they can use to offer a full and complete defense. Others believe those concerns are overrated. Lise Gotel, who is the national chair of the Women's Legal Education and Action Fund, LEAF, stated that the amendments simply recognize more contemporary forms of sexual communication, and I agree with her. If the evidence is used for the purpose of demonstrating inconsistencies, it can still be included if it's only used to perpetuate stereosexual type. I want to quote Ms. Gotel directly. There is no implied consent in Canadian law, she said, and so previous sexual activity should be irrelevant to a belief that someone is consenting to the sexual activity in question, close quote. That is the key. There is no implied consent in Canadian law with respect to sexual assault. And past sexual history or communications on the internet or Facebook or the like do not suggest or imply any kind of consent to the specific activity at that specific time. And the courts have made that clear, and I'm pleased that C-51 now makes that clear as well. Now, more than 20 years ago, in the case called O'Connor, the court ruled that medical and counseling records in a sexual assault case could be disclosed by judicial order. The government limited these productions through amendments, and that was upheld. In 1999, the court stated in Regina versus Mills that the judiciary had adequate discretion to preserve a complainant's right to privacy and also still allowed for a full and complete defense for the accused. Although the nature of the electronic communications today might be different, the concepts, Madam Speaker, remain the same. Sexual assault complainants, who are almost exclusively women, are still subject to widespread stereotypes and prejudice based on their sexual histories. Salacious texts and steamy graphics may be communicated differently today, but they're just as dangerous to the balance of justice. So these provisions that deal with the sexual assault measures of the court make a number of specific changes in addition to the ones I've sketched a moment ago. So the bill would amend a section to clarify that an unconscious person is incapable of consenting. Now, most of us would have thought that was self-evident, but there was a court case that clarified that, and to the government's credit, it has brought in a clarification to the same effect. Now, what about, it was pointed out, incapacity to consent short of full unconsciousness, such as when a complainant is very drunk or maybe only semi-conscious? I think that there are those who have said that somehow by putting this in, we create an uncertainty over those sorts of situations, severe intoxication, semi-consciousness. I'm not concerned about that because I believe that there are other provisions that would address those in the code, but that is one point that has been made in the debate at the committee and elsewhere about this bill. Then there is the other clarification brought into the bill, which would clarify that the defense of mistaken belief in consent is not available if the mistake is based on a mistake of law. So, for example, if the accused believed the complainant's failure to resist or protest meant that the complainant consented. That was respecting a case that was decided in 1999 that the court clarified that. Say, for example, the consent was extorted. I'm going to show all these nude pictures to the world unless you consent to have sex with me right now. That's not consent. And that needs to be clear, and I think is now increasingly clear in this case. One thing that is fascinating in this bill, and I think very, very positive as well, is the ability of the complainant to have legal representation in rape shield proceedings. She, as it's normally a she, can then retain counsel to be present and discuss and debate before the court the admissibility of diaries or text messages or the like. Now that sounds great, and I think it is a positive step. But the practical reality for most Canadians is they won't be able to take advantage of that because, sadly, we just don't have the money to do so. There is a dearth of legal aid in most provinces. We have a crisis in legal aid, and therefore it's nice to have that there, but I'm asking the practical question, will people be able to avail themselves of that? Will women be able to actually participate as has been suggested? Now, again, to give credit to the Justice Committee, on October 30th of this year, an excellent report on legal aid was produced. And I would commend members in this place to read that report because they talk about legal aid in very stirring terms about a service that, quote, breathes life into the democratic principle of the rule of law by ensuring that low-income Canadians have access to the courts. Once again, all three parties worked collaboratively to produce this excellent report, an acknowledgement that, of course, most of this is of provincial jurisdiction, but nevertheless, leadership and best practices were suggested, and I commend the committee for that. But unless the Government of Canada assists provinces with more legal aid funding, this section, which is so laudable, that allows women for the first time to actually participate, have a right of natural justice in criminal proceedings involving the disclosure of intimate information in provisions where, in situations where sexual assault is at issue. Unless they have legal aid, most of the time it's all irrelevant. And so Canadians need to understand that reality. And I'm here to make sure that this place looks favorably, and the government looks favorably, at the excellent legal aid report that was produced, so it isn't just another report that gathers dust on the shelves of Parliament. So I believe that the provisions at issue have been very, very thoughtful, and they're not simply symbolic. I think they are meaningful changes, and I hope that the government will move on them and also put its money where its mouth has been. Now, a number of people are in agreement with these provisions, and I speak of, for example, Professor Elizabeth Sheehy of University of Ottawa and Emma Cunliffe of the University of British Columbia, and they talked about the right of legal representation in rape shield hearings as an important step, but said it would be largely ineffective unless provincial legal aid programs provide the financial support to complainants seeking to retain a lawyer. I agree. On the streets where these amazing workers in rape relief and women's shelters work day in, day out, tirelessly with victims of sexual assault, they also have concerns. Hilla Kerner speaks for the Vancouver Rape Relief and Women's Shelter, and she said this: "Women who work with us were very discouraged after what we saw in the Gomeshi case. The provisions in the bill send a message that, quote, your past, the things you did before the attack and after the attack, will not deter the criminal justice system from actually dealing with the attack and holding men accountable," close quote. I think that's a very good indication that the message will be received by those who are so involved in counseling women after sexual assault. That, you know, the law has changed, it's better now, you can come forward, don't be afraid. And that has to be, Madam Speaker, the #1 objective of these amendments. Namely, that women are not afraid, don't think it's a waste of time to come forward. The Globe and Mail is doing excellent work in showing how few sexual assaults are actually processed seriously by the police departments across the land. They did an update this past weekend on an earlier award-winning series. So we're at the very heart of that issue in this bill, making it easier for women to come forward because they know that there'll be fairness, they'll be taken seriously, and the laws won't work against them. I think that is excellent. Now, not everybody has applauded the entirety of C-51 in these glowing terms. Michael Spratt, who's the Vice President of the Defence Council of Ottawa, refers to this bill as, quote, another half-hearted attempt to reform the justice system by grabbing the lowest of the low-hanging fruit. Now, it's true. The government mandate letter for the Minister of Justice speaks to a comprehensive reform of the criminal code. It's so overdue. But nevertheless, I don't fault the government for going after this low-hanging fruit. You know, no dueling, no trade stamps, that sort of provision, because they're also doing real work in the sexual assault provisions, and we have to support and give credit where credit is due. One hopes that there'll be the comprehensive reform that Professor Coughlin of the Dalhousie University, the Schulich School of Law, has been seeking, and I think we're going to get there. I'm confident we're going to get there. But on the issue of sexual assault, I commend the government for what it's doing. On the issue of charter statements, I say ho-hum, nice, but so what? But on this stuff, this key change to our criminal code to give women in this country the confidence that it's worth coming forward, I think the government is to be commended, and we will support this bill without reservation. Thank you, Madam Speaker.
Questions and comments? The honourable member for Mount Royal.
Thank you very much, and I want to thank my honourable colleague for Victoria for an excellent speech. I also want to thank him for the very kind words that he mentioned about me and the committee. I want to return the compliment. He is an incredibly productive member of the committee and incredibly helpful whenever he sits with us, and I want to thank him for that. I also want to note that there were indeed opposition amendments accepted. I'll note Clause 25, for example, where we did accept a Conservative amendment. So it wasn't only one party's amendments, but what I think is a problem systemically is that parties work together on their own amendments and then go off in one line, and then it's harder at a committee meeting thereafter to agree to other amendments because you've already gone off in your line on your amendment. So maybe one thing we can all work on is working together on amendments going forward, and maybe we'll be able to work to harmoniously have amendments. My question actually is around the people that are talking about a bright line on consciousness. The committee heard from many witnesses. We decided to say that consent needs to be ongoing, meaning we accepted an amendment to clarify that consent needs to be ongoing, which I think resolves any concerns that people had about unconsciousness being a bright line, and I'd just like to ask the honourable member for his opinion on that.
The honourable member for Victoria.
Thank you, and I thank the honourable member for Mount Royal and the chair of the Justice and Human Rights Committee for the question and the clarification. On the general point, I wish that there was an opportunity for us to work together before we get there. The timing doesn't allow, when you bring in a lot of amendments, to know what the other side is going to do, and so often we become in an unnecessarily adversarial place on committee, and I think that could learn from that. There's often better dialogue in the committee that he chairs than in many others, and that would allow us to maybe not waste so much time and find consensus around provisions. And so more of that, the better, as far as I'm concerned. On the unconsciousness provision, I agree. I think the insistence on ongoing consent before the act, during the act, and after the act confirming it, this ongoing nature is critical. The lack of consciousness that my friend talked about was of great concern to some, because if you say that, well, it's, lack of consciousness, absolute total unconsciousness vitiates the consent, then what about when you're just semi-conscious or you're very, very drunk and it's not clear that you are able to consent? I think this insistence on ongoing consent will do the trick, but I can tell you that there are those defense lawyers who are lining up to make the argument to the contrary.
Questions and comments? The honourable member for Thornhill.
Well, thank you, Madam Speaker, and I thank my colleague for a fine speech reflecting his previous career in law and as a scholar. And I would like to ask him about something, one of the elements of the Liberals' proposed legislation that is important to many of us on the benches in the official opposition. And I'm wondering whether my colleague sees, as we in the official opposition see, something of a forewarning in the removal of Her Majesty's portrait from that vast wall in Global Affairs Entrance Hall in favor of the two admittedly fine works of art by the great Quebec master Alfred Pellin. And because my colleague is from a royal city, I wonder whether he agrees with those of us in the official opposition that this Liberal government has demonstrated by attempting to withdraw the assault on Her Majesty from the Criminal Code a reflection of diminished respect for our head of state, or does my colleague think it was merely an ill-considered proposal made by the Justice Minister?
The honourable member for Victoria.
Well, I thank my friend from Thornhill for the question, and I must say I admire Alfred Pellin as an artist, so I'm conflicted in answering the specific question about the art. But on the more global question, the Queen of Canada is the Queen of Canada, and I know in my community is an immensely popular figure. I think the colleague from Niagara Falls pointed out her exemplary record of public service, and I don't think anyone can disagree with that. I do disagree with the honourable member for Niagara Falls that the section at question concerning the royal personage would somehow be affected. I do think it was an obsolete provision. I think the other provisions of the code that are still in place will adequately deal with Her Majesty when she comes to this country. Whether the government's demonstrating, in his words, a diminished respect for the head of state is something I can't comment on, but I know in my community of Victoria there is no such diminishment.
Questions and comments? The honourable member for Mount Royal.
Mr. Speaker, and coming back to that same question raised by my friend from Thornhill, I don't know if my friend from Thornhill is aware, Madam Speaker, but the Monarchist League of Canada themselves submitted a brief which did not complain about removing this provision. So I think we on the committee concluded if the Monarchist League of Canada did not object to it, there was no real harm in removing the provision. And I'd like to ask my friend from Victoria if he agrees.
The honourable member for Victoria.
Community where the Monarchist League is a very strong part of our community. I can assure you that I would have taken precisely the same position if I were in the shoes of the honourable chair of that committee. No, I think that the provisions that exist in the code adequately deal with that. And, you know, there's something to be said for brevity. This statute is enormous. It only gets larger and longer over time. I think, as we started by saying, the mandate letter requires the minister to do some serious house cleaning. Some of the low-hanging fruit, some of the cobwebs have indeed been addressed. Some of the sections that need to be fixed, such as sexual assault, that are more meaningful, have been, to the government's credit, modernized and improved. But there's so much more work to do in the criminal code. We should make it shorter, clearer, so Canadians understand their rights and responsibilities as citizens from coast to coast to coast.
L'honorable député de Drummond.
The honourable member for Drummond. Thank you, Madam Speaker, and I'd like to thank my colleague for his excellent speech and his commitment to defending Canadian citizens. This isn't a simple affair. I don't personally have expertise, but I do understand what happened in committee. I know the NDP tried to bring forward several amendments, including the issue of consent. In the Criminal Code of Canada, we want to make sure that when a plaintiff is unconscious, that do not provide a consent. We wanted to be able to change that. We also wanted to be able to prevent personal records being disclosed during a trial. Unfortunately, our amendments were turned down, so I'd like my colleague to talk about the restriction of the definition of consent, and I'd also like him to speak about evidence that can be introduced during a trial. For example, I know there was a case regarding an expert regarding an agenda, for example, that had been stolen from the accused. There were problems with respect to that being used as evidence. I'm wondering if my colleague could go into both of those concepts that I think are probably quite important.
L'honorable député de Victoria.
Honourable member for Victoria.
Well, thank you, and thanks to my honourable colleague from Drummond for the excellent question. As I was not present during the actual debate on this bill at committee, I only have the summary available to me. But it's true, the honourable member is correct. The NDP did attempt to more clearly define the meaning of the phrase "no consent obtained" in relation to sexual assault in one of the sections, such that the complainant is unconscious, not be kept as the threshold for incapacity to consent. We tried to make changes to the process for introducing private records of the complainant at trial as well, and the government members defeated us on those amendments. I think we were buoyed in doing so, in raising this concern, by Professor Benedict from the UBC Law School, who talked instead that the need for this ongoing consent that we talked about earlier. It has to be a yes that is not extorted through any kind of pressure. And the fact that somebody is blackmailed into providing consent is also something that we need to make sure. So by raising the phrase unconscious, we want to make sure that there was no effort elsewhere by raising that phrase to somehow limit the requirement of consent that must be ongoing in every case. And we thought we had a better way of doing it. That was not accepted, but in general, I think we've come to a place where the NDP can support. Thank you.
Reprise de débat.
Resuming debate, the honourable member for Willowdale.
Thank you, Madam Speaker. Before I begin, I'd like to inform you that I'll be splitting my time with a member from Oakville, North Burlington. Now, it's a great honor and a great privilege for me to follow in the footsteps of my learned friend from Victoria, as well as the chair of our committee from Mount Royal. I'm grateful for the opportunity I'm provided to rise today to speak about Bill C-51, an act to amend the Criminal Code and the Department of Justice Act, and to make consequential amendments to another act. I was honored to study and vote for Bill C-51 in the Standing Committee on Justice and Human Rights. The bill strengthens the Criminal Code and other related legislation to ensure that laws are clear, up to date, show fairness to victims, and are in line with the Canadian Charter of Rights and Freedoms. Our government is committed to making progress on addressing sexual assault and gender-based violence. I'm very proud that Bill C-51 is an important part of our efforts to attain that goal. Sexual assault and gender-based violence are a tragic reality for Canadian women and men, and we need our laws and criminal justice system to be responsive and to treat victims with respect and compassion. There have been major reforms to sexual offences in the Criminal Code ever since the 1970s, and the changes in Bill C-51 are logical next steps on that critical path. At committee, we heard from women's groups and members of the legal community that the current legal framework under the Criminal Code could be strengthened, especially on the question of consent. Bill C-51 adds clarification to existing law that no consent can be obtained if a complainant is unconscious, as outlined in the Supreme Court decision in JA. This does not mean that someone just short of unconscious is able to consent, even though they are otherwise incapacitated. Bill C-51 makes it clear that an inability to consent can be for reasons other than being unconscious. The committee also adopted an amendment proposed by one of my Liberal colleagues to further codify the JA decision in Bill C-51 by clarifying that consent cannot be given in advance and that it can be withdrawn at any time. As our understanding of consent changes, our laws obviously have to keep pace. Bill C-51 also proposes to strengthen consent in the Criminal Code by codifying aspects of the Supreme Court's decision in Iwanchuk, notably that an accused is not able to rely on the defense of an honest but mistaken belief in consent if said belief was based on the passivity of the complainant. It is vital that the Criminal Code is clear to avoid any misapplication of the law. The witnesses at committee also spoke at length about how a sexual assault trial can be very difficult for the complainant and how unfortunate stereotypes and myths about sexual assault victims continue to pervade our society. Bill C-51 makes important changes in the safeguarding of the privacy of victims to ensure that the justice system does not perpetuate such stereotypes. The bill strengthens the rape shield provisions that protect complainants. Clarity is paramount for any criminal code to be fair, accessible, and comprehensible. From time to time, we must clean up the code to remove provisions that are deemed redundant, are obsolete, or indeed unconstitutional. In the committee's study of the bill, we had numerous legal scholars and experts voice their support for the government's repeal of sections of the Criminal Code that are no longer necessary. In a modern criminal code, there is no need for an obsolete provision such as the offense to fraudulently pretend to practice witchcraft. Likewise, we heard from witnesses like Greg Oliver of the Canadian Secular Alliance that Canada's blasphemy law is obsolete and potentially in violation of the Charter guarantee of freedom of expression. I was honoured to have sponsored the petition started by Mr. Oliver on this issue, and I'm gratified to see that Bill C-51 will repeal Section 296 of the Criminal Code, the prohibition on publishing blasphemous libel. Although Bill C-51 proposed the repeal of Section 176, given that it is rarely used and other areas of the Criminal Code cover the relevant offences, the committee listened to the concerns of religious groups and constituents. They told us that they believe this provision is important to send a clear message about Canada's commitment to the protection of religious freedoms. For this reason, the committee adopted an amendment put forward by a Liberal member to reinstate Section 176. This amendment also changes the language to make it inclusive of all religious and spiritual faiths and to make it gender neutral. Our laws must make sure that all Canadians, regardless of their religious affiliation or gender identity, are free to practice their faith. During the committee's study of Bill C-51, I was also pleased to support the bill's proposed changes to the Department of Justice Act, which will create a new requirement for charter statements. This new section mandates that the Minister of Justice table a statement outlining the potential effects of all government bills on charter-protected rights and freedoms. The Charter is the most fundamental way in which the basic rights and freedoms of all Canadians are enshrined in law. It is imperative that proposed laws are clear in their relationship to these basic rights and freedoms. I applaud the government for taking this pivotal step to ensure transparency and respect for our Charter. I'm proud to have participated in the study of Bill C-51 by the Standing Committee on Justice and Human Rights. It is clear to me that this bill will strengthen sexual assault law, modernize the criminal code, and make it clear and accessible, while also placing the Charter of Rights and Freedoms at the center of our focus when crafting new laws. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary of the Government House Leader.
Yes, thank you, Madam Speaker, and I appreciate the thoughts expressed by my colleague. And one of the issues that has been talked about since virtually the legislation became known was the issue of religious freedoms. And what I think is important for us to recognize is this is a good example of grassroots involvement in improving the legislation. And I say that, Madam Speaker, believing, constituents that I represent. I had a number that had raised the issue in terms of why we couldn't leave, I believe it's Section 167 of the Criminal Code alone, protecting that religious freedom. And I believe that it's not a individual within the House, but rather responses from many constituents that ultimately saw the government make the change in standing committee in support of ensuring that that clause remain in the criminal code. And I'm wondering if my colleague can just kind of expand on that idea of how legislation can in fact be improved by the average Canadians contacting government or contacting their local member of parliament, that in fact it can make a difference.
The Honourable Member for Willowdale.
Thank you. Yes, I would like to thank the member for his pertinent question. That was an issue, Section 176, that did come to our committee. Obviously, the draft, we were not sensitive to some of the implications of Section 176, but after having had a chance to consider it, we did. We focused on it. And of course, one of the important things for any committee is to be receptive to things that are brought to the committee's attention, to think long and hard about what the implications of any proposed changes are. And in this particular instance, after having heard from various constituents that were concerned, we all took a sober look at it. And I'm happy to say that all of the parties were quite collegial in our approach to this issue and realized that perhaps they had raised a significant point and made those necessary changes.
Questions and comments? The Honourable Member for Calgary Signal Hill.
Thank you, Madam Speaker. I'd just like to ask the member who's also on the Justice Committee. I happen to serve on the Justice Committee, and I saw the Liberal members fight this right to the very end, and now they seem to be standing in this House taking credit for this initiative. I'd like to ask the member if he would like to comment on the fact that had that the opposition critic for for Justice and various organizations across this country had not put all this pressure, would the Liberal members of this Justice Committee actually have agreed to this amendment?
The honourable member for Willowdale.
I don't recall it as having been pressure. We were quite willing to hear from various groups and organizations. And once they did appear before our committee and raised concerns, we, as I said before, we took a sober look at it and realized that they had a very good point and thought that this legislation would be very much strengthened by addressing the concern that they had come forward with. So, as I said, there was no pressure. It was a collegial atmosphere, and we were quite adamant to get this legislation right, and we made those necessary changes. Thank you, Madam Speaker.
Time for a very brief question. Questions and comments? Questions et commentaires? Resuming debate. Reprise de débat. The honourable member for Oakville North Burlington.
Thank you, Madam Speaker. I appreciate the opportunity to participate in today's debate on Bill C-51. I think it's fair to say that this bill has enjoyed broad and bipartisan support from all members in this House. I wish to acknowledge this support and also to thank members from all parties for the collaborative, constructive, and focused discussions that have taken place so far, including before the Standing Committee on Justice and Human Rights. I expect that this approach will continue and hope that in doing so, we can quickly move this important legislation forward. As is well known, Bill C-51 reflects the mandate of the Minister of Justice to review the criminal justice system. It proposes changes that would make the criminal law fairer, clearer, more relevant, and more accessible. These changes are critically important. The Criminal Code provides the anchor for the criminal justice system and the actions taken within it. As such, these changes help to advance the Minister's ongoing work to transform the criminal justice system and ensure it continues to promote public safety, holds offenders to account, and meets the needs of victims. Bill C-51 proposes changes to the Criminal Code and to the Department of Justice Act. Madam Speaker, I'm particularly proud to be part of a government who has shown a consistent and unwavering commitment to promoting the greatest possible respect for the Charter of Rights and Freedoms. This commitment is reflected in Bill C-51 in many ways. Notably, it proposes changes that would require the Minister of Justice to table a charter statement in Parliament for every government bill. These statements are already being tabled by the Minister in respect of her bills. Under Bill C-51, this would be mandatory for the current and future governments. Some have suggested that this type of change is unnecessary given the Minister's current statutory responsibility to examine every bill introduced in Parliament in order to determine if any of its proposed changes are inconsistent with the Charter. However, we can go further, and this is what Bill C-51 does. By providing Parliament, the public, and all stakeholders with information on the effects of all government legislation on our constitutionally protected rights, these changes contribute to a more informed debate on government legislation and a more informed justice system. It is in all of our interest to ensure that those responsible for administering the justice system understand how federal laws implicate our charter rights. This is particularly true for the criminal justice system. Bill C-51's proposed changes to the Criminal Code can be said to fall in three broad categories. First, Bill C-51 would repeal a number of offences in the Criminal Code that are obsolete or otherwise redundant. Next, Bill C-51 builds on the work started by the Minister of Justice in Bill C-39 and proposes to repeal provisions that have been found unconstitutional by the courts. It also seeks to amend provisions that have been identified as raising charter risks, but which have not been constitutionally considered. I see the proposed changes in Bill C-51 as reflecting a recognition by the Minister of Justice that for far too long we have not been engaging in the kind of modernizing, clarifying, and rationalizing necessary to ensure that our criminal code remains coherent and contemporary. Criminal law academics from across Canada, as well as justice system stakeholders, have been calling for this kind of law reform for years. The public also deserves nothing less than a criminal code that reflects modern society and which would be an accurate reflection of the law enforced today. Bill C-51 seeks to make these kinds of changes, and I congratulate the Minister of Justice for making this kind of criminal law reform a priority. Bill C-51 has generated a lively and important debate. Much of the focus of the debates and the concerns expressed to date have centered on the bill's proposed changes to sexual assault law, an area that many recognize as complex, but for which we would all agree clarity is particularly important, and an area of particular interest to me as Vice Chair of the Status of Women Committee. I will focus the remainder of my remarks on this section of the bill. I think this area is important for a number of reasons, especially in light of what we have seen in Canada and elsewhere as an ever-expanding dialogue and discussion about gender-based violence and inappropriate and unacceptable sexualized conduct. This violence is almost universally perpetrated by men towards women or towards LGBTQ2 individuals. And we know that many survivors of sexual violence in Canada believe that the criminal justice system is not well equipped to address their needs, and that if they do come forward to report a crime, they will not see justice. We do have to do better in addressing these realities, and within our own responsibility can make positive contributions in this regard. Bill C-51 clarifies and strengthens the law on sexual assault and will help address concerns about how the law is applied in practice. I was particularly pleased to see the changes to consent that are included in this bill. I had the opportunity to sit in on the Justice Committee's hearings during testimony on consent. I am pleased to see that at report stage these definitions have been further clarified. We know that no means no, and that someone who is incapacitated by alcohol or otherwise, or unconscious, is not able to provide informed consent. Now the criminal code will reflect these realities. These changes are, however, only one part of the solution. I'm proud of the work of our Status of Women Committee, reflected in our government's commitment to tackling gender-based violence and promoting gender equality as a priority. Efforts like the establishment of a national strategy to address gender-based violence and the allocation of $12 million through the Victims Fund for projects are designed to improve the criminal justice system's response to sexual assault against adults. This funding is going towards initiatives pursued by the provinces and territories to support victims of sexual assault to receive independent legal advice or the development of awareness raising for the judiciary on gender-based violence. These initiatives are important and will contribute to making the justice system more responsive to the needs of survivors of sexual assault. Furthermore, our government has made judicial education a priority. In April 2017, we announced nearly $100,000 in new funding to the National Judicial Institute to develop training for both federally and provincially appointed judges that will focus on gender-based violence, including sexual assault and domestic violence. Additionally, Budget 2017 provided funding to the Canadian Judicial Council to support judicial education and training. This funding will ensure that more judges have access to professional development with a greater focus on gender and diversity training. Madam Speaker, I urge all members of the Chamber to support Bill C-51. I believe this bill is critically important in ensuring that survivors of sexual assault are treated with the respect and dignity they deserve. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. The honourable member for Ottawa West Nipissing.
Thank you, Madam Speaker, and I want to thank my honourable colleague from Oakville, North Burlington, for so eloquently talking about what this bill will actually do, particularly for women in sexual assault cases. And I wonder if she could elaborate on the fact that right now in law, we don't have definitions of consent that talk about if somebody is unconscious, and what specifically this bill is going to do to ensure that we strengthen our justice system with regard to those on sexual assault cases.
The honourable member for Oakville, North Burlington.
Thank you very much, and thank you for the question. I congratulate my colleague for her work in this area as well, and we had the privilege of serving together on the Status of Women Committee and heard evidence during our study on violence against young women and girls that consent is an issue that has been one of the reasons that many times women do not come forward, because they have believed that the law would not support them when it came to what actually defined consent. And in fact, we had comments made in the judiciary questioning whether or not consent was actually given. And so it was actually quite informative to sit in on the Justice Committee to hear the other side of how consent is actually interpreted. And I was pleased to see amendments made at committee that further strengthened the fact that no means no, and that it's important that consent is very consistently defined or carefully defined so that it's interpreted properly in the courts. Thank you.
Questions and comments? The only member for Barrie Innisfil.
Thank you, Madam Speaker. Quickly, just wondering what the member's opinion is on the changes to Section 176 of this legislation.
The member for Oakville North Burlington.
Thank you, and I thank the member for his question. And I know that this section was subject to a great deal of discussion in committee and outside of committee, and I have to say that I'm quite proud of this government for taking work at committee seriously and allowing committees to do the work that is required when bills come to be studied, to hear from witnesses, and in this particular case, with regards to this section of the bill, listening to witnesses, listening to the public, and amending the bill to actually retain this section and further modernize and make it gender neutral, and in fact improving upon what was sent to it. So I'm quite pleased with the outcome from the committee and to see what has been sent to the House during report stage.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of International Development.
Thank you, Madam Speaker. I'd like to thank my honourable colleague for her always insightful comments around this piece of legislation. And Madam Speaker, I'm wondering if she could provide some additional insight. As she well knows, over the last little while, there has been many campaigns in which women and girls have expressed their Me Too in terms of sexual violence. And, you know, I want to make sure that constituents in my riding of Whitby are clear as to how this piece of legislation is able to allow women to more readily find confidence in the justice system to ensure that when their complaints are brought forward, they are actually taken seriously and there is justice for those victims.
Our member for Oakville North Burlington.
Thank you, and I thank the member for her advocacy on this issue as well. And it's something that we know that women and members of the LGBTQ community have not come forward because of fears that they will not be taken seriously, and that when it does go to court, that they are concerned that consent may not have been given. This legislation can give them confidence that no means no, and whether they are, regardless of the situation they find themselves in, whether it be through alcohol or some other situation where they're concerned that perhaps it would be interpreted differently, that they can have confidence that the justice system, this is only one piece of what's required, but it is an important step in making sure that survivors of sexual violence can come forward with confidence.
Before I go to resuming debate, I just want to remind the next speaker that unfortunately we'll have to interrupt him until for the question period, and that he'll have his remaining time after when we are debating the issue after question period. Resuming debate, reprise de débat, the honourable member for St. Albert, Edmonton.
Well, thank you, Madam Speaker. I rise to speak on Bill C-51, the latest omnibus bill from this government. And I have to say it is a bit ironic that we're here debating an omnibus bill, given the fact that when the Liberals were in opposition, they made so much noise and such a fuss about omnibus bills introduced by the previous Conservative government. The Prime Minister and the Liberal platform called omnibus bills undemocratic. and the Prime Minister pledged that a Liberal government would undo the practice of introducing omnibus bills. But I guess, like so many promises made by the Prime Minister during the last election, this is just another broken promise in a string of broken promises from the Prime Minister, and really illustrates that the Prime Minister's platform, real change, wasn't worth the paper that it was written on. This bill, as an omnibus bill, contains a number of different sections and parts that are unrelated, and given the fact that it contains a number of different sections that are unrelated, it then comes as no surprise that there are parts of Bill C-51 that I strongly support, and there are other parts of Bill C-51 that I have real concerns with. Maybe, Madam Speaker, I'll start with some of the positives. One aspect of Bill C-51 that I strongly support is the removal of unconstitutional sections of the Criminal Code. Canadians should be able to expect that the Criminal Code accurately reflects the state of the law. And yet, for Canadians to make that common sense assumption, they would be wrong, Madam Speaker. They would be wrong because the Criminal Code contains dozens and dozens of sections that have been found to be unconstitutional. The consequences of leaving sections in the Criminal Code that are unconstitutional can be very, very serious. And that was most recently illustrated last year when Travis Vader's conviction of 2 counts of second-degree murder of Lyle and Marie McCann was vacated after the trial judge applied a section of the Criminal Code that had been found to be unconstitutional 26 years earlier, all the way back in 1990. And yet, there was the section in black and white in the Criminal Code purporting to represent the law on its face, Madam Speaker. The McCann family, Lyle and Marie McCann, who were murdered, resided in St. Albert, and the McCann family, members of the McCann family, live in my community of St. Albert. And I can tell you that that case really did have a profound impact on our community. And that was further strengthened the impact of the case after the family waited 6 years for justice. And at the moment that it seemed that justice had been finally achieved, we saw the injustice of having those convictions, those 2 convictions of 2 counts of second-degree murder, vacated. What happened to the McCann family should never have happened. It was completely preventable, and it is why in December of 2016 I joined Brett McCann, the son of Lyle and Marie McCann, at a press conference to call on this government, to call on the Minister of Justice to introduce legislation to repeal unconstitutional sections of a criminal code often referred to as zombie laws. And so, to that end, I am pleased that Bill C-51 does or will remove sections of the criminal code that have been found to be unconstitutional by appellate courts. I'm also pleased that the government introduced Bill C-39, which would remove sections of the criminal code that have been found to be unconstitutional by the Supreme Court of Canada. But I must say I'm very disappointed with the lack of progress that the government has made in the passage of Bill C-39. Bill C-39 was introduced by the Minister of Justice on March 8th of 2017. Nearly a year later, absolutely no legislative progress has been made. Indeed, Bill C-39 remains stuck at first reading. Bill C-39 is straightforward legislation. It isn't controversial, and it could be passed easily. And yet the minister continues to drag her feet. I have to say that I'm baffled, and the McCann family is baffled and frustrated about the failure of this government to move Bill C-39 forward so that unconstitutional sections, as determined by the Supreme Court, can be removed from the criminal code, including the section that was wrongfully applied in the Vader case. The inaction from this minister and from this government increases the likelihood that something like what happened to the McCann family can happen again, and in the event that it does, as a result of this government's inaction, this government will bear partial responsibility. So I urge the government to move forward with C-39 in addition to C-51. Now, one other positive aspect about Bill C-51 is the fact that the government has finally backed down from the removal of Section 176 from the Criminal Code. One of the parts of Bill C-51 is, again, to remove unconstitutional sections, as well as sections of the Criminal Code that, in the opinion of the government, are redundant or obsolete. Section 176 of the Criminal Code makes it a criminal offense to obstruct or threaten a religious official or to disrupt a religious service or ceremony. Section 176, simply put, isn't unconstitutional. It's never been challenged in court, never been found by any court to be unconstitutional. It isn't obsolete. Indeed, a number of individuals have been successfully prosecuted under Section 176, and it isn't redundant inasmuch as it is the only section of the criminal code that expressly protects the rights and freedoms of Canadians to practice their religion without fear or intimidation. A freedom that, by the way, Madam Speaker, isn't just any freedom. When we're talking about freedom of religion, we're talking about a fundamental freedom guaranteed under the Charter of Rights and Freedoms. And so I'm glad that this government listened to the official opposition, and more importantly, listened to thousands and thousands of Canadians who signed a petition, who wrote letters, who wrote emails, who made phone calls to MPs, to the government to say, keep Section 176 in the criminal code. Now, Bill C-51 will remove another section of the criminal code that I believe shouldn't be removed, and that is Section 49. Section 49 makes it an offense to attack or harm the head of state, Her Majesty the Queen. The government has not been able to provide any real meaningful rationale as to why Section 49 is going to be removed. They haven't been able to provide a rationale in debate. They haven't been able to provide a rationale at committee. And I have to say, Madam Speaker, that it couldn't come at a worse time, because this marks the 65th anniversary this year that Queen Elizabeth was ascended to the throne. And so it really is, it just makes no sense why this government seems intent on removing Section 49 from the criminal code. Now, perhaps the most substantive part of Bill C-51 deals with amendments to the criminal code related to sexual assault laws in Canada. And, Madam Speaker, there are a number of parts that Bill C-51 would amend in terms of sexual assault provisions of the code. A number of the changes in Bill C-51 would clean up the criminal code in terms of codifying certain Supreme Court decisions, including the JA decision and the Iwanchuk decision of the Supreme Court. I fully support the parts of Bill C-51 that clean up the criminal code with respect to sexual assault laws that codify decisions of the Supreme Court of Canada.
So I'm sorry to end the speech at this point, but the member will have 9 minutes when the subject is before the House after a question period. I do want to remind members that there is quite a bit of a buzz happening right now, and I would just ask people to tone their voices down so that the statements can be heard. Resuming, orders of the day, statements by members, déclaration des députés, l'honorable député.
The Honourable Member for Repentigny. Tomorrow will be the 6th anniversary of a shameful moment in the history of Canada, Madam Speaker. On December 12, 2011, Canada announced that it would be the first country to withdraw from the Kyoto Protocol. That is the Christmas present that the Conservative government gave the planet that year. But it's not surprising because Stephen Harper said that Kyoto was a socialist plot. And he even said that the greenhouse gas reduction targets under Kyoto were stupid. Harper preferred to establish his own targets to foster the expansion of the oil sands in Alberta, which he set in 2015. And today, Mr. Harper's not around anymore, but the Liberal government is still using the same targets as the Conservatives, which ones had been specifically designed to not meet the standards. The targets of a climate change skeptic government, which marked the history of Canada by making Canada the first country to withdraw from the Kyoto Protocol.
For Pickering Uxbridge.
Mr. Speaker, I want to remind Canadians that not everyone has a safe place to call home this holiday season. A recent article by Gillian Fuller highlighted the grave situation facing Durham Region's women's shelters. Over 1,000 women have been turned away from our shelters because they were already operating at overcapacity this year. In 1 year, Durham's 4 shelters housed 608 women and 320 children, fielding over 5,000 calls to their crisis lines. Our region has also seen 3 domestic homicides in 2017. These trends are extremely alarming. So, as we prepare for the holidays, I ask residents in my community to keep these women and children fleeing violence in their minds by showing their support for local organizations. One initiative, the Mitten Tree at Pickering Public Library, is collecting mittens, hats, gloves, scarves, and toiletries for Horizon House's women's shelter. If we were to stop this trend, we need men and women to become leaders in ending violence against women. Thank you, Mr. Speaker.
The Honourable Member for Banff Airdrie.
Well, Mr. Speaker, Christmas is a wonderful time to focus on our charitable giving. Canadians are extremely generous, and there's nowhere that's more evident than in our communities. There's 2 groups that I want to mention and congratulate today: the 100 Women Who Care, with chapters in Cochrane, Airdrie, and Bow Valley, and 100 Men Who Give a Damn in Cochrane and Airdrie. These 2 great organizations show what a big difference can be made when people work together towards a common goal. Once every quarter, these organizations meet and they hear pitches from local charities, and the group then votes for one of the charities to receive the money. Each participant kicks in $100 per meeting, resulting in tens of thousands of dollars raised throughout the year. Now, often all of the charities end up receiving support when members step up to give a little extra, as was evidenced in the first meeting of the Airdrie Men, thanks to Bill Martin and others. And I want to thank all of those who have joined me in being a part of either the 100 Women or the 100 Men, and hope that their spirit of charity and generosity is spread across the country during this Christmas season.
The Honourable Member for Eglinton Lawrence.
Merci, Monsieur le Président.
Thank you, Mr. Speaker.
Officially opened its doors in October 1980, it fulfilled a dream of the Italian-Canadian community. That dream started with a vision where youth and seniors, art and science, politics and faith could all come together in a cultural space which we could call our own. Over the years, the Piazza has hosted prime ministers, Supreme Court justices, cardinals, academics and musicians, even Luciano Pavarotti. Transcending these events are the families who come every day to see their nonas. Both of mine lived at Villa Colombo, or to drop off their kids at childcare or Centro Scuola, or for a workout, or just to have an espresso at Cinquecento. As the city grows, any case for development must respect the voices of the community first. Those voices are loud and clear. Do not tear down the Columbus Centre. It's more than just bricks and mortar. It's the heart of the Italian-Canadian community in Toronto. A dream that began with 1 million acts of kindness is now a cherished institution worth fighting for. Listen to the community. Siamo con voi.
L'honorable député.
The honourable member for Berthier-Maskinongé. Mr. Speaker, recently I had the opportunity to visit a number of Christmas markets in my riding of Berthier-Maskinongé. Christmas markets are an excellent opportunity to discover and rediscover the local products and crafts. These events also highlight the quality of our agri-food products, as well as the talent of our artists and artisans in the regions. By buying local, consumers are choosing quality products, committing to their community, and reducing their environmental footprint. So in the beginning of this Christmas period, I encourage you to go with your family to visit Christmas markets and local businesses in your regions. In closing, Mr. Speaker, we must also remember the exceptional contribution of volunteers in our regions and communities who make all the difference. Thanks for your generosity and collaboration in order to improve the lives of people in our regions. I wish all of you a wonderful holiday season. Thank you.
The honourable member for York Centre.
Glory in red, an ode to Toronto FC. The sun was setting on Saturday night as our boys in red took the field, shining so bright. A superlative season did lie in their wake, but this was the big game, an opportunity for redemption at stake. We were flying in the first half, keeping Seattle pinned back, but sadly no goals, even though we dominated attack. The second half kicked off, TFC in full flight, then in a moment of glory, Altador struck with great might. The celebration was wild. The fans, they did roar. Red Patch Boys, Tribal Rhythm Nation, U-Sector, and so many more. As the clock wound down, Vasquez put it away, ensuring TFC fans would never forget this championship day. As the lads raised the cup, our hearts filled with delight, our heroes got it done on this unforgettable night. So here is my message as I wrap up this short ditty. Your hard work and commitment bring tremendous pride to our city. As we end 2017, this year put to bed, we will forever have memories of our TFC champs, of their glory in red.
Hey, good job. Sounds as though the member for Cape Breton Council has some competition around here. The honourable member for Provencher.
Mr. Speaker, as we approach the end of the year in which Canada has celebrated its 150th birthday, we have much to be thankful for. Thankful for the blessings of freedom, peace, and abundance. We should not take these blessings for granted, but we should guard against their erosion. Broadcaster Paul Harvey noted that many of the world's great nations were at the height of their greatness at the 150-year mark, before they decayed morally, socially, culturally, and economically. Rights without responsibility and freedoms without restraint are recipes for disaster. We must be careful not to rewrite history and imply that our own forefathers' intentions were somehow less noble than our own. We can't afford to replace the rewards of ambition with reliance of the state. We must emphasize the family as the core of a strong society, not government. Canada is a nation founded upon principles that recognize the supremacy of God and the rule of law. We must continually recognize the absolutes of good and evil, right and wrong. As we look toward 2018, let us commit to re-embrace the principles that have made Canada great.
The honourable member for Etobicoke Centre.
Mr. Speaker, in December 1917, 100 years ago, the Crimean Tatars proclaimed their democratic republic and launched their National Assembly, the Kurultai. The Bolsheviks abolished this state, and in 1944, Stalin attempted ethnocide through the mass deportation of Crimean Tatars into Central Asia. Almost half perished during the deportation. However, starting in 1989, Crimean Tatars began returning home, and under independent Ukraine were provided citizenship and a formal right of return. Sadly, history seems to be repeating itself. With Russia's 2014 military invasion and illegal occupation, the Crimean Tatars are once again facing disappearances, the murders of leaders, exile, and collective repression and persecution. As we commemorate the centenary of the Crimean Tatar Kurultai, let us reaffirm the Crimean Tatars are the indigenous people of Crimea, and Crimea is Ukraine.
The honourable member for Hamilton East Stony Creek.
Mr. Speaker, the city of Hamilton remains in shock and sorrow over the tragic and needless loss of a teenage Good Samaritan. Yusuf al-Hasnawi died after trying to help an older person who was being threatened on the street by two young men. Yusuf was a 19-year-old Brock University student whose family came from Iraq to Canada to escape the violence in their homeland. His Muslim faith and his parents taught him to help others in need, as is stated in the Quran. As he stood between the older man and the assailants, a gun was pulled, a shot was fired, and within an hour, Yusuf succumbed to a bullet wound in the head, gone from the earth, gone from his family, his community, and his future. Let the Hasnawi family know, my colleagues here in Parliament today, that an attack on one is an attack on all.
The honourable member for Caribou Prince George.
Mr. Speaker, all too often we take for granted those who stand ready to give their lives for us. We live safely knowing that they stand at the ready to put themselves in harm's way. The brave men and women who are our paramedics, our firefighters, our police officers, and our Canadian forces, they put their uniforms on every day knowing full well that in their service to our country and to our community, they may experience human tragedy and that they themselves may pay the ultimate sacrifice. These men and women have an almost mythical aura that defies the day-to-day. But beyond the reality that is our perceptions, our heroes are, like the rest of us, only human. They're not immune to the horrific circumstances they experience. It takes a toll. I, along with the member from Elgin, Middlesex, London, invite you all tonight to attend the premiere of the documentary, The Other Side of Hero. The other side of the hero takes us into the world of our first responders that we rarely see, life beyond the uniform. I hope you all will join us tonight at the Sir John A. Macdonald Building in room 200 at 7 p.m. Thank you.
The honourable member for Vimy. There are a few things as admirable as risking your life for someone else. On May 7th, Luc Vincent did not hesitate for a moment to put his life on the line to try to save someone else when a car plunged into and eventually submerged under the waters of Lake de Montagne. Mr. Vincent returned with a boat and other assistants who continued to try and save the trapped individual despite suffering from effects of hypothermia from the freezing water. His heroism and selflessness should not be forgotten. For Mr. Vincent and others who have had to think fast and put their own well-being on the line, thank you for your courage. Sometimes altruism can change or save a life.
Bravo, Luc. Thank you, Mr. Speaker.
Honourable member for London North Centre.
Mr. Speaker, Greeks in Canada have a proud legacy as entrepreneurs, artists, athletes, and community leaders. Indeed, our country is home to over 250,000 Canadians of Greek heritage. As we reflect on Canada's 150th year, I'd like to highlight the legacy of a Greek explorer. Ioannis Fokas was born on the Greek island of Kefalonia in 1536. He was an experienced sailor who undertook missions on behalf of the Spanish court under the name of Juan de Fuca to what is modern-day China, the Philippines, and Mexico. He's best known for exploring the area that now bears his name, the Strait of Juan de Fuca between Vancouver Island and northwestern Washington state. Geologic wonders such as the Juan de Fuca Ridge, the Juan de Fuca Plate, and the Juan de Fuca Provincial Park on Vancouver Island's west coast are all named after him. On behalf of all Canadians of Greek and Kefalonian heritage, of which I am one, I salute the memory of Juan de Fuca. Zito Elas, Zito Kefalonia, Zito Kanadas. Ευχαριστώ, κύριε Πρόεδρε.
Zito!
The honourable member for Parry Sound, Muskoka.
Thank you, Mr. Speaker. I rise today to recognize International Human Rights Day, which was observed yesterday, December 10th. While there are numerous examples, of course, of human rights abuses that deserve to be highlighted, I would like to emphasize the current human rights situation in the Republic of Artsakh, or Nagorno-Karabakh. I traveled to the region this summer with One Free World International and observed firsthand the conflict there and the horrific human rights abuses inflicted upon people who ultimately only wish to live in peace. We met with mothers who had lost sons and who had lost servicemen and others in the conflict. I was on site of some scenes of unspeakable horror. Mr. Speaker, I have hope for a peaceful and prosperous Artsakh where people can live side by side with their neighbors, including Azerbaijan. The Artsakh conflict is currently mediated through the Organization of Security and Cooperation in Europe, where Canada is a full member, and I urge the government to condemn human rights abuses in the region and work to deter further escalation of the conflict. Thank you.
The honourable member for La Salle-Mar.
Chief Justice and the first woman to lead the court will officially retire from the Supreme Court of Canada. Originaire de Pincher Creek, Alberta,
Originaire of Pincher Creek, Alberta, she studied philosophy and law at University of Alberta
and British Columbia before joining the Faculty of Law at UBC in 1974. Her 36-year judicial career, Mr. Speaker, started in 1981 when she was first appointed to the Vancouver County Court. Puis de la Cour suprême de la Colombie-Britannique à
Then, from the Supreme Court of BC to the Court of Appeal, she was named puisne judge by Brian Mulroney to the Supreme Court of Canada on March 30th, 1989, and was appointed Chief Justice of Canada on January 7th, 2000 by Jean Chrétien. Mr. Speaker, after 28 years on the bench of the highest court in the land, including 17 as Chief Justice, Beverly McLaughlin will be hanging up her robe.
She has been a real leader for our court and our country and a great Canadian judicial ambassador abroad. We will remember her sense of humor and her joie de vivre, and as she enjoys true moments of happiness when cooking for her family and friends using fresh vegetables.
The honourable member for Skeena-Bulkley Valley.
Thank you, Mr. Speaker. It is with great pride and humility that I stand to pay tribute to the wisdom, courage, and determination of the Wet'suwet'en and Gitxsan leaders of northern British Columbia. Today marks the 20th anniversary of the landmark Supreme Court decision known as Delgamuukw Stay-Way. After generations of struggle, these elders stood in our highest court and won not only a victory for their nations, but also for First Nations across Canada. By proving that oral history must have equal standing in our courts, Delgamuukw tore down a stone from the wall of legal and colonial oppression. That day 20 years ago didn't just change the history of Canada, it changed our very idea of history. It has been said that the arc of the moral universe is long but bends towards justice. And while the history of the federal government with respect to this land's First Peoples is filled with shame, the struggle for justice is of a far greater power. Today we honor the Wet'suwet'en and Gitxsan elders for their determination in opening all our eyes to a more just and beautiful country.
Honourable member for Calgary Confederation.
Mr. Speaker, the eyes of Canada's curling world were focused on the Roar of the Rings tournament this past weekend in Ottawa that featured teams from across Canada. Olympic spots were on the line. I was there and the competition was fierce. The fans were passionate. It was a curling competition at its best. After many games, lots of cheering, agonizing losses, and triumphant victories, it was down to the finals on Sunday. For the women, the final match saw Team Homan of Ottawa best Calgary's Chelsea Karen, Kathy Overton Clapham, Jocelyn Peterman, and Lane Peters. On the men's side, Manitoba's Team McEwen was bested by Calgary's finest. A hearty congratulations to Calgary's skip Kevin Cooey and his team of Mark Kennedy, Brett Lang, and Ben Hebert. You're off to the Olympics. Calgary and the rest of Canada will be cheering for you every step of the way.
Honourable member for Scarborough Rouge Park.
Mr. Speaker, I rise today to mark International Human Rights Day, a day to reflect on the enormous strides we have made in advancing human rights both in Canada and around the world. It is also a day to recommit to ensuring that the principles outlined in the Universal Declaration of Human Rights are fulfilled. This sesquicentennial year, Canadians celebrated the 35th anniversary of the Canadian Charter of Rights and Freedoms, and we've advanced human rights by accepting the United Nations Declarations on the Rights of Indigenous Peoples, through a historic apology to the LGBTQ2 community for past wrongs, the introduction of a national housing strategy that views human rights, that looks at housing as a fundamental human rights, and a meeting of federal, provincial, territorial ministers on human rights, first such gathering in 29 years. Human rights are universal, indivisible, interdependent, and interrelated. As Canadians, we need to strive towards the attainment of human rights for all. It is the greatest legacy we can leave our children. Thank you, Mr. Speaker.
Questions orales, oral questions. The Honourable Leader of the Opposition.
Mr. Speaker, the Prime Minister is currently under investigation because he accepted a free trip, and the Finance Minister is under investigation on a conflict of interest regarding his pension bill. The Ethics Commissioner is so busy with the Liberals that we don't know if she'll have time to wrap up her investigations by the end of her term. Will the Prime Minister commit to making sure that those investigations will continue once the Ethics Commissioner is replaced? The Honourable Prime Minister. Mr. Speaker, as I have often said, I have recused myself from any discussions regarding the appointment of the next Ethics Commissioner. Furthermore, 4 members of our staff have also put up a screen to not participate in those discussions. My team, however, will continue to support the House Leader and their staff in the same way that all other ministers' offices are supported in the hundreds of appointments made. The Honourable, the Leader of the Opposition.
I understand how inconvenient it is for the Cabinet that the Prime Minister can't answer these questions because he's under investigation. But Canadians need to know, normally a new Ethics Commissioner would be appointed by government after consulting with the opposition and a parliamentary committee hearing for the nominee. But the Liberals are trying to ram this appointment through. So if the Prime Minister can't answer this himself, is there someone over there who can make the commitment that members of Parliament will have the opportunity to interview the nominee for the Ethics Commissioner before the appointment is official?
Right Honourable Prime Minister.
Mr. Speaker, after 10 years of the kind of patronage that the previous government put forward, we put forward an independent, merit-based process for government appointments. This ensures that government appointments are not only of the highest quality, but reflect the range and scope of experiences and diversity that makes Canada strong. But I know that every member of this House relies on the impartial and expert advice that the Conflict of Interest and Ethics Commissioner will give, and I have utmost confidence that the Government House Leader is managing this appointment process appropriately and as must be expected.
Honourable Leader of the Opposition.
Mr. Speaker, during their election campaign, the Prime Minister promised that no veteran would be forced to fight his own government for any compensation they had a right to. For 2 years now, the veterans have had to fight this Prime Minister. We learned that since the end of March, the backlog for veterans waiting for their disability awards has increased by 50%. Our veterans deserve respect because they fought for their country. Why does this Prime Minister not defend them? The Right Honourable the Prime Minister. Mr. Speaker, here is what did happen. For 10 years, the Conservative government closed veterans' offices, spent their time in benefiting from the appearance of the veterans while not giving them the services they had a right to. For 2 years now, we have reopened those offices. We have invested far more money and more insistence for these veterans. And veterans are coming forward with their proposals. They lost hope under the previous government, but now they're coming back into our system, and that's a good thing.
Mr. Speaker, like many Canadians, veterans are now realizing that this Prime Minister said just about anything during the campaign to get elected. It's this government's record that has resulted in an increase of 50% for the backlogs of these cases. That's on him and his government, nobody else's. The Defence Ombudsman has made simple, easy recommendations to improve the transition of our armed forces members onto the Veterans Affairs payroll. And this Prime Minister has yet to act on any of them. When will he start listening to the advice of experts and stand up for our vets?
Right Honourable Prime Minister.
Mr. Speaker, it's fairly straightforward what happened. So many veterans had abandoned the idea of getting help under the previous government that now that we are actually putting in place systems and benefits that they can access, reopening offices that they shuttered, more and more veterans are coming forward to claim what this government and all governments owe them. This is a good thing, Mr. Speaker, and what's great is that we have been tooling up over the past years so that we can give all the veterans who entitle it what they have. That veterans be coming forward to claim their benefits.
The Honourable Leader of the Opposition.
only to a Liberal would increasing spending and getting worse results be a good thing. Canadians are sick of this kind of attitude. But it's not just veterans who are realizing that this government has had a mean-spirited and cold-hearted attitude towards them. Those who have applied for disability tax credits have realized it as well. Now, just last week, the Revenue Minister told this House, and I quote, "I would like to reassure all Canadians who receive the disability tax credit that the eligibility criteria have not changed." But on Friday, her parliamentary secretary apologized for that very change, which saw 80% of applicants see their claims denied. So can the Prime Minister explain, if there wasn't a policy change, exactly what did his government apologize for?
Right, Honourable Prime Minister.
Mr. Speaker, as a government, we are committed to ensuring that citizens get all the benefits to which they are entitled. That is something we've been focused on over the past 2 years, and that is something that we are delivering on. We have heard that some of the clarification letter has resulted in negative impacts, and that's why we are making looking at it carefully to ensure that indeed we're getting the delivery of services that Canadians expect.
The honourable member for Rimouski-Nejet-Témiscouata-Les-Basques. Mr. Speaker, the government has been in office for 2 years, and yet the situation of veterans is only getting worse. They have to take responsibility. It is the Canadian government's duty to make sure that those who serve their country are not simply left to their fate. 71% of veterans are still waiting for more than 3 months before getting their pension. That leaves them in a financial limbo, which has profound and negative consequences. Can the Prime Minister make sure that pensions and support for veterans and their families be in place before they leave the Army? The Right Honourable, the Prime Minister. Over the past 2 years, we have done considerable work to restore services to our veterans and that they expect and deserve. There is still work to do, and we acknowledge that there are veterans who are now sending in their applications into a system that have been literally abandoned under Conservatives, and that's why we're working so hard to meet requirements. We've opened up 9 service points for our veterans, and we will continue to work for our veterans so that the sacrifice and their service does not remain unacknowledged.
Mr. Speaker, with less than a third of cases actually meeting departmental targets, this government is merely paying lip service to veterans. The department remains understaffed thanks to Conservative cuts and the Liberals' failure to hire enough staff to meet increased demands. And, Mr. Speaker, veterans are still waiting to hear what this government's new promised pension scheme will be. What's the delay? Where is the plan? Will the minister release his plan for our country's veterans before the House rises? Yes.
The Right Honourable Prime Minister.
Mr. Speaker, the fact is we have worked very, very hard over the past 2 years to restore the kinds of benefits that our veterans deserved and that they didn't get under 10 years of a Conservative government. There is much to do, and there continues to be more to do, and we look forward to continuing to work with veterans groups to ensure that the new lifelong pension is restored to the level that everyone can expect. These are the kinds of things that we know need to happen, and they need to happen right, and that's why we're taking it so very, very seriously.
Honourable member for Rimouski-Nejet-Témiscouata-Les-Basques.
Across the country, and the principle of a free and democratic press is actually in jeopardy. The favoritism this government is showing to American digital giants, such as Netflix, is a large part of the problem. After confusingly defending her scheme, the Heritage Ministers threw the ball in the Finance Minister's court, who left her hanging by confirming that he will continue giving Netflix a free pass. With his cabinet in disarray on this issue, the Prime Minister must step in and defend the press. Will he do it?
Honourable Prime Minister.
Mr. Speaker, the first thing we did when we came into office was lower taxes on the middle class and raise them on the wealthiest 1%. So despite what the Conservatives and the NDP propose, we will not be raising taxes on Canadians.
The honourable member for Longueuil-Saint-Hubert. Mr. Speaker, the Minister of Heritage came back to Montreal on Friday to say the same thing she said 2 months ago, except that this time she added that she hears Quebec and that she will no longer defend the tax break for Netflix and that we'll have to speak to the Minister of Finance. While Quebec is unanimous in condemning special tax credit, special tax treatment for Netflix and other web giants, unions, business people, everyone. What did the Minister of Finance say? No, that's pathetic. That's how important the Quebec consensus is for this government, for this Prime Minister? Can they do more than just go on at UNESCO and not stand up for our culture? I would encourage members to be wise in their use of language. The Right Honourable the Prime Minister. Thank you, Mr. Speaker. It has been a pleasure for me to be able to travel throughout Quebec and to Lac-Saint-Jean over the past few months, where I had an opportunity to speak to people about their priorities. And I can tell you, there was not a single Quebecer who told me to increase their taxes. Even though the Conservatives and the NDP want to increase taxes for consumers, we will not increase taxes on consumers. We will continue to lower taxes for the middle class and increase them for the wealthiest, but not for ordinary people. Honourable Member for Richmond-Athabasca. Mr. Speaker, on the 1st of January, in a few days, tax changes will come into effect and negatively impact our small and medium-sized businesses because they have not received the details of these changes. Tax experts have been clear. It's too late. The minister will be taking even more money out of their pockets. With Christmas coming, this looks awfully like a poisoned gift. Why doesn't the minister give a real gift to Canadians? And why doesn't the Prime Minister give them a gift and dismiss his Minister of Finance and stop attacking our job creators? The Honourable Parliamentary Secretary to the Minister of Finance. Thank you, Mr. Speaker. I can reassure my colleague that the details on our tax changes and on income sprinkling will be announced soon, imminently, actually. And I would like to recall to my colleague that our goal here is not to have an impact on family businesses, but to have more tax fairness in the system. It is not fair that the wealthiest be able to incorporate in order to be able to save the equivalent of the average salary of a Canadian, $48,000. Now, I know this is very difficult for the Conservatives to understand. The Honourable Member for Richmond-Athabasca. Mr. Speaker, please allow me to read from one of the hundreds of letters that I received at my office. It says this: I am shocked to learn that our Minister of Finance intends on completely disregarding the fundamental right of all citizens to do the necessary tax planning for their financial affairs. Small and medium-sized owners are the ones who will be penalized. This is a double injustice, bad tax reform, and no time to plan. What a lack of responsibility, and what hypocrisy on the part of the minister. He should do the right thing and resign. This is from an angry citizen, Pierre. The Honourable the Parliamentary Secretary to the Minister of Finance. Mr. Speaker, on the contrary, our goal has always been to make sure that a member of a family working in a family business continue to be able to work. We just want to bring more tax fairness where there are undue advantages for certain Canadians that middle-class Canadians do not have access to. All SME owners will benefit from a lower tax, 10.5 to 9% by 2019, because we recognize the importance of businesses in our prosperity.
House Leader.
With only 3 weeks left until these tax changes come into effect, the Minister of Finance refuses to tell small businesses what effect they will have on them. He says it's no big deal. Well, we know it's not a big deal for the minister because he's got his millions sheltered from taxes in offshore accounts and numbered companies. But it's a big deal to local small businesses who are trying to deal with these hypocritical and unfair Liberal tax changes. Why is the Minister of Finance so disrespectful to our small business owners?
Parliamentary Secretary to the Minister of Finance.
Thank you, Mr. Speaker. I want to reassure my colleague from the opposition that the details will be coming in very shortly. Our objective here is to bring more tax fairness to a system where there are inequities built in the system. Our objective is also to always support the family business model. We have no intention to impact the family members who work in a business. And I might also remind the member that what's good for small businesses is the fact that we've reduced taxes for small businesses from 11 to 10.5 to eventually 9% by 2019. And we've had the the growth in Canada, the fastest in the G7, and 600,000 jobs created. That's good for all businesses. Thank you, Mr. Speaker.
Honourable Opposition House Leader.
Well, remember the last time that the Liberals said that these small business increases were no big deal and they shouldn't worry? Well, remember, that did not go so well for the Liberals. Have the Liberals learned absolutely nothing? They're punishing small businesses again, not just with this hypocritical tax increase, but by the minister ignoring their very substantial questions for some information. The Minister of Finance always seems to be hiding something, doesn't he? What is he hiding now from small business owners?
Honourable Parliamentary Secretary.
Well, Mr. Speaker, our objective here is, and we'll always stand behind the family business model. We've reduced taxes for small businesses from 11 to 10.5% and to 9% by 2019. That's because we realize the importance of small businesses to contribute to the prosperity and to the growth of Canada, and we have great results. Our plan is working, Mr. Speaker. We've got the fastest growth in the G7, 600,000 jobs created in the last 2 years, most of them full-time, and that's the work of this finance minister and this government, supporting small business owners from coast to coast to coast. Thank you, Mr. Speaker.
Honourable Member for Carleton.
The Finance Minister plans a reasonableness test to determine what small businesses can pay their family members. Here's what the former Chief Justice of the Tax Court says about it. I think it's going to substantially increase the number of cases that go to the court because it's going to be a battle between the CRA and the taxpayers as to what reasonable means in various situations. How much will this cobweb of rules cost CRA to enforce, small businesses to comply, and both of them to litigate?
More litigation. Honourable Parliamentary Secretary to the Minister of Finance.
Mr. Speaker, we heard Canadians and entrepreneurs from one ocean to the other. We reviewed their applications over the past few months, and we looked at the details on income sprinkling, which will be announced very soon.
Mr. Speaker, the question was for the Finance Minister. He is the one who says he's going to impose a reasonableness test on what family businesses can pay their family members. But it's not just the past Chief Justice of the Tax Court. The current Chief Justice, in an extraordinary comment, has said that these rules are so vague that no one will know how to enforce them or interpret them. Why doesn't the government listen to the judges and the small business and do away with this complex web of tax increases?
Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. As I've mentioned, and it'll be my pleasure to work with the member opposite to explain the details when the details are known, and these details regarding income sprinkling should be known eminently, Mr. Speaker, and we will always stand behind small business owners. That's why we've reduced the small business tax rate from 11% down to 9% by 2019, Mr. Speaker, because we recognize the importance of small business. We'll always be behind the family business model, and we want to continue to work to make sure that prosperity is trickling down to everyone in this country. Thank you, Mr. Speaker.
Order. Order. The member for Carleton will come to order, please. Honorable député.
The honourable member for Sherbrooke. Mr. Speaker, when it comes to the special tax treatment Netflix gets, the Minister of Finance has once again closed the door in the faces of Quebecers. And who was there right in front? The Minister of Heritage. Obviously, her voice doesn't carry much weight in Cabinet. And the voices of Liberal members from Quebec neither. The Minister of Heritage says one thing and the Minister of Finance says another. Perhaps someone has to get their act together in the government. When will the government stop ignoring a consensus in Quebec? The Honourable Parliamentary Secretary to the Minister of Heritage. Mr. Speaker, our government has always been clear and our position has not changed. We hear the concerns of the Francophone cultural sector and we want to reassure them and recall that we have made historic investments to support our culture. We have massively invested in arts and cultures, more than $2.3 billion. And we've reinvested in the media fund to support production and television. These investments have had a concrete impact on the lives of our artists.
Diana Louvain.
Mr. Speaker, the federal government has aggravated the crisis in local media by slashing its own advertising in Canadian publications while pouring millions of dollars into American digital giants. In a report tabled last week, the Government Operations Committee unanimously recommended increasing the share of federal advertising from Canadian publications. Well, will the government follow this all-party recommendation to support our local media and reach more Canadians?
Parliamentary Secretary to the Minister to the President of the Treasury Board.
The government took another step to making government more open and transparent and accountable by delivering on our commitment to eliminate partisan advertising and modernize its communications. We now have a process in place for conducting independent reviews of paid government advertising to ensure it's nonpartisan. And in addition to that, Mr. Speaker, we have reduced the spending budget by 50% on advertising compared to the previous Conservative government with their partisan advertising. We're proud of what we're doing, and we appreciate the work of the committee in looking at the advertising budget for the future years.
Député de Louis Saint-Laurent.
The Honourable Member for Louis Saint-Laurent. Mr. Speaker, on May 2nd, an internal email in the CRA showed that 80% of those applying for the disability tax credit had been denied. What was the result? Well, last Friday, the CRA announced that it would be reassessing all those denials. What is that? Well, that's an admission of guilt on the part of the government. However, there's one thing lacking still. That's honour. Can someone in this government stand up and say to individuals with diabetes, we apologize? Honourable Parliamentary Secretary to the Minister of National Revenue.
Mr. Speaker, our objective has always been clear, ensuring that Canadians have access to the credits that they're eligible to. With the reinstatement of Disability Advisory Committee, the agency will have a formal advisory process to work on improving the accessibility of its services to Canadians with disabilities. We're giving these groups back their seat at the table, Mr. Speaker, which the Conservatives took away in 2006. This formal process will ensure that any future actions taken by the agency are made in consultation with stakeholders. Thank you, Mr. Speaker.
The Honourable Member for Louis Saint-Laurent. Mr. Speaker, it didn't take a committee to solve this situation. When we were in power, 80% of applications were accepted. When they came into power, 80% were denied. 23 times, Mr. Speaker, in this House, the Minister of Revenue has said no changes were made to the rules. Last Friday, her department said exactly the opposite. So, my question is the same. Will someone in this government be honourable enough to stand up and say to those suffering from diabetes, we apologize, we were wrong?
Mr. Speaker, as a registered nurse, I know how important it is to have vulnerable groups to have their voices heard. With the announcement of the Disability Advisory Committee last week, we will make sure that in the case when it comes to how the agency administers the credits and benefits for people with disabilities, following concerns raised by Canadians, the agency is evaluating applications to determine whether or not there has been an impact in the delivery of DTC. We will continue to take steps to improve the agency's services to all Canadians, particularly the most vulnerable in our country. Thank you, Mr. Speaker.
Honourable Member for Calgary Rocky Ridge.
Mr. Speaker, after 2 months of questions from the opposition and pressure from Diabetes Canada, the Liberals have finally said that they will revert to their pre-May 2nd policy. The strange thing is that even while the minister reverses her policy, she continues to deny that she ever made a change in the first place. Will the minister finally admit that she made a choice to deny the credit, she's now trying to cover her tracks, and will she apologize to type 1 diabetics?
Honourable Parliamentary Secretary to the Minister of National Revenue.
Thank you, Mr. Speaker. Mr. Speaker, our government is committed to ensuring that all Canadians who are eligible for the credits and benefits have access to them. Following concerns raised by Canadians, the agency is evaluating applications to determine whether or not there has been an impact in the delivery of DTC. Through the Disability Advisory Committee, disability advocates, medical professionals, Indigenous advocates, and other important stakeholders will now have consulted on how agency can improve its services to Canadians with disabilities. Unlike the previous government, Mr. Speaker, we want these groups at the table. Thank you.
Honourable Member for Calgary Rocky Ridge.
Mr. Speaker, during a meeting with stakeholders on November 30th, the minister insisted that there was no evidence that there had been any change to the disability tax credit. During that same meeting, type 1 diabetics produced the evidence. They showed her documents that proved that the eligibility criteria had changed. This minister's treatment of diabetics has been terrible. Will she finally quit fighting type 1 diabetics and apologize for her appalling conduct?
Parliamentary Secretary.
Mr. Speaker, again, let me be absolutely clear. The law and the eligibility criteria for disability tax credit has not changed. We will continue to improve the accessibility of this credit to Canadians, and we have already taken extremely important actions. We have simplified the application form. We have allowed more nurse practitioners to certify these patients' applications. And with the restatement of the Disability Advisory Committee, we are bringing stakeholders back at the table to better determine how we can improve access even more. Thank you, Mr. Speaker.
L'honorable député de Saint-Hyacinthe.
The Honourable Member for Saint-Hyacinthe-Fagot. Mr. Speaker, Le Courrier de Saint-Hyacinthe, which has been published since 1853, is the oldest French-language newspaper in the Americas. It is a member of the Coalition for the Survival of the Printed Press in Quebec. These are pillars of our democracy. Local media in our ridings are now having to deal with a significant drop in their advertising revenue, and this to digital giants. When will this government support the print press as it has done with other industries? The Honourable Parliamentary Secretary. Mr. Speaker, we know that newspaper content, reliable newspaper content, is necessary for a healthy democracy. Canadians appreciate local media, and we intend to continue to support them. We have already announced that we will modernize things in order to help the print press in both digital format and paper.
2 weeks ago, we learned that more than 30 local and community newspapers throughout Ontario will shut down. These newspapers employ 291 people who will all lose their jobs. Some of these local papers have been publishing since the 1800s. People of Essex are lucky to still have their community news. But if the attitude of this heritage minister, who says the Liberals won't bail out local media, doesn't change, all MPs will have local newspapers in their communities shut down. How can the minister continue to sit back and do nothing when Canadians are losing jobs and their news sources?
Parliamentary Secretary.
Mr. Speaker, our thoughts are with the workers and their families affected by the cuts in the print media industry. Canadians value local news, and our government will continue to support it. We know that reliable journalistic content is critical to a healthy democracy. We've already announced that we will be modernizing our programs to better support local media in both paper and digital formats. Our approach will be to support innovation, adaptation, and transition to the digital era. This is something that our government takes very seriously.
The Honourable Member for Brossard-Saint-Lambert. Mr. Speaker, yesterday we talked about the anniversary of the signature of the Declaration of Human Rights. Our first program on housing is a demonstration of the government's progressive attitude towards creating appropriate housing. We know what this means for every Canadian. The Honourable Minister. Thank you, Mr. Speaker, and I'd like to start by congratulating my colleague for her extraordinary work on behalf of her citizens. The right to housing is an essential right which should be guaranteed to all Canadians, and this is the first housing strategy which should help to cut 50% of homelessness in Canada because many Canadians cannot find affordable housing. Mr. Speaker, Canadians are happy that we're back with a housing policy to help them.
Thornhill.
Mr. Speaker, the clock continues to tick on three important investigations by the Ethics Commissioner. Two of the Prime Minister's conflict of interest holiday violations, and of course the most recent of several involving the Finance Minister. But as Canadians wait patiently for the Commissioner to report, her spokesperson says If those reports aren't completed before she leaves office in coming weeks, it will be up to her unnamed successor to continue, restart, or abandon those investigations. Mr. Speaker, will the Prime Minister commit to appointing someone who will continue these important investigations?
Government House Leader.
Mr. Speaker, our government values the work of the Conflict of Interest and Ethics Commissioner, and we have put in place a new appointment process which supports an open, transparent, and merit-based selection that is open to all Canadians to apply. We have confidence in this process, and it is from this process that a nominee will be named. This selection process requires a comprehensive approach. We will not undermine the process. The government has a responsibility to put forward a nominee, and we take that responsibility very seriously. We are committed to identifying the most qualified candidate through this process as quickly as possible. Thank you, Mr. Speaker.
Honourable Member for Thornhill.
Well, Mr. Speaker, delay is the deadliest form of denial. And Canadians can clearly see by the Liberals' unacceptable delay in appointing a new ethics commissioner, by the PM's flippant disregard of the ethics laws and regulations fundamental to this House, that ethical practices are discretional for Liberals. But, Mr. Speaker, Canadians deserve rulings on the ethical lapses of the PM and his finance minister. Will he commit to appointing a new ethics commissioner who will continue these important investigations?
Government House Leader.
As I have just responded, we have put in place a new process, an open, transparent, merit-based appointment process in which Canadians are eligible to apply, as all positions are posted online. We look forward to the outcomes of this process and putting forward a name. We look forward to working with opposition parties to ensure that the new nominee can start to work as soon as possible. Thank you, Mr. Speaker.
The Honourable Member for Lévis-Lotbinière. Mr. Speaker, the government's many ethical problems make the appointment of a new ethics commissioner a priority for Canadians. And Canadians need assurance that this is not a partisan appointment. Mr. Speaker, can the Liberals assure us that the next ethics commissioner will continue the current investigations regarding the Prime Minister and the Finance Minister? Mr. Speaker, we appreciate the work of the Ethics Commissioner, and we have put in place a new procedure for appointments, and this is based on openness, transparency, and merit-based. It's open to all Canadians interested in stepping forward to present their candidacy, and we trust in this procedure, and we will be using this procedure to appoint the next person. We'll try to go forward as soon. We're doing as much as we can to find the best qualified candidates. Thank you, Mr. Speaker.
River Northern Rockies.
Thank you, Mr. Speaker. The Ethics Commissioner's term expires on January 8th, and she hasn't finished her investigation into the Prime Minister's holiday to Billionaire Island. She hasn't finished her investigations into the Finance Minister's multiple conflicts of interest either. We have no commitment from this government that she will complete these investigations by January 8th. And we have no guarantee that the new Ethics Commissioner will pick up these investigations where she left off. What assurances can this government give that this ethics investigations into the Prime Minister, and the Finance Minister won't simply be swept under the rug?
The Honourable Government House Leader.
Mr. Speaker, as I have said, that our government values the work of the Conflict of Interest and Ethics Commissioner, and that's something we will always continue to do. I actually encourage members opposite to actually have regard for those offices and the important work they do, and we have an open, transparent, merit-based selection process. We have confidence in that process, and we know that we will be putting forward a name that will work hard for all Canadians. Thank you, Mr. Speaker.
Honourable Member for Hamilton Mountain.
Mr. Speaker, a year ago I wrote to the Finance Minister asking him to use his meeting with the country's finance ministers to fix his flawed CPP enhancement legislation and restore the dropout provisions for child rearing and those living with disabilities. Despite promising to bring it up as a priority with his counterparts, we have not heard of any results to date. Is this another item to the list of hollow promises from this government? Simple question. Will the Finance Minister use today's meeting to do the right thing and finally fix the problem which will affect 14 million Canadians?
The Honourable Minister. Thank you, Mr. Speaker. I'm proud to be part of a government which has as a priority the well-being of our seniors, not only today, but with upcoming generations, the Minister of Finance, working in partnership with provinces and territories, put in place in 2016 a historical agreement to improve Canada's CPP to make sure that 25% of Canadians have financial security in the future. We're working hard with our partners to make sure that these improvements help as many Canadians as possible. The Honourable Member for Jonquière. Mr. Speaker, the fact that the dropout provisions are not among the changes in the CPP, this will affect 14 million Canadians, especially women and disabled persons. The NDP has been putting this question forward for more than a year, but the Liberals have still done nothing, and yet they've had the time to correct this important omission. Will the minister roll up his sleeves for women and disabled persons and raise this question at the next minister's meeting? Thank you, Mr. Speaker. I'm delighted to be part of a government which has cut senior poverty by many people, by increasing the GIS and putting the age at 77. We're trying to get seniors out of poverty, and our government this very day is working with provinces and territories to make sure the CPP is more flexible, is more generous for generations to come.
Yesterday was Human Rights Day. Female genital mutilation is a human rights violation. Even though FGM is a crime in many countries, the practice continues because it's allowed to be shrouded in silence, and victims can face stigma or much worse if they come forward. This is why Plan International charges us with raising awareness of the problem. With reports of FGM practitioners entering Canada, will the minister reverse his decision to remove listing FGM as an intolerable practice from Canada's Citizenship Guide?
Honourable Minister of Immigration.
Mr. Speaker, the assertion by the member opposite is completely inaccurate. To be clear, the content of the new guide has not been finalized. We're engaging, unlike the previous government, we're engaging with a range of stakeholders and subject matter experts to make sure that the new guide better captures the contributions of women, the role of Indigenous people, and members of the LGBTQ2 communities and Francophone communities. I'll remind the member opposite that it was her party that actually removed any references to the LGBTQ2 community rights, including anti-discrimination laws, from the Citizenship Guide.
Honourable Member for Calgary Nose Hill.
The government that first included LGBTQ rights in Canada's Citizenship Guide. Mr. Speaker, a leaked copy of Canada's new Citizenship Guide removed references to female genital mutilation. I do not understand why this minister can't just condemn this process. It's ridiculous. Mr. Speaker, will the minister finally commit to reversing his decision to remove listing FGM as an intolerable practice from Canada's Citizenship Guide? This is a no-brainer.
Honourable Minister of Immigration.
Mr. Speaker, the assertion by the member opposite that we have removed anything from a final Citizenship Guide is completely inaccurate. Just to be clear, the content for the new guide has not been finalized. Unlike the party opposite, we actually listened to stakeholders, we listened to experts, and I want to remind the member opposite that it was her party that removed any references to LGBTQ2 rights, including anti-discrimination laws, from the Citizenship Guide. We will ensure that the new Citizenship Guide reflects all Canadians and not just a few.
It's getting much too noisy. Members have to remember that each side has their turn. And we can have confidence, I think, in the public to assess the questions and the answers. The honourable member for Leeds, Grenville, Thousand Islands and Rideau Lakes.
Mr. Speaker, 6 months ago, the Health Committee reported to the Minister that Canada's thalidomide program needs to be revamped to include the forgotten survivors beyond the 25 that the government continues to reference. It's almost Christmas again, and these survivors are still suffering pain, discrimination, and humiliation. When will the minister show some compassion, do the right thing, and include the forgotten survivors in the compensation program?
Parliamentary Secretary to the Minister of Health.
Mr. Speaker, our hearts go out to thalidomide survivors, and we remain deeply committed to offering the support that they need to live the rest of their lives with dignity and with respect. The Thalidomide Survivors Contribution Program is helping support 122 Canadian thalidomide survivors, 25 of whom were identified using the objective review process that was put in place to assess the eligibility of unconfirmed individuals. Mr. Speaker, we wish to acknowledge and thank the Health Committee for its important work on this matter. We are reviewing their important report and we will be responding in very due course.
Honourable Member for Humber River Black Creek.
Mr. Speaker, our government believes that the benefits of free trade should result in opportunities for all Canadians. Could the Minister of Finance update this House on what our government is doing to deliver on its commitment to allow for participation of unions in Canadian trade remedy proceedings?
Honourable Parliamentary Secretary.
Mr. Speaker, I want to thank the member for Humber River Black Creek. Our trade agenda puts people at the center of what we do. In Budget 2017, we announced regulatory amendments to ensure that unions have the right to participate in trade remedy proceedings. New regulations will come into force early in 2018 and will require relevant unions to be identified in dumping and subsidy complaints and to explicitly identify trade unions as interested parties in various trade remedy proceedings. Canadian workers deserve to have a voice in these proceedings, and we are taking action to ensure that they are heard. Thank you, Mr. Speaker.
The Honourable Member for Foothills.
Mr. Speaker, with Canada's $4 billion pulse industry in jeopardy, a Liberal trade mission to India, which did not include the Minister of Agriculture, came back empty-handed. Grain companies have stopped buying peas because of 50% duty. Pulse producers have lost $360 million, and they are facing some very difficult decisions as they prepare for next season. The Liberals bet Canada's farm when they went all in on China, and they lost. And now critical trade agreements, along with alternative market access, are in serious jeopardy. When is the Agriculture Minister going to start doing his job and start fighting to secure vital market access for Canada's pulse producers?
Honourable Minister of Agriculture.
We are extremely concerned and disappointed with India's increase in import duties of 50% on all peas without providing any advance notification. We are raising our concerns with the Government of India, including the recent trade mission led by the Minister of Trade, who raised this issue at every opportunity. And we will continue to work with our farmers to make sure that they get every opportunity possible. Thank you, Mr. Speaker.
The Honourable Member for Courtenay Alberni.
Mr. Speaker, the Newchannel people are eager to reconcile, but the Liberals keep fighting them in court. Newchannel fishers have waited since 2009 to exercise their right to catch and sell fish in their own territories. The courts, right up to the Supreme Court of Canada, have confirmed their right to do so, yet this government still does not honour their rights. The Liberals claim their most important relationship is with Indigenous people, so when will they prove they are serious about reconciliation? End this costly prosecution of the Newchannel people, and finally recognize their fishing rights.
The Honourable Parliamentary Secretary to the Minister of Immigration.
Thank you, Mr. Speaker. And this is a renewed relationship from nation to nation, and this has to do with partnership, with respect for Indigenous peoples. We will be cooperating with the 5 nations in this area in order to ensure stability and operational stability in this area. Mr. Speaker, given that this is before the Superior Court of British Columbia, it would not be appropriate to comment at this time.
East.
Mr. Speaker, Canada 150 has been a rousing success, and no more so than in St. John's East, where we celebrated Canada Day for the 69th time with cultural events that brought us together as Canadians. Alors que Canada 150.
As Canada 150 winds down, a Pee Wee hockey team from my riding is very excited about being able to participate in the final celebrations on Parliament Hill. Can the Parliamentary Secretary to the Minister of Canadian Heritage talk to us about the successes of Canada 150? The Honourable Parliamentary Secretary. Thank you, Mr. Speaker. And I'd like to thank the Honourable Member for his question and for his excellent work. Last week, for the first time, we opened our temporary rink on Parliament Hill.
The hockey teams from coast to coast to coast will be here to compete in the Hockey on the Hill tournament This will be a once-in-a-lifetime opportunity for these young players. We look forward to welcoming all Canadians as we close out the Canada 150 celebrations. Merci, Monsieur le Président.
The Honourable Member for Bellechasse-les-Citermont-Lévis. Mr. Speaker, with the decommissioning of the preserver and protector, there is a serious operating gap. This vulnerability has been recognized by a Liberal majority Defence Committee. The Astérix was brought in on time by Davy Shipwards. Now, the government has no excuse for not honouring its commitments and not obtaining this second boat, the Obélix.
With Canada's new defence policy, we're committed to making sure that we modernize our Canadian Navy. And as part of the national shipbuilding strategies, two permanent joint supply ships are required for our Navy. However, because of the previous cuts, there was a capability gap that was left. And then because of that, the interim capability gap is going to be filled, and Davie Shipyard has built the Asterix, Mr. Speaker, and we thank you very much for their tremendous work.
L'honorable député de Pierre Boucher, les Patriotes Verchères.
Honourable Member for Pierre Boucher, les Patriotes Verchères. Mr. Speaker, the ears of the the Heritage Minister must be reddening. They are giving privileges to multinationals. The minister heard things, but she's not really listening. Voting Liberal means voting for just people who don't do anything. They're not the fact that they're not taxing these things is not just an attack on our culture, but also on our economy. The Honourable Parliamentary Secretary. Mr. Speaker, our government has always been clear. Our position has not changed. We do hear and are listening to the concerns of the cultural sector, and we are making historic investments in order to support our culture. More than $2.3 billion, which has been invested in the media fund, and this will have concrete repercussions for the lives of our artists. The Honourable Member for Joliette. Now, are we to understand that the Liberal government doesn't really want to pay attention to the consensus in Quebec? Mr. Speaker, the Finance Minister says he's flexible for sharing the cannabis tax revenue. Is he ready to share this tax unconditionally based on cost sharing? So 100% for Quebec, the provinces, and the municipalities, and for the federal government, zero. The Honourable Parliamentary Secretary.
Our senior officials have been meeting on this file for over 2 years. We share a consensus in every part of this country that the current system of cannabis control is failing our kids, enriching organized crime, and putting the health of Canadians at risk. We continue to remain committed to a respectful discussion with our provincial, territorial, and municipal partners to ensure that those who have responsibilities have the resources they need to fulfill those responsibilities. Thank you, Mr. Speaker.
Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. All that remains to be done now is a rubber stamp from the Investment Canada Act for one of Canada's largest construction companies, Aecon, to be sold to a state-owned enterprise of the People's Republic of China, the China Communications Construction Company, or CCCI. This company has a very troubling human rights, environmental, and safety record, and yet it has not come before this House. We're not hearing. I asked the Prime Minister, can he assure this place that this sale will be put to a thorough review before Investment Canada Act rubber stamps it?
Right Honourable Prime Minister.
Mr. Speaker, every proposed investment of this scale is examined on a case-by-case basis to ensure it is in Canada's best interest. This rigorous process is done in consultation with our national security agencies. When it comes to the health and safety of Canadian workers, this is an issue that we take very seriously. We're currently working with provinces and territories to improve occupational health and safety regulations, and we expect all companies operating in Canada to follow all provincial and federal regulations and make sure workers have a safe working environment.
Dépôt de documents, tabling of documents. House Leader.
Mr. Speaker, pursuant to Standing Order 101.11.1, I have the honor to table in both official languages a certificate of nomination and biographical notes for the proposed appointment of Marion Dion to the position of Conflict of Interest and Ethics Commissioner. I request that the nomination be referred to the Standing Committee on Access to Information, Privacy and Ethics. Thank you, Mr. Speaker.
Here we go.
You can see it now.
Order. I encourage members to take their conversations into the lobbies, and I'd ask members to assist me by saying shh. Thank colleagues for their assistance. Tabling of documents, the Honourable Parliamentary Secretary to the Minister of Crown Indigenous Relations.
Reports to table. First of all, under the provisions of Standing Order 32.2, I have the honour to table in both official languages copies of the West Bank First Nation Self-Government Agreement, the annual report on implementation for 2013 and 14, and I request that this report be referred to the Standing Committee on Indigenous and Northern Affairs. Further to that, Mr. Speaker, under the provisions of Standing Order 32.2, I have the honour to table in both official languages copies of the NISHKA's Final Agreement Implementation Report for 2013 and 14, and I request that this report be referred to the Standing Committee on Indigenous and Northern Affairs. And further to that, Mr. Speaker, under the provisions of Standing Order 32.2, I have the honour to table in both official languages copies of the combined annual reports for 2010, 2011, and 2011 and 2012, the James Bay and Northern Quebec Agreement and Northeastern Quebec Agreement. And I request again that this report be referred to the Standing Committee on Indigenous and Northern Affairs. Thank you.
Mr. Speaker, pursuant to Standing Order 36(8), I have the honour to table in both official languages the government's response to 43 petitions.
Dépôt de projet de loi.
Introduction of government bills.
Est-ce que l'honorable député?
Does the honourable member of for Miramichi Grand Lake have a document to table?
Oh, je pense que ça vient plus tard avec les...
No, that's later with the committee reports. Thank you. Introduction of government bills.
Déclaration.
Statements by ministers. Reports from interparliamentary delegations. The honourable member for Sackville, Preston, Chesapeake. Yep, you have to say it 10 times to memorize it, Mr. Speaker. Mr. Speaker, pursuant to Standing Order 34.1, I have the honour to table in this House of Commons, in both official languages, the report of the Canadian branch of the Assemblée parlementaire de la Francophonie, respecting its participation at the meeting of the Parliamentary Affairs Committee of the Assemblée parlementaire de la Francophonie, held in Ho Chi Minh City, Vietnam, from March 24th to 26, 2017.
Presenting reports from committees, the Honourable Member for Coast of Bay, Central Notre Dame.
Mr. Speaker, I have the honour to present in both official languages the 12th report of the Standing Committee on Fisheries and Oceans in relation to Bill C-55, an act to amend the Oceans Act and the Canada Petroleum Resources Act. The committee has studied the bill and has decided to report the bill back to the House with amendments. Thank you.
Honourable member for Humber River Black Creek.
Thank you, Mr. Speaker. I also have the honour to present in both official languages the 20th report of the Standing Committee on Transport, Infrastructure and Communities, entitled An Interim Report on Infrastructure and Smart Cities. And I also have a second one. You can see the committee's been very busy. I'm pleased to be able to present the 21st report of the Standing Committee on Transport, Infrastructure and Communities, entitled Lead in Drinking Water. Thank you very much, Mr. Speaker.
The honourable member for Kelowna Lake Country.
Speaker, I have the honour to present in both official languages the 8th report of the Standing Committee of National Defence entitled Canada's Support to Ukraine in Crisis and Armed Conflict. Mr. Speaker, Canada proudly stands with the Ukraine.
The honourable member for Miramichi Grand Lake.
Mr. Speaker, I have the honour to table in both official languages the 10th report from the Standing Committee on Agriculture and Agri-Food, entitled A Food Policy for Canada. Pursuant to the Standing Order 109, the committee calls upon the government to table a global response to this report.
Private members' bills. First reading of Senate public bills. Motions. Presenting petitions. Présentation de pétitions. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. I'm presenting a petition today on a subject that I've received many passionate representations on in my office. It's a difficult subject. It's on custody arrangements after divorce. The people bringing forward this petition are concerned that the current system, as it relates to this issue, often leads to embittered litigation, to primary and secondary custody relationships where one parent may have limited access to their children, and an overburdened legal system. The petitioners are asking the House to look at alternatives and to try and do better. In particular, they're calling upon the House of Commons to introduce a presumption of equal shared parenting in the event of parental separation or divorce, only exempting cases in which a parent is demonstrably unfit or where a compelling case can be made proving that equal shared parenting would not be in the best interest of the child. I commend this petition and the issue in general to the detailed consideration of my colleagues. Thank you.
Honourable member for Etobicoke Centre.
Mr. Speaker, pursuant to Standing Order 36, I'm presenting a petition signed by 60 constituents in my riding of Etobicoke Centre. The petitioners are deeply concerned with the ongoing persecution of Falun Gong practitioners in China, a persecution that has as its goal the eradication of Falun Gong, a spiritual practice based upon the core principles of truthfulness, compassion, and tolerance. The petitioners urge legislative efforts in Canada that would help put a stop to the persecution and murder of Falun Gong practitioners and that would investigate allegations of illegal organ harvesting of innocent people in China. Thank you.
Honourable member from Nanaimo, Ladysmith.
Protect the coast and the jobs and ecology dependent on it. Petitioners from Gabriola, Nanaimo, Langley, Port Alberni, Vancouver all urge the Minister of Transport to cancel the proposal for establishment of 5 new bulk anchorages off Gabriola Island. These are each 300-meter freighters. The risk of oil spill, the damage from scouring from the anchor chain is untenable, unnecessary, of no benefit to our community, all downside, no upside. I urge the Minister of Transportation to hear their cry. Thank you.
Member for Cypress Hills Grasslands.
Speaker, and I present a petition on behalf of 7,456 residents of Canada. Call upon the Government of Canada and the United Nations to ensure that Christians and other minorities living in Iraq and Syria enjoy a citizenship with equal rights, that they are provided with dignified living conditions, that Christians are given a prominent role in reconciling and rebuilding society. They call on the Government of Canada and the United Nations to do 3 things: ensure that the current and future legal frameworks in Syria and Iraq fully promote and protect the equal and inalienable rights of their citizens, irrespective of race or religion. They safeguard the dignified and continued improvement of living conditions for all citizens, but especially for returning refugees and the internally displaced, including through provision of adequate housing, education, and jobs, and that they identify and equip religious leaders and faith-based organizations to play a constructive and central role in reconciling and rebuilding both Syria and Iraqi societies. And Mr. Speaker, I have a second petition on behalf of some folks in my riding and just outside who call who will say, whereas equality means that all people are treated fairly without discrimination, and whereas individuals holding Christian beliefs in Canada are experiencing discrimination and that some laws are contrary to the practice of their religious or conscience beliefs. Therefore, we call on the House of Commons to exercise their religious beliefs and conscience rights both in their private and public acts without coercion, constraint, or discrimination. I call on the government to amend Section 241 of the Criminal Code, the Medical Assistance in Dying, and the Civil Marriage Act to provide Christians and their faith-based institutions protection from its provisions. And secondly, that the government enact a policy to provide a review of any new legislation as may be brought in future by the government to ensure it does not impinge upon the religious rights of Christians in accordance with the historic continuity of the Canadian Bill of Rights and the Canadian Charter of Rights and Freedoms.
The honourable member for Sydney Victoria.
Speaker, and I have a petition here from hundreds of constituents from my riding, and the petition is to change the Canadian EI system for cancer patients. What they want to see is a change from the EI system, which is right now 15 weeks. They want to see it to be 40 to 50 weeks, because most patients need at least a week. They most need at least a year off to recuperate. Many people with heart and stroke or cancer, they need that year. They're very productive citizens. Many of them never drew EI in their lives. And for us to help them to get back on their feet, they become productive citizens and back into society. So it's a very good petition, and they got all the signatures here within good form. Thank you.
L'honorable député.
Honourable member.
Mr. Speaker, and I have two petitions, both the same, from citizens who are very concerned about the fact that the Conservative government stripped environmental regulations covered in the Navigable Waters Act, leaving many hundreds of rivers vulnerable. As you know, Mr. Speaker, the ecological diversity of the North Thames, Middle Thames, and Thames River are at risk as a result. And they wish the Liberal government to take up its promise to reinstate the environmental protections gutted from the original Act and support my bill, C-355, which commits government to prioritizing the protection of the Thames River by amending the Navigational Protection Act.
And now with perhaps the most seasonal outfit of the day, and certainly when it looks very good, the honourable member for Winnipeg Centre.
Well, Merry Christmas to you as well, Mr. Speaker. Thank you very much. Whereas 130 million girls are currently out of school around the world, almost 4 times the population of Canada, it is a tragic waste of human potential. The petitioners call upon the House of Commons to fulfill Canada's responsibilities established by the International Education Commission to ensure that girls everywhere have access to a quality education. And specifically, they ask that Canada increase their funding for global education from its current $302 million to $592 million by 2020, an increase of 2 pennies per Canadian per day. And there are 2 petitions which are of a similar nature. Thank you very much, Mr. Speaker, and Merry Christmas.
The Honourable Member for Jonquière. Thank you, Mr. Speaker. It gives me great pleasure to rise again in this House and table a petition to end the theft of pensions of workers by businesses. Workers count on their pensions to be able to live and retire with dignity. We are calling on the government to amend bankruptcy legislation that currently allows businesses to take the money from pensions to pay CEOs, banks, and investors instead of workers.
Algoma, Manitoulin, Kapuskasing.
The Honourable Member for Algoma, Manitoulin, Kapuskasing.
And I'm pleased to rise once again to table a petition which asks for the implementation of a pan-Canadian strategy for eating disorders. The petitioners indicate that those who suffer from eating disorders such as anorexia and bulimia have the highest rate of mental illnesses. They add that more than 1 million Canadian sufferers and their families are negatively affected physically, emotionally, and financially by their struggles. And, Mr. Speaker, given that the holiday season is upon us, this time of year is often more difficult for those who suffer from anorexia and bulimia and their families. They ask the government to work with provinces and territories and those affected to develop a comprehensive pan-Canadian strategy. Thank you very much, Mr. Speaker.
Honourable Member for Winnipeg North.
Yes, thank you, Mr. Speaker. I have many constituents of mine who have signed a petition calling on the Government of Canada to take action and encourage palliative care, quality health care, and they recognize that no one level of government has the sole responsibility to ensuring that Canadians have good quality health care systems, in particular special focus on this petition with respect to palliative care. Thank you, Mr. Speaker.
Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I rise today to present yet more petitions calling for the People's Republic of China to cease the assault and the persecution and discrimination against practitioners of Falun Dafa and Falun Gong, calling for the Canadian government to make this clear to the People's Republic of China and publicly call for an end to the persecution of Falun Gong practitioners. Thank you, Mr. Speaker.
Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. The following questions will be answered today. Question 1270, question 1272, question 1277, question 1279, question 1282, question 1285, and question 1289. Furthermore, Mr. Speaker, if the government's responses to questions question 1267 to question 1269, question 1271, question 1273 to question 1276, question 1280, question 1281, question 1283, question 1284, question 1286 to question 1288, and question 1290 could be made for orders for return. These returns would be tabled immediately.
It is the pleasure of the House that the aforementioned questions be made order for return, that they be tabled immediately. Agreed, and so ordered. The Honourable Parliamentary Secretary.
Yes, thank you, Mr. Speaker. I would ask then that all questions be allowed to stand at this time, please.
Agreed. Agreed, and so ordered. I have notice from the Honourable Member for Calgary Rocky Ridge that he wishes to add to arguments in relation to a question privilege that he raised, last week. The Honourable Member for Calgary Rocky Ridge.
Thank you, Mr. Speaker. I rise today to provide additional information to support my question of privilege on Tuesday, December 5th, 2017, regarding the Minister of National Revenue deliberately misleading the House. In my submission to you, Mr. Speaker, I demonstrated on several occasions that the Minister of National Revenue tried to convince the House that no changes had been made to the eligibility criteria for the disability tax credit, as well as the way it is interpreted. I then provided an internal memo from the Minister's own officials, her procedures and medical review team, that the Department of National Revenue were applying a new and different interpretation to the eligibility criteria for the disability tax credit. I now have evidence that the Minister's Parliamentary Secretary has also confirmed that the Minister's statements were false. On Friday, the Parliamentary Secretary to the Minister of National Revenue was interviewed on CBC News. During that interview, she was asked about the fact that the Canada Revenue Agency was applying different criteria, and because of the fallout from that, the agency had decided to pull back on applying this new interpretation. She was asked if the government needs to say sorry for what people had gone through because of these changes. The Parliamentary Secretary said, quote, of course, we do apologize for that, unquote. The reporter pressed her again, stating, quote, so I want to be crystal clear. You said that when there's an apology due, we offer one, but you say in this instant that you do apologize? Her reply again, Mr. Speaker, quote, of course, unquote. The body of evidence is overwhelming, Mr. Speaker. This House can only conclude that, of course, the Minister of National Revenue deliberately misled this House. On Wednesday, December 6th, the Parliamentary Secretary to the Government House Leader tried to defend the Minister and referenced page 86 of O'Brien and Bosk's House of Commons Procedure and Practice, second edition. The Parliamentary Secretary said, quote, the following three elements have to be established when it's alleged that a member is in contempt or is deliberately misleading the House. One, it must be proven that the statement was misleading. Two, it must be established that the member making the statement knew at the time that the statement was incorrect, and 3, that in making the statement, the member intended to mislead the House. These criteria have not been met in the situation at hand, unquote. Well, I disagree with the member, Mr. Speaker. To address the member's first element, I have clearly demonstrated that this minister's statements were misleading. To his second point, her own department officials and now her parliamentary secretary have revealed that the minister's statements were false. It's just not credible, Mr. Speaker, for everyone else involved with the interpretation of the criteria, everyone else involved in the interpretation of the criteria acknowledges the false statements except for the person in charge. To the member's last point, and I covered this off in my question of privilege last Tuesday, the minister made these claims time and time again during question period on many occasions, and anyone who has listened to her statements could not come to the conclusion that they were not deliberate. Clearly, her mission was to convince the House that no changes had been made to the eligibility criteria for the disability tax credit as well as the way it is interpreted. I'm certain that any Canadian following this story would be confused about the conflicting information available on this matter and would have some level of concern that this minister deliberately misled this House. With that, Mr. Speaker, I leave you with a ruling from October 21st, 1978, where Speaker Jerome quoted a British Procedure Committee report of 1967, which states in part, quote, the Speaker should ask himself when he has to decide whether to grant precedence over other public business to a motion which a member who has complained of some act or conduct as constituting a breach of privilege desires to move, should not be, do I consider that, assuming the facts are as stated, the act or conduct constitutes a breach of privilege, but could it reasonably be held to be a breach of privilege? Or to put it shortly, that the member has an arguable point. If the Speaker feels any doubt about the question, he should, in my view, leave it to the House, unquote. Thank you, Mr. Speaker.
I thank the honourable member for Calgary Rocky Ridge for these additional arguments that I will consider, along with the other arguments that he previously made and that others in the House have made on this issue. Oh, and I see the honourable parliamentary secretary to the government House Leader wishes to add something.
Yes, Mr. Speaker, just listening to my colleague across the way, I believe that there's some new information that has been brought to the House. I, on behalf of the government, would like to take a look in terms of what it is that the member has put on the record, and we will come back to you in due course, Mr. Speaker, to provide further information.
I thank the honourable parliamentary secretary, and I would ask him or the government to return with alacrity with their argument, if they have additional argument on that, or to let the table know if that's not going to happen. Orders of the day.
Government orders, government bills, commons, resuming debate at third reading stage of Bill C-51, an act to amend the Criminal Code and the Department of Justice Act and to make consequential amendments to another act.
Resuming debate, the honourable member for St. Albert Edmonton has 9 minutes remaining in his speech.
Thank you, Mr. Speaker. I wish to continue my speech on Bill C-51. As I alluded to before question period, the most substantive part of Bill C-51 deals with amendments to the criminal code related to Canada's sexual assault laws. I support many of the amendments to the criminal code brought forward in Bill C-51, including those amendments that clean up the criminal code by codifying law determined by the Supreme Court of Canada, including in the J.A. and Iwanchuk decisions. That being said, there is one area of Bill C-51 in terms of changes to sexual assault laws that cause me some concern. And that area of concern relates to the defense disclosure requirements. Bill C-51 would require that in order for the defense to tender evidence in terms of records that relate to the complainant, that they would have to bring an application to the court. In other words, records that relate to the complainant would be deemed inadmissible unless the court determined otherwise. Such an application would have to be brought prior to the trial. Moreover, the complainant would have the right to counsel and would be a party to that application. There are a number of concerns that I have with that. First of all, Mr. Speaker, the definition of records is very, very broad. The type of records, the scope of records that would be captured, again, is just about any record related to the complainant. That would include, Mr. Speaker, potentially joint records, records that both the accused and the complainant otherwise have a right to access. It would include potentially records that are subject to Crown disclosure, that are in the control of the Crown. It could include, Mr. Speaker, records that were ordered subject to a third-party application. And so, Mr. Speaker, when we're talking about the breadth of records that would be captured, we could be talking about, in some trials, thousands and thousands of records that would be subject to such an application. Now, Mr. Speaker, what that will do is result potentially in delay. And I have to say, in addition to the potential for delay, the timing of the application is of some concern. The application would have to be brought prior to a trial. Now, what is the problem with that? Well, one problem is that there are often issues that arise in trials that are not necessarily foreseeable prior to the trial. And so, from a practical standpoint, what that will mean is that there could be records that do not appear to be relevant prior to the trial that become very relevant as a result of an issue that arises in the course of the trial. So what that will mean, Mr. Speaker, inevitably, is that there will be, of course, applications brought prior to the trial, but in those instances where records become relevant that were not necessarily obvious or apparent prior to the trial, it will result in the need for mid-trial applications. That will mean the adjournment of trials and a delay in the administration of justice. And, Mr. Speaker, that is particularly concerning in light of the Jordan decision. In Jordan, the Supreme Court determined that delay is presumptively unreasonable where 18 months pass between the laying of charges and a trial for matters before a provincial court and 30 months in the case of matters before superior courts. Over the last while since Jordan was rendered, we have seen dozens and dozens and dozens of serious criminal cases thrown out of court, cases involving everything from murder to sexual assault to other violent offenses. In addition to that, Mr. Speaker, we have seen hundreds, if not thousands, of perfectly prosecutable cases, or cases that would otherwise, but for Jordan, be perfectly prosecutable, dropped as a result of delay. And so the prospect of adding further delay to a system that is stretched to the limit is problematic. What it is going to mean, potentially, Mr. Speaker, is that more sexual assault cases are going to be thrown out than otherwise, based upon Jordan at present. And I say that that is less than comforting to victims of sexual assault. It's less than comforting, it's frankly unacceptable, Mr. Speaker, that we could be opening that possibility. And it certainly runs counter to the purported objectives of Jordan, which include, of course, ensuring that victims see justice. Then, Mr. Speaker, I believe that there have been some legitimate questions that have been raised about the appropriateness of a complainant to be a party to such an application with the right of counsel. Very often in sexual assault cases, the outcome of the case rests on the credibility of the complainant. And the fact is that most complainants are truthful, but not all complainants are truthful. In some exceptional circumstances, complainants are not truthful. And the effect of this means that a complainant will gain insight into the defense's case and potential lines of cross-examination. This, in turn, Mr. Speaker, could undermine trial fairness in a significant way. Okay. And I say, Mr. Speaker, in closing, that I would like to quote the recent caution of Ontario Superior Court Justice Malloy in Niznik at paragraph 17, where he stated, quote, "Although the slogan, 'Believe the victim,' has become popularized of late, it has no place in a criminal trial. To approach a trial with the assumption that the complainant is telling the truth is the equivalent of imposing a presumption of guilt on the person accused of sexual assault and then placing a burden on him to prove his innocence," unquote. I think that pronouncement of Justice Malloy is something that we, as members of Parliament, need to be mindful of as we try to strike the right balance between ensuring that victims of sexual assault are protected and that their dignity and privacy is upheld with the right of the accused to make full answer and defense. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Whitby.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for his comments. And Mr. Speaker, I think we could all agree on the merit of this bill, and so I do appreciate his insightfulness when it comes to talking about the legalities here. But I was somewhat disappointed that the member, in the opening of his speech, would take this opportunity to attack our government and be partisan, particularly on this very sensitive and important bill as it relates to consent and victims' rights. We have heard members on this debate on both sides of the House talk about how this bill would give women confidence to come forward, and we've demonstrated our capacity to really work together in this House. We unanimously passed a motion put forward by the interim opposition leader. So I wonder what the member would say to women in his riding about the benefits of this particular bill as it pertains to them specifically.
The honourable member for St. Albert, Edmonton.
Mr. Speaker, there are a number of good components to this bill related to changes to sexual assault laws, including codifying the Wanchuk decision to make it absolutely clear with respect to mistaken belief that the defense of mistaken belief based upon mistake of law cannot be put forward, Mr. Speaker. The bill also is positive in that it codifies the JA decision to make clear that under no circumstances can a complainant be found to have given their consent on the basis of when they're in an unconscious state, Mr. Speaker. So these and other changes are positive aspects of the bill. But that being said, I do have serious concerns about the defense disclosure requirements. These are very real concerns. They are substantive concerns. They raise charter issues, and they go to the heart of trial fairness, Mr. Speaker. At the end of the day, it is fundamental that complainants are protected in our system, but it is also fundamental to our justice system that accused persons have the right to make full answer and defense. That is fundamental to getting to the heart of the truth in a particular case and to guard against wrongful convictions.
Questions and comments? The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. I wonder if the member can speak a little bit to the Section 176 that this bill had initially proposed to remove, and it now seems that that there's a willingness on the part of the government to back away from this. But this wasn't a concession that came easily. Obviously, the member will know that he and other members of our official opposition worked very hard. There were many Canadians who became active and mobilized across faith communities to show the government that it doesn't make much sense to, on the one hand, talk about a rising climate of hate and fear, to, on the one hand, talk about risks that faith communities might face, but on the other hand, to propose to remove the one section of the criminal code that actually specifically provides protection for the practice of faith in Canada.
The honourable member for St. Albert, Edmonton.
I thank my friend and colleague, the member for Sherwood Park, Fort Saskatchewan, for that important question, and I want to acknowledge the work that he did as being one of the first members to flag that Section 176 was sought to be removed by the government in its initial draft of Bill C-51. And he is quite right that it took a lot of pressure for the government to come around and do the common sense thing and the right thing about a section of the criminal code that is not unconstitutional, that isn't redundant, and that has been used regularly. Not regularly, but certainly in several cases, including most recently involving an Ottawa woman who vandalized a religious statue. And he is quite right when he speaks about a climate of fear and a climate of hate in which persons have, and churches and synagogues and mosques have been targeted by people who are hateful. And we have seen that recently with a number of acts of vandalism at Ottawa area synagogues and mosques. We have seen many instances of this. And so not only was it substantively the wrong thing to do, the timing couldn't have been worse, and it is really inconsistent with the government's purported commitment to ensuring that measures are taken to deal with and address serious issues around hate being perpetrated and individuals being targeted on the basis of their religion or other characteristics.
And comments? Questions et commentaires? The honourable member for Central Nova.
Thank you, Mr. Speaker, and I enjoyed the very legalistic approach to my honourable colleague's remarks, and I come from a similar professional background and a similar vintage as the honourable member. But one of the things that I've been able to do, has been a complete privilege of mine since I arrived in this place, is to serve on the Status of Women Committee. And when we did a study on ending violence against women, particularly against young women and girls, some of the testimony that we heard was about the dramatic underreporting of sexual assault in Canada and how ill-equipped our legal system is to deal with those who do muster the courage to come forward. I view this bill to be a positive step that will not only encourage more young women who've been victimized and have survived sexual violence to report, but potentially leading to more convictions where that sexual assault is reported. Does my honourable colleague agree or disagree that it will lead to more convictions in circumstances where a sexual assault has been committed?
The honourable member for St. Albert, Edmonton.
Mr. Speaker, I believe that certain parts of Bill C-51 help clarify the law around sexual assault. One example of that is in the area of evidence that is tendered with respect to the twin myths, Mr. Speaker. This bill makes it clear that that evidence cannot be tendered under any circumstances, and that is good because there has been some confusion in the case law with respect to Section 276 sub 1 and then another subsection 276 sub 2 and subsection 3 that has resulted in some cases, trial judges basically having a balancing test. This bill would eliminate that to make clear that if evidence is being tendered to on the basis that a complainant, as a result of her sexual history, is less believable or more likely to consent, but under no circumstances can that evidence be tendered. So that is a positive step. But the problem with this bill is that it is an omnibus bill. It relates to matters that are unrelated to one another. And so there are parts of this bill that are very positive, but there are other sections that are frankly very problematic, including with respect to the defense disclosure requirements.
Questions and comments? The honourable member for Winnipeg North. We have 2 minutes left, so a minute for the question, a minute for the answer, and I think that should be great.
Thank you, Mr. Speaker. I'd like to pick up on my colleague from across the way's comments when he makes reference to omnibus bill. What we have before us is a number of changes, and those changes come in good part as a result of courts' decisions and reviews that have been done of the Criminal Act. And when you take a holistic approach at making some of these changes, that would it not be best to incorporate it into one bill, referencing the importance of having those changes take effect? Some of those changes, as I say, are completely mundane and necessary. They're just, who duels nowadays, as an example, being repealed, and his comments with respect to that.
The honourable member for St. Albert, Edmonton.
Mr. Speaker, it might have made sense that the government introduced one bill related to changes to sexual assault laws, but this bill does more than that. It would, among other things, require that the Minister of Justice introduce a charter statement with any bill that the minister introduces in this House. It would remove unconstitutional sections of the criminal code, something I fully support. It would remove sections of the criminal code that are redundant, which again I fully support, but again totally unrelated to changes around sexual assault laws. And it would remove sections like Section 49 dealing with protecting Canada's head of state, Her Majesty the Queen. Again, totally unrelated to sexual assault laws. So, Mr. Speaker, this is an omnibus bill, and it is exactly what this government campaigned that they wouldn't do, and here we are debating an omnibus bill.
Resuming debate, reprise du débat. The honourable member for... We have a bit of a conflict here. I see my notes and what I see standing up. Is it okay? The honourable member for Winnipeg North.
Thank you, Mr. Speaker. And I do stand rise to speak on C-51. I think it's an important piece of legislation that the government has brought forward. I don't necessarily agree with my colleague from across the way when he talks about the omnibus nature of legislation. That in fact, we've had a very thorough review that has taken place. This legislation is in fact a reflection, as I made reference to in my question, Mr. Speaker, of court decisions that have been made, along with a review from bureaucrats and others that have been involved in trying to update or modernize our criminal code. I've had the opportunity to see, and it's a fairly wordy book, the Criminal Code, and unless you modernize or make a genuine attempt to make these sorts of changes, sometimes legislation or the law needs to change, Mr. Speaker. And, I can't recall the details right offhand, other than the fact that one of them is getting rid of dueling, Mr. Speaker. This is something that I'm sure you would have to look long and hard to see the last time there was an actual duel of swords here in Canada. There's legislation that just ultimately, because it's never repealed or taken out of the criminal code, it just becomes somewhat dated and therefore necessary for us to take a look at and make the changes. My colleague from across the way made a couple of references that I do want to pick up on. Referring, for example, the charter statement. For years I sat in the opposition benches, and we would look to the government, would be bringing in legislation and quite often one of the questions would be, well, is that charter proof? Like, is there an opinion, a legal opinion, in regards to that legislation that the government is introducing would have a chance going through the court system? Would it in fact meet the charter? On many occasions, I've stood in the House and I've talked about the importance of the charter and different perspectives. Canadians as a whole have really responded over the years, 33 decades plus since we've had the charter, as something that's a part of our Canadian values. And often, when I sat in opposition, you would have a government that would talk a fairly tough line on criminal manners, and wanting to, as much as possible, talk tough. And then at times they would bring in ideas in which they would be questioned, do you have a legal opinion that would in fact have an opportunity to be successful if it went to a Supreme Court? Or, Mr. Speaker, ultimately challenging the government to ensure that legislation should have some vetting that's done to ensure that it would be in compliance as much as possible, if not all of the time, with the Charter of Rights, Mr. Speaker. So what we have, and I like to think of it as a very positive aspect to the legislation that we're debating today, is a charter statement which virtually indicates that government would then be required to get that statement before producing legislation to the House, Mr. Speaker. I see that as a very strong positive, and obviously very supportive of it in terms of being inside the House or inside the legislation. I want to pick up on an issue that has been talked about a lot from the Conservative benches in regards to this, because the Conservatives seem to feel that a change that was made with regards to the repealing of 176, which was originally suggested in the legislation, has been now taken out because of the fine work of the Conservative Party. And that's the impression that they're trying to give. And I think that that's a false impression, Mr. Speaker. I say that because I, too, have had constituents of mine in Winnipeg North and others that have expressed genuine concern about why it is Section 176 is actually being proposed to be repealed from the Criminal Code. And just for those that are following the debate that maybe, like myself, were not a part of the committee discussions, Mr. Speaker, but those that are interested in exactly what it is that members opposite and myself and others have already talked about today, Section 176 was originally going to be repealed. When we looked at second reading, when the bill was introduced to the House, there was a repeal component in it. And that was with respect to Section 176, and it stated currently in law that by threats or force unlawfully obstructs or prevents or endeavors to obstruct or prevent a clergyman or a minister from celebrating divine services or performing any other functions in connection with his calling. Mr. Speaker, the response to that, to the repealing of that particular section of the Criminal Code was something in which many individuals had become to known after first reading, and somewhere between first reading and second reading, it was brought to my attention, and I was really quite glad to see the system works, because I don't believe I was alone. I suspect that there would have been members of Parliament that were approached on this issue on both sides of the House. And from my perspective, I would suggest to you that it demonstrates that the system actually works. After a second reading and the debates that had occurred there, the bill goes into committee. We've had members recognize on all sides of the House just to the degree in which, whether it was through the committee chair and the committee membership, of that high sense of cooperation and understanding of the things that needed to be done. There was presenters that came forward and recommended, in essence, what it is that many of us were hearing in our constituencies back home. So I was not surprised that we saw an amendment to allow for Section 176 to remain. In fact, Mr. Speaker, I believe it was actually improved upon in the Criminal Code, where, and if I get right to that aspect of it, the Standing Committee actually addressed the concerns to repeal 176 and amended it out. But they also added more strength to it, Mr. Speaker, by expanding it so that it went beyond just ministers to incorporate spiritual leaders and so forth, Mr. Speaker. And I thought that was a positive a change that was brought forward. So had it not even been in the appeal, in the original piece of legislation, that aspect of it would not have been changed. Therefore, we actually have a stronger criminal act, or a stronger Section 176, I would ultimately argue. But I wanted to emphasize that aspect or that particular clause, Mr. Speaker, because it gives me room to say to my constituents in terms of just how it is when we talk about trying to improve legislation or to bring legislation forward, that we have a process that allows to improve legislation itself. And C-51 is a very good example of that. I understand, for example, there was at least, from what I understand, one opposition amendment that was made and approved. And there were a number of government members that brought forward amendments to improve the legislation. So it clearly demonstrated in a very specific way that second reading is a great opportunity to get a good understanding and principle of what the legislation is about. It goes to committee. Canadians experts are afforded the opportunity to provide their thoughts. Members of Parliament are able to reflect on the clause by clauses, and caucuses, either directly or indirectly, were able to feed their thoughts into the need for changes. So we saw amendments, and for me personally, this particular amendment was a very strong positive, because I know that there were constituents of mine that were wanting to see that happen, Mr. Speaker. So I applaud the efforts of the Standing Committee and the fine work that they did at ultimately returning the legislation to where we are today. And I think today we have fairly good support coming from all political parties in favor of it. I understand, that many within the chamber and outside the chamber see this as a strong a piece of legislation that will further advance the important issue of sexual assault. I think that we often underestimate just how serious the issue of sexual assault is in Canada. I believe it was in 2016, there were some 20,000 plus incidences that were actually reported, Mr. Speaker. That's far too high in terms of numbers. I don't know how it compares to previous years. All I know, Mr. Speaker, is that it's an unacceptable number. Now, when you factor in that if there's 20,000 plus in 2016 that were actually reported, you can anticipate that for every one that was reported, there were many others that were not reported, Mr. Speaker. And that is something in which I think needs to be talked about more. As a government or as a House, we need to look at ways in which we can ensure that individuals that are victims or become victims that feel comfortable in knowing that a society as a whole wants them to and to encourage them to come forward. Because we all understand and can appreciate the consequences of this type of violence or type of crime, Mr. Speaker, which occurs every day. The numbers are fairly significant and, quite frankly, very upsetting. To say that it affects every community, all communities in which we represent in the House. And that's one of the reasons why I believe that, we can talk about bringing in the legislation and trying to improve it through legislation, but I would ultimately argue, Mr. Speaker, that it's going to take more than just legislation, that there needs to be a national-led approach at how it is that we can deal with this issue. I'm very happy when I hear we have different departments, in particular public safety and other departments, status of women that are engaged and as much as possible on top of this issue, that we need to promote the dialogue. I've always thought that we vastly underestimate, for example, the roles that our school divisions throughout the country can play on the issue of violence, in particular in regards to sexual assault, Mr. Speaker. That is something in which I would like to see the different stakeholders provide more ideas, start having more of that dialogue. What takes place in our schools is of critical importance. I used to be the education critic a number of years ago in Manitoba, and we often talk about issues such as the curriculum, setting the curriculum agenda for our schools, and the importance that the provincial government has to play with respect to the curriculum. Well, I would further comment, Mr. Speaker, that there are likely some areas where there in the country where there's better practices, and this is where I ultimately believe a national government can play a leadership role by looking for those better practices and trying as much as possible to encourage and promote those practices in other jurisdictions. It's one of the reasons why I really believe in the importance of having interprovincial discussion groups, having a government and its ministers here take these important issues to the many different tables in which they sit around. The legislation is important. We recognize that. And that brings me right to the bill itself, where it proposes to remove and repeal the passages and provisions of the code that have been ruled unconstitutional in many ways by our courts or raise concerns under the Canadian Charter of Rights and Freedoms, as well as the passage of provisions that are obsolete, redundant, and or just quite frankly no longer in place for or in the criminal law itself, Mr. Speaker. I would want to clarify by strengthening the criminal law of sexual assault is expected to assist in enhancing better understanding of the law and addressing concerns about the law's application. That is something in which, Mr. Speaker, I believe, as I was commenting earlier, the better the understanding of the law, the simpler that it is made and known to victims, the greater the likelihood that we would actually have victims actually approving and coming forward to report what has taken place in their particular situation. The proposed changes to the Department of Justice Act and Criminal Code reflect the government's unwavering, I would suggest to you, commitment to promoting respect for the Charter and the rule of law. And that's where I made reference to the years in which we sat in opposition and how important it was for us in opposition that when government brought forward legislation, that in fact that there was a charter test, if you like, applied to it. this legislation does just that. Repealing provisions that are very similar to those found unconstitutional by the courts will help to avoid expensive and time-consuming litigation. Requiring or avoiding unnecessary litigation will also help to prevent court delays and backlogs, which again is so critically important, Mr. Speaker. I think that if we take a look, we'll see that the members of the Standing Committee on Justice and Human Rights did that outstanding job in reviewing and making the amendments that I've made reference to. Were of the utmost importance. The government is committed to ensuring that our criminal justice system protects Canadians, holds offenders to account for their actions, Mr. Speaker, that it upholds the Charter of Rights and Freedoms, and it shows compassion to victims. We have to ensure as much as possible, Mr. Speaker, that we have confidentiality and privacy as much as humanly possible is protected of the victims, Mr. Speaker. Absolutely critically important. This includes the unwavering commitment to ensuring that victims of sexual assault are treated with the utmost dignity and level of respect. Mr. Speaker, that during the actual study, we heard many individuals that came before the committee where there was questions in terms of the importance of clarity of what a sexual assault laws are. The feedback that was provided was most welcome. Getting a better understanding of how a person is given consent, that need to recognize that if someone is unconscious, that they are not capable of giving consent. So it provides more definition in that area, Mr. Speaker, or more clarity in that area. And I believe at the end of the day, based in terms of what I'm hearing from members opposite, that there is fairly good support for the legislation. And on those areas that were repealed, that in most part, with the one or possibly two exceptions, that the House seems to be fairly supportive, and the one greatest exception, the 176, has in fact been dealt with in an appropriate fashion. I know I, for one, Mr. Speaker, was, as I indicated, quite grateful that in fact it was repealed. I see that my time has expired, Mr. Speaker. I appreciate the opportunity to share a few thoughts on this piece of legislation. Thank you.
Questions and comments? Questions et commentaires. The honourable member for Barrie Innisfil.
Thank you, Mr. Speaker, and I do want to thank my honourable colleague for his tempered comments today. Oftentimes we see the arms waving and flailing, and but I think the fact that there's all-party support for the changes of this legislation perhaps led to the tempered comments that we heard today. I do want to bring up 176 because I think it's important to understand, Mr. Speaker, that it was the member from Niagara Falls who really highlighted the fact that the changes were not in this bill, that they were significant issues with religious freedoms and religious institutions practicing. And the member from Niagara Falls brought this up, that it wasn't in fact advertised as part of the changes to this piece of legislation. And so I want to ask the honourable member why it wasn't highlighted when this bill was tabled, and in all the press releases and the correspondence that were put out by the government subsequent to the releasing of this piece of legislation, they in fact neglected to put these changes with Section 176 of this Act. And again, it was the member from Niagara Falls that highlighted those.
The Honourable Parliamentary Secretary.
Yes, Mr. Speaker, and that's one of the reasons why I started the speech in the manner in which I did, focusing specifically on Section 176. And, you know, there's been a number of my colleagues, members from across the way, that have talked about C-51 and the many different advantages of the passage of this particular piece of legislation, especially when it comes to sexual assaults, Mr. Speaker. And, you know, there's no way that I could articulate on in the same manner in which some of our colleagues have in terms of the actual benefits in that whole area. So that's why I focused a good part of my comments just talking about the issue of process. And I looked at the Section 176 as actually a fairly positive experience in the sense that what we saw was not just one member of the House, because I believe that this thing was being driven in most part by Canadians to say, hey, look, let's just wait a minute here. I know I've had calls on it, and they felt that this was an important aspect of the Criminal Act. So whether it was being used very rarely or not, it definitely provided, you know, a disincentive for individuals to, you know, go into whether it's a mosque, Gurdwara, Christian church, whatever it might be, in an attempt to disrupt. It was a positive aspect to the criminal code. How it ultimately came into being and appearing in that piece in Bill C-51, I suspect had a lot more to do with reviews that were being conducted. As I indicated, some of the stuff that's within C-51 is because of court decisions. Others is because of bureaucratic decisions. Others would be because of other stakeholders' decisions. Which category that one falls under, I'm going to choose to believe that it was under the bureaucratic review in terms of how many times possibly it was being utilized in our courts. And as a result, Mr. Speaker, it appeared there. But the good news is that we have a process in place. We have individuals that were listening to their constituents, and we're able not only to get rid of the repeal, but we also amended it in the criminal code so that it went to include faith and spiritual leaders. And I think that even made the criminal code that much better. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. L'honorable député.
The Honourable Member for Jonquière. Thank you, Mr. Speaker. When I visit people in my riding of Jonquière, I met with a number of people in women's and children's shelters. I went to La Chambrie, one of these units, which shelters women who are victims of sexual assault and who are fleeing it. So I've discussed, I chatted with a lot of these women. They're from all kinds of social backgrounds, and they end up at this shelter because it is a place where they can feel safe. Of course, we want to support the amendments around sexual assault, but we must ensure that we are saying this is not just a minor change, because this change, especially for victims of sexual assault, who are also often women, we need to make sure that there's enough money for legal aid to ensure that all victims can have the right to legal representation. What does my colleague think of that?
The Secretary.
Well, thank you, Mr. Speaker. And for me personally, this legislation, and it's the sexual assault aspect of the legislation that I believe makes it so very, very important, and one of the reasons why this government needs to move forward with the legislation as soon as possible. And I suspect that's the reason why most individuals are getting on side supporting that aspect of the legislation. What it does, at least in part, Mr. Speaker, amends Section 273(1) to clarify that an unconscious person is incapable of consenting, which reflects the Supreme Court of Canada's decision in R versus J, 2011. Amends the Section 273.2 to clarify the defense of mistaken belief and consent in not available if the mistake is based on mistake of law, for example, if the accused believed that the complainant's failure to resist or protest meant that the complaint consented. This will codify aspects of the Supreme Court of Canada's decision in R versus Iwanchuk back in 1999, Mr. Speaker. More specific in terms of the importance of our shelters, I think that if the member was to look at the National Housing Strategy, which is, from my perspective, a historical document that the Minister of Housing has done an incredible job, you'll find that there's significant amounts of money that's being allocated to ensure that we continue to support an area in which there's a need for support. And it's also important that we work with the provincial entities, Mr. Speaker, where in my area it's Osborne House, which does a fantastic job at meeting many of the needs of women and others in our community that unfortunately have had to endure sexual assault and many other harms. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Central Nova.
Thank you very much, Mr. Speaker. And just before I pose my question, I know a comment was made earlier about my honourable colleague waving his arms on occasions. When he spends as much time in the chamber as this member does, there's very little time for exercise. So I know where it comes from. I do want to ask on a more serious note. This bill includes important measures dealing with the importance of consent in terms of criminal law around sexual assault. I want to recognize some of the points made from different members from different parties on the issue of the circumstances across different sectors of society in the battle that we need to fight to ensure that victims have the support that they need. But in addition to those systemic supports, this particular bill proposes certain revisions around that clarify the importance of consent in sexual assault cases. They ensure that, for example, communications are now subject to the rape shield laws that have long protected the use of a person's sexual history to impugn their credibility, for example, or imply consent in a certain circumstance. Does the honourable member think that this particular bill is going to enhance the number of women who actually are able to come forward and restore their faith in the justice system to report the crime of sexual assault when it takes place in our communities?
The Honourable Parliamentary Secretary in 60 seconds or less, please.
Yes, thank you, Mr. Speaker. I suspect that is one of the greatest motivating factors as to why it is the government is wanting to move forward on this particular issue. And maybe, Mr. Speaker, if I conclude by just on the rape shield provisions to include communications of sexual nature or communications for a sexual purpose. These criminal code provisions provide that evidence of a complainant's past sexual history cannot be used to support an inference that the complainant was more likely to have consented to a sexual activity at issue, or that the complainant is less worthy of belief. Mr. Speaker, that's often referred to as the twin myths. This is something in which, as I say, is one of the greatest motivating factors for the government to move forward on this particular piece of legislation, along with the charter and concerns that I've raised earlier. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Battle River Crowfoot.
Well, thank you very much, Mr. Speaker. It's indeed an honor to rise in this place once again and to speak on the debate around another Liberal omnibus bill, Mr. Speaker. This time it happens to be a justice bill. We note that it's been mentioned already today that during the past election, the Liberals promised no more omnibus bills. They also campaigned against the use of time allocation, and we've seen time after time after time that this government has ignored those commitments, ignored those promises, and they've moved with this omnibus bill and many times with time allocation. Mr. Speaker, I'm very pleased to be able to speak on a bill that received so much input from my constituents in this over the summer. In this bill, we are dealing with especially those who have strong religious beliefs. And that's not just one religion. It's not just pick and choose a religion. It really affects all religions. This bill was originally introduced by a Liberal government with a section containing what many people thought was an assault on religious freedom and belief. And Mr. Speaker, I will be splitting my time with a member from Sherwood Park, Fort Saskatchewan. The Liberal government planned to repeal, as we've heard today, Section 176 of the Criminal Code pertaining to the protection of religious officials and the freedom to worship peacefully without disturbance. Canadians know that the Conservatives have always supported religious freedom and the protection of those freedoms. In fact, Mr. Speaker, it was the Conservative government that brought forward a position, an ambassador of religious freedom in the office that promoted religious freedom around the world. And Andrew Bennett served there after a long period of time with Foreign Affairs. He became that ambassador and did amazing work for our country and for the whole concept of religious freedom. But the Liberal government in this Bill C-51 planned to repeal Section 176 of the Criminal Code pertaining to the protection of religious officials. And Mr. Speaker, there was a response in my constituency office and across the country as we heard pastors and others involved who really expressed their deepest concerns. I'm very pleased with the work of the Conservative members of Parliament that sat on the Justice Committee during the hearings on Bill C-51. That includes the member for St. Albert, Edmonton, and also the member of Parliament for Niagara Falls. There were many other Conservative colleagues, including the great work that the Member of Parliament for Cypress Hills Grassland does with the whole religious freedom file, that put considerable effort into the protection of all religious officials and the freedom to worship peacefully without fear of disturbance during those services. So I want to thank the many witnesses who appeared before committee and testified, provided submissions to the committee for standing up and defending religious freedom in Canada. Together, their voices were heard, and I commend the Liberal government for backing down on their attempt to repeal Section 176. And Mr. Speaker, I think that we've seen where amendments should be brought forward and accepted, and so we commend them for that. It was disconcerting to see that the current government would include in Bill C-51 a dismissal of the importance of that entire issue of religious freedom in Canada. They announced their belief that the disruption of a religious service, by not including it in the bill, was not a serious enough matter that should be protected in this legislation. And consequently, again, people responded. And at first, initially at committee, we saw where the government tried to ignore it and said that's not what's going to happen. And by November this year, the Liberals on the Justice Committee agreed to allow Section 176 of the Criminal Code to remain operable. And this was a victory, I think, for all faith communities in Canada. It's important because hate crimes in the religious community, we see it all across the world. Hate crimes on the increase. And Mr. Speaker, unfortunately, it's the very same thing here in Canada. Whether it is Jewish faith, Judaism, attacks on synagogues, the Christian faith, or the Muslim faith. Bill C-51 was introduced by the Minister of Justice and Attorney General of Canada just days before the parliamentary recess, June 6, 2017. Clause 14 of Bill C-51 proposed to repeal Section 178 or 176 of the Criminal Code of Canada, which makes it a crime to unlawfully obstruct, threaten, or harm a religious official before, during, or after they perform a religious service. And again, all summer, we heard about it. Just want to read a little bit later on of what Section 176 did. But why is this important? And I want to go back to a quote that former Prime Minister John G. Diefenbaker said, and it's a quote that I think all of us should take note of and appreciate. And he said this, and I quote, "I am a Canadian, free to speak without fear, free to worship in my own way, free to stand for what I think right, free to oppose what I believe wrong, or free to choose those who shall govern my country. This heritage of freedom I pledge to uphold for myself and all mankind." His pledge was to stand up for not just direct assaults on religious freedom, but to stand up against the erosion of religious freedom. And this is the way that Canadians have lived for decades. Mr. Speaker, the new sunny ways of the Liberal government is very selective on who they respect. Worse, the Liberal government tried to reduce the security of religious Canadians by burying their repeal in Section 176 deep in an omnibus justice bill. Well, more than 65 interfaith fellowships or interfaith leaders, including the Evangelical Fellowship of Canada, one of 65, sent a joint letter to the Minister of Justice on October 31st, 2017. And, Mr. Speaker, they very much brought forward the concerns that they had. Let me just read very quickly part of 176, right out of the Act, because I think it's important for Canadians to get the perspective of it. Everyone who, A, by threat or force unlawfully obstructs or prevents or endeavors to instruct or prevent a clergyman or a minister from celebrating divine service or performing any other function in connection with his calling, or knowing that a clergyman or minister is about to perform, is on his way to perform, or is returning from the performance of any of the duties or functions mentioned in the paragraph, A, assaults or offers any violence to him or arrests him on a civil process or under the pretense of executing a civil process, is guilty of an indictable offense and liable to imprisonment for a term not exceeding 2 years. Disturbing religious worship or certain meetings, it goes on. Everyone who willfully disturbs or interrupts an assemblage of persons met for religious worship or for a moral, social, or benevolent purpose is guilty of an offense punishable on summary conviction. This provision, Mr. Speaker, protects the pastor, the clergyman, the rabbi, the imam, to lead, and it protects the individuals who want to participate in such a service. It's important to note, again, that, Mr. Speaker, they felt that this was unacceptable. In unison, members from all faith came together. Mr. Speaker, C-51 has other points. I got a minute left, and so I'm going to have to hurry. First of all, it deals with sexual assault provisions. It clarifies and strengthens certain aspects of sexual assault related to consent, admissibility of the evidence, and legal representation for the complaint. It repeals or amends a number of provisions in the criminal court that have been found unconstitutional by appellate courts. It's a housekeeping measure. And so I think as the member who spoke before me suggested, it's good to see that there is support in this place for some of those measures. And Mr. Speaker, I'll just close by saying that this is the way really that it should end up. It should end up where Canadians stand up, first of all, for what they believe is an assault of their way of life, where we can take it to committee, where we can make those amendments, and where governments are then willing to allow those amendments to come forward. So I thank the Conservatives for bringing forward the amendments and all other parties for accepting the amendments. And certainly, Mr. Speaker, we hope that, although the bill may not be perfect, we hope that the measures that have been amended and are coming forward will pass through. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Mississauga Centre.
Thank you, Mr. Speaker. I want to thank my honourable colleague for his speech. And I as well want to add my voice that I am relieved that faith leaders had the opportunity to offer their perspective, and I am pleased that the minister and our government has reinstated that clause in the legislation. But I want to congratulate my colleague on his speech at length about protection of religious freedom. And I would like to ask him if he were to share with us his opinion on the woman's right to cover her face out of her own religious belief. Because the previous government, his party, wanted to deny women that right. So would he please comment on that? Thank you.
Honourable member for Battle River Crowfoot.
Well, thank you very much, Mr. Speaker, and I appreciate the question, but the question is absolutely not true. It's not correct. We have never said that we would not allow a woman to cover her face or to cover her head or to do anything such as that. The only question comes is if someone is taking a pledge of citizenship, or if they're wanting their picture taken for their driver's license or some form of identification, should they be able to conceal their identity? And so I know there are massive concerns around that, but as far as accommodation, I think, you know, that we recognize that people have different opinions within their faith. I will stand and defend the right of a Muslim to worship in the way that they choose, the Christian to worship, the Jewish faith, the Sikh, the Hindu, whoever. I may not understand all their forms of worship, but I will defend their right to worship as long as it adheres to the law in a peaceful way. And so I think common sense also says, you know, what do we expect? Do we expect you know, I have a Hutterite colony in my constituency who took a great offense to the fact that they felt they should have driver's licenses, but they would not be willing to pose for their picture so that the officer could identify them if they were caught. They said it was a religious thing. We have to find balance here somewhere, and we have to be able to find common ground. And the member is wrong in saying that we did not believe in women's rights to cover her face.
Questions and comments? The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. I thank my colleague for an excellent speech. Of course, in talking about this bill, he touches on a number of the different aspects of it, dealing with sexual assault, dealing with religious freedom, dealing with a range of different things that are frankly disconnected. So aside from the particulars of the provision, I'd be curious for his thoughts on whether this constitutes an omnibus bill and how he feels about the fact that we're seeing many omnibus bills from a government that in fact railed against omnibus bills when they were in opposition.
The honourable member for Battle River, Crowfoot.
Well, again, Mr. Speaker, you know, sometimes there may be reason for an omnibus bill. I don't believe this was one of those times. A budget, you know, sometimes there may be measures that are other measures that are brought into a budget. The problem was, in the last election, the Liberal government railed against a few times that we brought forward omnibus bills. They said they would not bring forward omnibus bills. Bill after bill, they're now bringing forward as omnibus. They said time allocation, closure was a measure that was should never be employed here in the House of Commons. And yet, how many times have we seen this government do exactly what they said they wouldn't do in the last election? They said in the last election that they would have a very small little deficit, $10 billion deficit, over a $20 billion deficit. It's the broken promises. I think that's the issue. So is this an omnibus bill? Yes, I believe this is an omnibus bill. They brought different measures into the bill. There's other omnibus bills that they brought forward and they're going to bring forward. And, you know, Mr. Speaker, the public will judge them. The public will judge them. And whether it's a bill worthy of passing, listen, you know, it's one thing if you're going to make a promise, live up to it. If you aren't going to promise it, it's pretty hard to ridicule someone later for doing it. But they're just backing down on their word once again.
Conformément à l'article
Pursuant to Standing Order 38, it is my duty to inform the House that the questions to be raised tonight at the time of adjournment are as follows.
Honourable member for Peace River Westlock, Justice. Resuming debate, the honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. It's a pleasure for me to have this opportunity today to join the debate on Bill C-51. It's a bill that is, I think, quite clearly an omnibus bill. It deals with a wide range of different provisions with respect to justice. And I'm going to comment on some of those provisions. But at the outset, let me just quickly comment on the fact that we have before the House an omnibus bill. Now, I'm not one of these people that says any omnibus bill represents the end of the world. But there are some people on the other side of the House that took at least something close to that position in the last Parliament. And I remember being asked about this during election forums that happened in my riding, and I said very clearly, I think there is an appropriate use of bills that contain a number of different kinds of provisions. There's also an inappropriate use of that, and ultimately, you can't necessarily codify exactly what that looks like in every case, but it's the kind of thing where reasonable people should look at it and judge. And as the principle is that as much as possible, opportunities should be created for debate and votes that are particular to specific individual issues. You shouldn't have a situation where you have a whole bunch of different contrary, unrelated things in the same bill that aren't in any way part of an overall plan moving in the same direction. When the government does that, they create a situation where obviously there may be some aspects of the bill that are positive, some aspects of the bill that are not, and then it creates a very particular challenge for members of parliament who are trying to decide how they express their support for certain provisions of the bill that they may like, and obviously their opposition to things that they may have concerns about. But it also creates an opportunity for the government to bury things in the legislation that actually deserve particular scrutiny. I'm going to talk about the changes with respect to Section 176 of the Criminal Code that were proposed. This is an example of one provision that would have had a very substantial impact. It was buried within a larger bill. It didn't figure prominently in the government's communications on it, and it was only because of the activism of the opposition raising the awareness of this section that we were actually able to see it debated, see it discussed in committee, and ultimately see what seems like the willingness of the House to remove that section. But regardless of one's views on the principle of omnibus legislation, we should hold the government accountable for the fact that they have failed to live up to the standard that they set for themselves with respect to omnibus legislation. Now, a few of the provisions that we see in this bill, one of them, I understand, removes the sections from the criminal code dealing with witchcraft. And I think it makes sense that the government would do this. Witchcraft may be their only chance of balancing the budget in the near term. Now, some members may think this is uncontroversial. I actually discussed it with Mackenzie King this morning, and he has some concerns about this section of the bill. But ultimately, we decided it will only have a medium impact going forward. So I think we'll just leave it there, Mr. Speaker. Members are encouraging me not to give up the day job. Don't worry, I intend to be here for a long time. Now, the particular focus of public debate around this legislation was Section 176 of the Criminal Code, which previously existed and at present does exist. Section 176 specifically made it illegal to disrupt a worship service or attack a, quote, clergyman or minister. The original version of C-51 sought to remove that section, and really this would have removed the only section of the criminal code that provided specific protection by criminalizing attacks on religious services or religious leaders. And we heard a number of arguments in the course of the debate. Of course, the general thrust of this legislation in terms of the government's communications on it was that they were saying that they are removing redundant or unnecessary sections of the criminal code. And some argued that these specific protections for religious officials and for religious services were not necessary because any of the things that are particularly identified within that section, well, they deal with things that would have been illegal anyways. Disrupting a worship service might have been captured under trespassing provisions. Vandalism obviously would have been and is illegal anyways. Assaulting someone, whether they're a religious figure or not, is illegal anyways. So the argument was Section 176 of the Criminal Code is redundant. Well, why did we disagree with that on this side of the House, Mr. Speaker? Well, we recognize in law that even things that are already illegal may need extra legal recognition in order to ensure that they are treated by the law in a proportionate way. This is, after all, why we have laws with respect to hate crimes. Anything that is not permitted under hate crimes legislation is probably something that is, in fact, already illegal. But I think all members of the House agree that it is still important to have hate crimes legislation, recognizing the proportionality, recognizing that there is something much more serious that should be treated more seriously, about targeting someone because of their background, their identity. There's something more serious about that than a purely random act of vandalism or violence. Not to downplay the seriousness with which the law should treat a random act, but when an individual, an institution, a group is targeted specifically because of their identity, that has a different and arguably much greater social effect, because it seeks to impede the practice of that faith, impede the living out of that identity, and to create a climate of fear for people that are part of that identity. So when we have specific sections that deal with crimes that target specific groups, that helps us to ensure that the law is treating crimes in a proportionate way that reflects the social effects of those actions. So Section 176, we can see on that basis, was not redundant at all, but it reflects an important social purpose of the law, which is to ensure proportionality. Now, another reason why 176 was not redundant, I would say, Mr. Speaker, is that even the fact of this being in the criminal code sends a clear message. The law has practical effects, but it also has pedagogic effects in terms of demonstrating our commitment to religious freedom and to the protection of the practice of faith in Canada. Now, we also had people objecting to this section on the basis of that the language implies that it might only apply to certain faith communities. It uses the language clergyman or minister, which obviously is gender specific, but it also implies that it only refers to a particular faith. The reality is, though, that and those who raise this objection were being somewhat disingenuous, because this section is clearly interpreted as applying to men and women, and as applying to people of all faiths. And certainly it probably makes sense to update and clarify the language with respect to that, to change the language to ensure that there's no misunderstanding. But in reality, there never really was a misunderstanding in terms of the way in which the law applied. So those objections were incorrect, Mr. Speaker, and many people over the course of the summer and early fall were actively engaged on this issue, signing petitions, lobbying their MPs. I know I was involved in Edmonton in organizing a roundtable for our leader, meeting with religious leaders from different faith communities. It was a great opportunity to get leaders from different faith communities together as part of a common roundtable, talking about the issues around C-51. And of course, we are glad to see the government backing down on this. But it is important to ask the question, why was the removal of Section 176 in this bill in the first place? Whose idea was it to put it in there, buried in a long list of provisions with respect to all kinds of other issues? The government, in certain instances, maybe talks the talk about protecting at least certain minority communities and certain faith communities. But when it comes to actually walking the walk, they tried to, in the initial draft of this legislation, remove this critical protection for faith communities. And when they were caught, when communities became engaged, eventually the government backed down. But this speaks to the importance of vigilance, that the government talks the talk on the one hand, but when they think people aren't looking, when it's small provisions within large omnibus bills, they frankly try and get away with things that most Canadians would see as unacceptable. So this is then a call, Mr. Speaker, for continuing vigilance on the part of members of Parliament and Canadians to hold this government accountable. Thank you.
Questions and comments? The Honourable Member for Winnipeg North.
Yes, thank you. Mr. Speaker, I disagree with my colleague across the way in the sense that he's trying to give what I believe is a false impression. We have Canadians from different regions of our country that contacted their members of Parliament. I was but one member of Parliament that was contacted after the bill was introduced with respect to that clause 176. Like the person I talked to, I too expressed concerns in regards to it. I think we had a very productive committee meeting. There seemed to be a lot of commonality amongst the members after the committee got into the debate on possible amendments. I understand it was even a Liberal amendment that was brought forward that actually enhanced that particular clause, made it more up to date with spiritual leaders and faiths of all natures. And I'm wondering if my colleague would not agree that the credit is not necessarily owed to an individual, but rather it's likely better owed to the individuals that took the time to make calls to individuals like myself and other members of the House, and those that took the time to get a good understanding of it at the committee level, and those that made presentations. And those members of all stripes on the committee did a fine job by repealing this particular aspect of the legislation that was being proposed.
The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. You know, it's not about anyone claiming credit here, although I will note parenthetically that the government is rarely shy about claiming credit, even for things that happened under the previous government. But let's be very clear, Mr. Speaker, that the question that I posed in my speech, and I'll pose again, is why was the removal of Section 176 there in the first place? Somebody made the choice to include as part of this legislation. The recommendation may have come from somewhere in the public service, but it was the minister tabling the legislation who presumably looked at the legislation when it was initially proposed and said, yep, that provision to remove Section 176 is okay to be in there. And I think it's worth asking the question, why was that done? Yes, of course, through the activity of many different communities and through the work of members of Parliament as well. Attention was brought to this section, and ultimately we were able to work to a position of fixing that problem. But it doesn't change the question when we see the government doing all kinds of things that might concern Canadians with respect to religious freedom. Their decision, for example, to eliminate the Office of Religious Freedom. When we see some of these different actions raising concerns, again, it just begs the question, and maybe the member from Winnipeg North will want to answer it at some point. Why was the removal of Section 176 from the Criminal Code included in the initial draft of this bill?
Questions and comments. The honourable member for Barrie Innisfil.
Thank you, Mr. Speaker. And oftentimes I go back to three pieces of information if I ever want a giggle or two, and that is the real change policy that was announced by the Prime Minister prior to the previous election. The second piece that I get a giggle from is the speech from the throne. And the third one, oftentimes, are the ministerial mandate letters. And the honourable member brought up the issue of omnibus bills. By my count, Mr. Speaker, this is the fourth, at least, omnibus bill that we've seen. And if you go back to the Liberal platform in 2015, it said we will change the House of Commons standing orders to bring an end to this undemocratic process. And yet here we are with another omnibus bill being proposed by this Liberal government. So it shows complete hypocrisy. And I think the honourable member, and I'm asking him, would he agree with that?
Member for Sherwood Park, Fort Saskatchewan.
Well, thank you, Mr. Speaker. A very wise and thoughtful question from our Deputy Whip. I'm always happy to pay compliments to my colleagues, but especially the Deputy Whip. Certainly in my interest to do so. But anyways, Mr. Speaker, this is exactly right, that the government is continually putting forward omnibus bills which are directly in violation of their election commitments. It shouldn't have been difficult to recognize that there are some cases where omnibus, where bills that include different elements make sense. There are some cases where one can make an argument for that. But the government is even stretching any kind of reasonableness test, and in any event, they're certainly going far beyond the commitments they made during the election.
Resuming debate, the honourable member for Central Nova.
Thank you kindly, Mr. Speaker. And before I begin, I'd like to inform you that I'm going to be sharing my time with the honourable member from Niagara Centre. This bill that we have, C-51 on the floor of the House of Commons, deals with certain revisions to our criminal code and also certain revisions that will impact our charter. These are two extraordinarily important laws in our country that have a very direct impact on the lives of Canadians. And like anything worth keeping, they require maintenance by time, so to speak. Bill C-51 performs some of that much-needed maintenance. The bill attempts to do three main categories of things. First, and perhaps most importantly, in my opinion, provides much-needed clarity around the concept of consent when it comes to criminal law around sexual assault. It also addresses certain sort of zombie laws, I've heard them referred to as previously, that have either been deemed unconstitutional by our nation's highest court or have become obsolete because of the social context in which we find our country today. Finally, it will require the Justice Minister to introduce a charter statement to declare the compliance with our charter of any government bills introduced through that portfolio. So first, to the real crux of the matter, in my opinion, Bill C-51 provides desperately needed clarity around issues surrounding criminal law and sexual assault. Before I deal with the specifics, I'd like to just share with the House that this is a social problem that is endemic to Canadian society. It impacts every community. I've had the good fortune of sitting on the Standing Committee for the Status of Women and have heard directly from witnesses who've been impacted by this horrific experience and have survived sexual assault about what it's done to them personally. And to the extent that we can help stamp it out in this House, I think that's the very least that we owe Canadians. Now, there's a number of measures that the government's taken outside of this bill to help fight gender-based violence once and for all, including over $100 million introduced for a gender-based violence strategy. But what we heard during our committee study on ending gender-based violence against young women and girls is that it's not simply supporting victims, but it's also legislative reform, particularly in the criminal context. We have a criminal law system that discriminates against complainants at every turn. We are so ill-equipped to deal with these kinds of cases that, in fact, a vast majority of complainants choose not to report incidents of sexual assault at all. And those who do muster the courage do so knowing that the rate of conviction and the rate at which justice will actually be granted is so small that it's hard to imagine why they would put themselves in the position of being questioned and re-victimized in the first place. So we have an opportunity here, in a small way, to better our system, to help encourage more people to come forward, and to help ensure that justice is indeed granted in circumstances where that's possible. One of the ways in which this is achieved, proposed Section 273.1 confirms the JA decision, which explains that, quite simply, consent is required on an ongoing basis. Essentially, if you're unconscious, you're not able to provide consent. This is the simplest message to anyone who might be listening at home. If you're having sexual relations with a person who is too drunk to consent or who is unconscious, that isn't sex. That's rape, and we need to acknowledge it for what it is. Section 273.2 of this legislation also provides additional protections by ensuring that there's not, and this reflects the Supreme Court decision in the Ewanchuk case in 1999, by preventing, in our criminal law, making absolutely clear that mistaken belief of the law cannot constitute consent. It's not okay to assume a person has consented because someone else gave consent for them. You need a positive affirmation. You can't assume that because a person consented in advance that their consent is ongoing. You can't assume that a failure to resist a sexual advance constitutes consent. If that's your only line of defense in a sexual assault case, you should be found guilty under our law. Importantly, the Bill C-51 before the House also deals with our well-established rape shield provisions. The sort of twin myths I've heard discussed from different members of the House today explain that we can't rely on the sexual history of a complainant to make findings as to their credibility or the fact that they've given consent or not in a given instance. Bill C-51 expands this protection to ensure that communications sent with sexual content or for a sexual purpose are not used to perpetuate those same myths. This is an added layer of protection that reflects the world that we live in. In the 21st century, if consenting adults wish to send each other communications of a sexual nature or for a sexual purpose, that's their decision. But the fact that someone has demonstrated that they were interested in sexual activity before cannot be used for a court to make a finding that they have given consent. You know, if I transpose this logic to any other social circumstance, I feel as though just about everyone gets it. And without being flippant about an extraordinarily serious issue, I often, after work, could join a colleague for a beer or potentially have a glass of wine or two over dinner. But if I am asked to go out for a drink on a given night and I say no, my friends understand that. I don't know why the same logic can't be applied to cases of sexual assault. For some reason, particularly amongst young men, again, if you're listening, just because a person has demonstrated a willingness to engage in sexual relations in the past, you should not assume that that is consent forever thereafter. Some of the other themes that are touched on that I'd like to address while I have the floor, Mr. Speaker, include some of these zombie laws. These laws create uncertainty and unnecessary expense and litigation and should be removed from the books and largely reflect decisions of our Supreme Court of Canada. I know cases of defamatory libel, cases involving evidentiary burdens and reverse onuses that have been dealt with by the Supreme Court will be reflected in laws. And I think, although I don't want to speak for everyone, that those provisions are unanimously supported by members of this House. There's other matters that are completely obsolete in this day and age. I noticed some of the provisions around challenging a person to a duel, which is a very interesting backstory in Nova Scotia involving our third Premier, Joseph Howe, if anybody wants to take the time to read it. There's crimes of publishing crime comics. There's fraudulently pretending to practice witchcraft. I think we'll leave the discussion around people who are actually practicing witchcraft for another day. But I think you get the point. There's many laws that exist in our criminal code that really should be removed from the books. Now, the government has a responsibility to ensure its laws comply with the Charter. And that brings me to the last theme that's addressed by Bill C-51. And that's the obligation on the Minister of Justice to introduce a compliance statement, a charter statement, with new pieces of government legislation that impact that portfolio. This is a very positive exercise, in my opinion, and it's one that will enhance openness and transparency. It will allow Canadians to see that the government is stating for the record why it believes its laws are in compliance with the Charter. You know, we sometimes fall into the trap in different governments in different parts of our nation's history, and putting forward laws that may seem popular to a voter base, but may be contrary to the rights that are included constitutionally in Canadian law. This practice of introducing a compliance statement with the Charter is going to ensure that our government is subject to Canadian laws and that our people are protected by it, not the other way around. Mr. Speaker, this proposed legislation has my full support. Whether it's making clear the provisions around consent in cases of sexual assault, whether it's removing from our Charter specific provisions that should not be there, either for their unconstitutionality or their being obsolete, or it's the introduction of a Charter statement. These are positive developments that are going to help make our criminal system more efficient and will help protect the charter rights of Canadians. Thank you.
Questions and comments? Questions et commentaires? Resuming debate. Oh, we have a question. I'm sorry, we have a question. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. And I agree with the principal thrust of my colleague's speech, which was to discuss the sexual assault provisions. I want to ask him about omnibus issues in particular. Does he see this bill as an omnibus bill?
The honourable member for Central Nova.
Mr. Speaker, thank you. And I listened intently to much of the debate around omnibus bills. And one of the things that I'd like to clarify here is that omnibus in and of itself should not be a swear word in this House. There are many times that a certain piece of legislation will seek to amend different laws that are somewhat related. In this case, the vast majority of the legislation before us seeks to update our laws to reflect either Supreme Court decisions from the Supreme Court of Canada or provisions that are obsolete in the social context in which we live. So although a certain piece of legislation might change different laws, when there is a common theme that renders them not completely unique, I don't think it's inappropriate. Now, there is the improper use of omnibus bills, and the weight of the irony is crushing me as I stand here taking a question from a member of the opposition on this subject. But I've heard testimony, or rather speeches in this House within the last hour that have discussed how the committee process has worked the way it should. Members were able to identify the different problems and propose useful amendments. But I can't let this question go by without pointing to Bill C-38 and C-45 in the Parliament of 2012, where I saw a budget erode the Fisheries Act protections and the Navigable Waters Protections Act that are so important to my community.
Questions and comments? The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. And my colleague who's been listening to a lot of the debate this afternoon will recall a good portion of his talking about the repeal, the original piece of legislation that actually had the repeal of 176, and how it was ultimately amended out of the legislation and in fact improved upon to more modernize that aspect of the Criminal Act now. And I wonder if he would like to share some of his thoughts in regards to even possibly just the process related to that particular aspect of the legislation.
The honourable member for Central Nova.
Once again, Mr. Speaker, thank you for the opportunity, and thank you to my honourable colleague for this great question. There are many great things about democracy in Canada, but one of our flaws I find is partisanship. Good ideas and good people come from different parties all the time. Our process sometimes helps those good ideas come to the fore, no matter which party they come from. I note on this issue, I've heard commentary to the effect that the member from St. Albert Edmonton and the member from Niagara Falls made great contributions to this specific debate on 176, which in my opinion does enhance the protection of religious freedoms in Canada. I also note that I was having conversations about this very provision as one of my colleagues and member of the Standing Committee for Justice, the member from West Nova, raised some of the concerns he had around this and some of the feedback that I heard in my own office as well. In my mind, this is a perfect example of how a nonpartisan committee is supposed to come to challenge the initial draft of legislation that's put before government, listen to the evidence that they hear, and make amendments to improve laws for all of Canadians. Because at the end of the day, a piece of legislation that makes it through this chamber and the other chamber is Canadians' law, not the laws of one government or another.
We have time for a very quick question. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. And my colleague has pointed out that some of the omnibus bills in the last Parliament were about as long as this government's omnibus budget bills. But the interesting thing about his response to my question is that he said, well, most of the provisions of this bill deal with sections of the criminal code that were obsolete vis-a-vis the Charter or the social context. Well, might I point out that to declare something obsolete in light of the social context is about as general as you can get, Mr. Speaker. There are all kinds of legislation which, for subjective reasons, some members might view as obsolete in light of a particular social context or not. In fact, that was their, in some sense, initial argument for the removal of Section 176. I understand this argument that, well, it's okay to do an omnibus bill if there's a common thread, and that's their argument now. It wasn't their argument during the election. We're holding them to the standard that they set for themselves, Mr. Speaker. But can't you claim a common thread on almost anything? Is there any limits to the common thread that he would tie across a range of obviously unrelated provisions?
The honourable member for Central Nova in 30 seconds or less, please.
Certainly. I'll try to do you better than that, Mr. Speaker. Taken to its logical extreme, the honourable member would have us address legislation one section at a time, which is not reasonable. If I actually look at the things that I'm staring at that are included in this bill, things about challenging a person to a duel, fraudulently pretending to practice witchcraft, pretending you're someone else during a university exam when in fact that's captured by other provisions, I do see a common thread. I don't see a problem with the use of an omnibus bill with a thread like this.
Resuming debate, the honourable member for Niagara Centre.
Well, thank you, Mr. Speaker. I am, in fact, pleased to speak today on Bill C-51, an act to amend the Criminal Code and the Department of Justice Act, and to make consequential amendments to another act. This bill, Mr. Speaker, proposes to make various changes to the Criminal Code that seek to make the criminal law modern, relevant, and consistent with the applicable Charter, case law. Mr. Speaker, it would also make important clarifications to the law of sexual assault. The Justice and Human Rights Committee has now concluded its study on the bill. The committee heard from a number of important witnesses and stakeholders representing diverse viewpoints. In particular, witnesses were most interested in sharing their perspectives and recommendations with the committee members on issues relating to the proposed sexual assault reforms. Mr. Speaker, the committee considered a number of amendments to those proposed reforms and adopted two that responded to what they heard from the many witnesses and that seek to bring even greater clarity to the law. The committee also heard from witnesses in relation to the proposed repeal of an offense that targets disrupting religious officiants and ceremonies. The bill proposed to repeal this offense because, Mr. Speaker, to the degree that it prohibits conduct that merits the criminal sanction, it is, in fact, duplication of other more general offenses. During the study, Mr. Speaker, of Bill C-51 at the Standing Committee on Justice and Human Rights, committee members also heard from witnesses and constituents who were, in fact, concerned about the proposed repeal of Section 176, as mentioned earlier by one of my colleagues. Our government listened to these concerns. Liberal MP and committee member from West Nova put forward an amendment to retain and modernize the section to ensure it is, in fact, gender neutral, and make clear that the section applies to all religious and spiritual faiths. The government supports this amendment. We believe that all Canadians, regardless of which religious or spiritual faith they adhere to, must be able to practice that faith without fear of violence or disturbance. Mr. Speaker, there are other proposed amendments contained in Bill C-51 that may not garner as much attention, but which are nonetheless very important to the proper functioning of our criminal law and to the overall coherence of the criminal code. For instance, Bill C-51 proposes to amend a large number of offenses by removing what is called a reverse onus. Mr. Speaker, a reverse onus is a rule of law that places the burden on the accused to prove that something is more likely than not to be true. This is contrary to a long-standing and fundamental principle of criminal law, namely that the prosecution bears the burden of proving guilt beyond a reasonable doubt. It is also, Mr. Speaker, it is also contrary to the presumption of innocence as enshrined in our Charter of Rights and Freedoms. Under these normal rules of criminal law, the fact that the prosecution has to prove guilt beyond a reasonable doubt means that the accused, to be acquitted, needs only to raise a reasonable doubt about their guilt. A reverse onus, Mr. Speaker, by contrast, says the accused must do more than raise a reasonable doubt. He or she must convince the judge or jury that it's more likely than not that they are innocent. There are special circumstances, Mr. Speaker, in which the burden can be reversed, such as when an accused raises the special defense of mental disorder. This burden is reversed because mental disorder is really a question of what is happening inside the mind of the accused, information to which they have to have the best access, and it is also a defense that can be easily feigned. Absent compelling reasons, the burden must always be with the prosecution, Mr. Speaker. Yet it seems that in 1953-54 consolidation of the Criminal Code, a reverse onus was in fact introduced into numerous offenses, defenses, and evidentiary presumptions. These, Mr. Speaker, have remained in the law until the present time, with the exception of a number that have been challenged on the Charter as violating the presumption of innocence. Most such challenges have resulted in the courts finding the reverse onuses to be unconstitutional. Mr. Speaker, Bill C-51 will remove the reverse onuses that have been struck down, and it would remove all the others that, while they have not yet been subject to challenge, do not appear, Mr. Speaker, to have any meaningful justification. These changes would not have a negative effect on public safety, would better reflect long-standing principles of criminal law, would eliminate the potential for new charter challenges, and would thereby avoid the need for accused persons, prosecution services, and courts to waste precious time and resources examining these provisions. Mr. Speaker, the consensus view amongst legal professionals and associations is that these amendments form part of the kind of reforms that our criminal justice system needs to work more effectively and efficiently. Other types of amendments that may not generate a lot of attention, Mr. Speaker, but are still important include the proposed repeal of a number of offenses in the criminal code that were enacted long ago. In many cases, Mr. Speaker, more than 100 years ago, many of these offenses reflect forms of conduct or values that are no longer relevant to our society. For example, Bill C-51 would repeal offenses such as alarming Her Majesty, Section 49, challenging someone to a duel, Section 71, and blasphemous libel, Section 296. Another example of an offense to be repealed is one related to making or publishing what are called crime comics, which are exactly what they sound like, namely graphic depictions of criminal activity and violence. While there once was a time where great public concern was had for the potential of these materials or to corrupt children, for example, those days are long past, Mr. Speaker. While not everyone will support this type of material or entertainment, we no longer believe, as a society, that people should be labeled as criminals for making it. Mr. Speaker, there are also offenses in our criminal code that are overly specific and duplicate other offenses that are more general in nature. A number of these would be repealed as well. A good example, Mr. Speaker, is the proposed repeal of Section 365, pretending of practice witchcraft, as was mentioned earlier by my colleague across the floor. Section 365 makes it an offense to fraudulently pretend to exercise or use any sort of conjurations, tell fortune, or pretend to use one's skill or knowledge of an occult or a crafty science to find lost or stolen goods. This conduct is really just a small subset of fraud. Fraud involves some kind of deception or dishonesty combined with a risk of economic loss to another person. Fraud, Mr. Speaker, can occur in an infinite variety of circumstances. There is mortgage fraud, home renovation fraud, health insurance fraud, securities fraud, and basically any other situation in which a person voluntarily gives over money in response to something deceptive or dishonest. Also amounts, in fact, to fraud. There is no good reason to have offenses in the criminal code that spell out fraud, looks like in each of these circumstances, one offense of fraud gets the job done and, in fact, is defined within Bill C-51. Archaic offenses, such as those that overly be specific and duplicative offenses, take many pages in the criminal code. Mr. Speaker, I know that some commentators might consider these reforms the parts of Bill C-51 that do not get headlines or generate passionate presentations before committee are of little importance. But in fact, Mr. Speaker, I take a different view. We should not underestimate the importance of this kind of reform. The criminal code is a reflection of Canadian values and what we as a society deem to be blameworthy conduct deserving punishment and denunciation. It is to be clear, Mr. Speaker, the moral code of our society, and it is our job as legislators in this House to ensure that this code reflects our current values, current priorities, and that it does not overreach, and to be rational and orderly. Mr. Speaker, in conclusion, I support the Minister and our government in undertaking this routine but vitally important maintenance and updating of our criminal code to make it clearer, more accessible to Canadians, more relevant and modern, and more consistent with our human rights and freedoms. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. The honourable member for Peace River Westlock.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for his great speech there. I was just wondering if you had any comments. I noticed that he left that out of his speech about the fact that this is an omnibus bill, and I was just wondering if, since the Liberals had promised not to introduce any omnibus legislation, how he justifies this bill. Thank you.
The honourable member for Niagara Centre.
Thank you, Mr. Speaker, and I thank the member across for the question. And it seems they're putting a lot of emphasis on omnibus bills of this government, when in fact they did the same when they were in government. But I have to say, Mr. Speaker, our government is in fact committed to ensuring that our criminal justice system protects all Canadians, and that it holds offenders to account. upholds the Charter of Rights and Freedoms, and shows compassion for victims. Mr. Speaker, this includes an unwavering commitment to ensuring that victims of sexual assault, as contained within C-51, are treated with the utmost dignity and respect. This bill, although defined as omnibus by the members across the way, once again deals with those issues that are highlighted in the bill through C-51 to deal with, once again, sexual assault and ensuring that those treated with the utmost dignity and respect is a priority to this government. Some may call it omnibus. We call it a responsibility that deals with our values as Canadians.
Questions and comments? Questions et commentaires? La députée de Jonquière.
The Honourable Member for Jonquière. Well, thank you very much, Mr. Speaker. Now, as I said earlier, for victims of sexual assault, we support the provisions in the bill. However, this can't just be rhetoric or nice words. There needs to be legal assistance with the funding required to help people have access to legal services. Oftentimes, we're talking about women, and the government keeps talking about how important the middle class is to it, but sometimes these processes are extremely costly. So with this bill, I'd like to know what my colleague opposite thinks about the idea of financial assistance and legal assistance provided as well.
Thank you, Mr. Speaker, and thank you to the member across. I think it's a great question. And I have to say that repealing provisions that are very similar to those found unconstitutional by the courts will help to avoid expensive, time-consuming litigation. So we are, in fact, trying to bring those costs down. And with that, there are mechanisms, levers that are within the system that people can take advantage of for financial assistance. But I want to make two more points based on the question, especially the beginning part of the question. I think the member also has to recognize that requiring charter statements for every government bill introduced in Parliament represents a major step in support of our government's commitment to openness and transparency, and will help all Canadians, once again, all Canadians, understand the potential effects of new laws and their charter rights. And finally, Mr. Speaker, if I may, I do also want to mention, going to the latter part of the member's question, is that we wanted, in fact, through this bill, avoid unnecessary litigation, which will also help prevent court delays and backlogs, which, once again, it lends itself towards efficiencies and then, therefore, less costs. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. The honourable member for Winnipeg North. Very brief question.
Sure. Thank you, Mr. Speaker. Just maybe ask my colleague, one of the important aspects of the legislation that I'm very fond of is the sexual assault component. And just to highlight that, I believe it was 2016, there was something over 20,000 sexual assaults that were actually reported, but there's far more that went unreported because many victims actually failed to report for a wide variety of reasons. And this legislation will, in fact, hopefully encourage more to bring it to the attention when, in fact, they are victims of this nature. And if he might want to provide a quick comment on that issue.
The honourable member for Niagara Centre.
Thank you, Mr. Speaker, and a great question from my colleague. There's no question that this bill, once again, is going to add, again, a mechanism. I'll use those words, mechanism, a lever, to those victims to come forward with the expectation to be dealt with the utmost dignity and respect. But also, I have to say that when you look through this bill, it goes to our government's commitment since day one to really ensure that we reflect, as a government, on behalf of all Canadians, the values of which we live by in today's society. And I believe that this bill reflects that, and it reflects, once again, the dignity and respect that we're going to give to those that would fall under the laws that are contained within this legislation. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Peace River Westlock.
Thank you, Mr. Speaker, and it's my privilege to rise today to speak to C-51. Mr. Speaker, just the very word C-51 harken back to during my the election, the last election. I do recall the then opposition, now the government party, very much made a lot of noise about a particular bill, C-51, from the last Parliament, and I know that they also made a lot of noise about omnibus bills, and that was one of the things I heard a lot about. And so it's kind of ironic today that two of those things that are forever burned in my memory are now coming again up today as we discuss this current C-51 when it comes to and this particular omnibus bill. Before I go any further and before I forget, Mr. Speaker, I'd like to just notify you that I'll be sharing my time with the member from Provencher as he's giving me some hand gestures telling me to remember to share my time with him. So I will definitely be doing that. Now, getting back to the omnibus bill, Mr. Speaker, this is specifically why we never we had used, as far as I'm aware, we had used omnibus bills when we were in power, when the Conservative Party was in power. They were a tool that was available to the governing party at the time. We made no apologies for that, and we did that. I wasn't here at the time, but I do know that that was a practice that was loudly protested by the Liberals in particular. And I know that I heard about that particularly in the faraway places of the Promised Land up in northern Alberta, where I'm from. I heard about that repeatedly on the campaign trail, that it was the Conservatives, they used this omnibus legislation. So I had to do some research as to what omnibus legislation was, and it turns out, Mr. Speaker, that it's legislation that affects more than one bill or one act of Parliament of Canada. And so it seemed logical to me, but for some reason the Liberals seem to make this out as to be an evil and a wrong thing. And to their credit, I guess, is that omnibus sounds kind of omnious, I guess, and that was what they were going after with that whole line of attack. And so it is overly interesting today. Wow, we're fireworks here today. Such is the bluster. So it is kind of ironic, I guess, that we were standing here today discussing an omnibus bill when this could be there's much ado about the rest of the bill we're in vast agreement on many parts of it. So I want to point that out. And we've seen over and over again members stand up and say, well, it's ridiculous, Mr. Speaker, the fact that party over there is asking us about omnibus bills because they seem to have no problem using omnibus bills. Well, Mr. Speaker, that's precisely the point, is we never promised to not use omnibus legislation. They were the ones that were accusing us of doing all kinds of things with omnibus legislations, and there was something inherently wrong with omnibus legislation. Now they're the ones using omnibus legislation to roll out their agenda, which is perfectly within their right. But the very fact that they accused us and ran on the platform of not using omnibus legislation proves to me, Mr. Speaker, how they were willing to say whatever it took to get elected. It never had to be anything of substance. It was just omnibus legislation. Well, it sounds terrible. It must be a terrible thing. So we're gonna run on the fact that we're not gonna use omnibus legislation. To me, it was absolutely ridiculous. Yeah, never mind electoral reform, but that's a whole nother topic. That's a whole nother topic for sure. But it just goes to show that the Liberals can make a promise about something during an election and then completely, well, we didn't know what we were talking about, or no, well, if they did it too. Well, Mr. Speaker, this is what elections are won and fought over, is that you say you're going to do something, then you have to live up to that. The consequences will be borne out of what you said. But we all understand that you sometimes need to do omnibus legislation. It's what it takes to change several different acts when you're trying to implement a particular idea or a particular thread. That seems to make perfect sense, but the Liberals, in fact, on the last election ran that they wouldn't introduce omnibus legislation. That brings us to a bit more of the substance of the bill. I'm pleased to say that Section 176 has been removed at committee out of the bill, and I must say that I'm quite perturbed as to why that particular section was in the bill in the first place. It seems to me to indicate that the Liberals are completely out of touch with Canadian culture and Canadian society when on the just a media news scan of every day, you see that crimes against religious institutions or crimes against religious people seem to be on the uptake around the world, to see that this section 176 was put in this bill as a cleanup piece. This is an obsolete piece of legislation that we no longer need in our Canadian society. To me, throws into question a number of the Liberal priorities. Like, why are they saying that this is not needed? Why is the protection of the clergy or the protection of religious institutions and their buildings, why is this not needed in modern day society? Well, they said, well, it was only one particular religion. Well, when we checked, Mr. Speaker, we asked, do imams, do they claim some of the tax credits that are available to the clergy? And yeah, indeed they did. And were rabbis gaining those same, were they classified as clergy under Canadian law? And indeed they were. And so this seemed to be completely unrelated to reality. So we also did a bit of a check, Mr. Speaker, as to has there been changes in terms of the crimes being perpetrated across the country, and we've seen that religion accounted for 35% of the targeted hate crimes in 2015, Mr. Speaker. So this is completely out of touch, in my opinion, to introduce Section 176 in a so-called cleanup bill when the reality is quite the opposite. And I've seen a significant amount of mail that came from my riding, a number of emails and mails. I had over 176 responses from people from across my riding concerned about this being removed. And we've seen that even at committee members also mentioned the fact that this had seemed to spark a significant amount of feedback, this particular section of this bill. And so I'm happy to see that the Conservative members at the committee were able to convince the rest of the committee that this was not necessary, that they should remain, this part should remain in the criminal code, and I'm happy to see that it did stay in there. Mr. Speaker, once again, we need to ensure that religious communities across this country are able to worship in a manner where they seem faith, and then they're not prevented from worshiping. One of the pieces of legislation that was considered to be removed from the criminal code was the prevention of a clergyman to get to his place of worship in order to hold the worship service. And that to me, Mr. Speaker, that is very important, that we ensure that our clergy can do their duties, that they can fulfill their job without harassment and without worry of being detained along the roadway. And Mr. Speaker, I'm not sure how often this piece of legislation has been used in the past, and I'm not sure if even most of the clergy were aware that they even had this protection from the criminal law. But I must say that after this particular bill was introduced, we've seen a dramatic uptake in the education on this, and also the realization that, hey, there are these protections in the law. And so I'm happy to see that has gone in here. Mr. Speaker, I got basically a graph here of all the particular hate crimes in the country, and we see that religion is among the highest levels of hate crime motivations across the country. It ranks between race and ethnicity, and then others is what the other thing. So we see that it's a significant part of the motivation, and we want to ensure that our religious communities feel safe and that our religious communities are therefore protected by the criminal code. And so I finish with, I feel that the bill, I had some more stuff to talk about, Mr. Speaker, just about the sexual assault thing, and I have some concerns with the way that the bill is continuing to go, and the fact that I think that the duty for evidence needs to come from the accused, and we need to ensure that all evidence, regardless of when or where it is acquired, can be seen and heard at a trial. And so I have some concerns about there, but I'm at this point I'm supportive of this bill. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Families, Children and Social Development.
Listen to the member opposite describe this as an omnibus bill, and I'm curious as to how he comes to the definition. every single measure in this bill relates to one specific ministry. It's not like Bill C-43 that sort of scattershot affected legislation across, I think it was every ministry. Things as unrelated as land rights issues connected to ports, as well as the cost of certain taxes going up, as well as a whole series of measures that had nothing to do. In fact, they weren't even announced in the budget. They were slipped in the back door through what was everybody called an omnibus bill. When you look up the legal definition and the parliamentary tradition of what gets constituted as an omnibus bill, and the member's free to challenge it to the chair to get it split. But the reality is that this bill is completely unified insofar as it reforms the criminal code around evidence, around sentencing. It reforms the criminal code around obsolete laws that don't need to be on the book. I'm sure the member opposite doesn't worry about crime comics causing us a problem in his riding. I guess under what definition does this constitute an omnibus bill when every single measure is introduced by a single minister, and every single measure has to do with the criminal code, and every single measure is related to the reform and the updating of the criminal code system, in particular for the protection of individuals who are sexually assaulted. This is good progressive legislation, and further, the committee that passed it didn't worry about it being an omnibus bill. In fact, the committee passed it unanimously, and your party supporting it.
For Peace River Westlock.
Thank you, Mr. Speaker. And my point on the whole omnibus bill thing was that even his defense of the not being an omnibus bill, this is definitely not an omnibus bill, is the very fact that this is what they ran on. They ran on the fact that they weren't going to pass, or they weren't going to introduce omnibus bills, and then proceed to introduce omnibus bills, and then say, well, when you guys did it, it was bad, but when we do it, it's amazing. So that's the hypocrisy. That's the hypocrisy of all this. We never this is the whole frustration that I have with this Liberal government is that there seems to be one rules for all of Canadians, and they've accused former governments of doing particular things just to get elected, and now when they're in government they realize that, oh, these are good tools that governments need to use in order to pass legislation, and they're using those very tools. And then when we call them out on it, saying, hey, you promised in your platform. This wasn't our platform, Mr. Speaker. In your platform, you promised you weren't going to do this. Then when they do it and we call them out on it, they say, well, you guys did it too. You guys did it too. It's ridiculous, Mr. Speaker. Thank you.
Questions and comments? The honourable member for Elmwood, Transcona.
Well, thank you very much, Mr. Speaker. I want to thank the member for his speech. It had a lot of pop. And although for reasons outside of his control, I think was a little less bright than the last speech that was given. On the theme of omnibus bills, I think maybe there's a misunderstanding. I wonder if some of my Conservative colleagues thought that what was offensive about omnibus bills was their simple length. I would argue that what defines an omnibus bill has more to do with what you might call its thematic unity and the number of different kinds of statutes that it amends and whether the issues are related one to the other. So I wonder if he could just provide a little more clarity for the House. When Conservatives talk about omnibus bills, what do you take to be an omnibus bill? Or what do they take to be an omnibus bill, Mr. Speaker? Is it defined by simple length alone, or does thematic unity play a role in determining whether a bill is an omnibus bill or not? And if so, in what ways does thematic unity bear on the question of whether a bill is omnibus or not?
The honourable member for Peace River Westlock.
Thank you, Mr. Speaker. Well, this is precisely my point again, is that it wasn't us that were saying that omnibus bills were a problem. It was the Liberals that championed this in their platform, and that is exactly what I'm addressing today. So the definition of omnibus bill, I think as they put it out in their platform, was that a piece of legislation that amends more than one thing at one time. That's exactly what we have going on here today, is a piece of legislation that amends several pieces of the law all the way through that aren't necessarily tied together. If they wanted to repeal the entire Criminal Code Act and bring it back in, I guess that wouldn't be bring in something different. That wouldn't be an omnibus bill. But we have this scattershot all over the place bill that amends some things, takes some things out, puts other things in, deletes other things altogether. That is, in my terms, an omnibus bill is something that doesn't. It may have a theme, but it doesn't necessarily. But get back to, I feel like I'm defending something that I don't even want to defend, Mr. Speaker. I don't really care if you introduce omnibus bills. This is what the Liberals championed. This is what they ran on in their platform. Why are they abandoning it today? Thank you.
Resuming debate, the honourable member for Provencher.
Well, thank you, Mr. Speaker, and thank you to my colleague, the member from Peace River Westlock, who I think did a great job of expanding on this bill. And it is indeed a real privilege for me to stand and speak about Bill C-51. I think the last time I spoke about Bill C-51 is about 2 years ago when the Minister of Public Safety introduced it as an anti-terrorism measure, and I was very happy to work on the Public Safety Committee at that time and be part of the drafting or the committee work that brought that bill forward, and it was indeed a wonderful piece of legislation which I may remind the Liberals that they wholeheartedly supported. Bill C-51 today is an omnibus bill, as previously mentioned, and so I Googled it just for the sake of understanding maybe what an omnibus is, and it could be a bus, a four-wheeled bus. That is not the case here, but it is also it says here, items previously published separately is what constitutes a bill as being omnibus. And certainly this is an omnibus piece of legislation, something that the Liberals railed against during their time as the third opposition or the third party in this House. And so from that perspective, we're going to talk about it a little bit more, and and it's going to mean that we have to cover a bunch of unrelated items, but they're all stuck in this bill. So the first part of the bill I'd like to talk to is found in Clause 14 of Bill C-51, and it was introduced to remove Section 176 of the Criminal Code. And I'd like to, just for the benefit of the folks watching these proceedings, read the section as it is written today, or as it is being presented. Section A of Section 176 of the Criminal Code, subsection A says, by threats or force unlawfully obstructs or prevents or endeavors to obstruct or prevent an officiant from celebrating a religious or spiritual service or performing any other function in connection with their calling, or subsection B, knowing that an officiant is about to perform, is on their way to perform, or is returning from the performance of any of the duties or functions mentioned in paragraph subsection A. And then subsection B, subsection 1, assaults or offers any violence to them, or part 2, arrests them on a civil process or under pretense of executing a civil process. So Section 176 provided explicit protection in the Criminal Code, which explicitly makes it a crime to unlawfully obstruct, threaten, or harm a religious official before, during, or after they perform a religious service. It also makes interrupting or disturbing a religious service a crime. In a time where there's an increasing amount of violence directed against religious groups and religious gatherings, removing this section made little sense. Yet for some reason, the Liberal government wanted to get rid of the only protection for Canadians performing and participating in a religious service. The Liberals said that attending a religious service was no different than attending a lecture. However, the many and varied religious groups which exist in Canada came forward in one collective voice, speaking one collective message. The message was simple. Religious services and members of the clergy require protection under the law because they are a different kind, different in kind from other sorts of public gatherings. Removing Section 176 would treat the disruption of a religious service as a mere mischief charge. To religious Canadians, a religious service is more than just an event to attend. It is rather a formative experience to their individual and community identity. Disrupting such a ceremony is not a small matter, but an act which offends their most fundamental right to gather in a peaceful assembly while sharing their most cherished beliefs. A mere mischief charge in a time of growing intolerance would not have been sufficient. Indeed, repealing Section 176 seems to show an intellectual disconnect on the part of the Liberals. Like, Mr. Speaker, I'm wondering, what were they thinking by removing Section 176 at a time when we see religious persecution all over our globe? We've seen attacks on religious institutions here in Canada, and then they want to remove the only explicit protection that members of our clergy and members of faith institutions have while they're conducting a worship service. So I want to talk a little bit about my own personal experience, Mr. Speaker, because I grew up as the son of a clergyman. And so I have a pretty good idea, at least in the Christian faith, what a clergyman does and what part of his duties are. And I'm sure it's similar in all faiths. And that's the beauty of Section 176. It's not explicit to the Christian faith. This is protection for clergy, protection for worship services that applies to all faiths, whether they're Christian, whether they're Jewish, whether they're Sikh or Hindu or Muslim. This provides protection for members of the clergy, provides protection in the criminal code for all forms of worship services. I remember clearly as a young man growing up, or as a young person growing up and into my early adulthood, during the times when my father was a member of the clergy, a pastor, and my father died at the age of 51, like one of our colleagues here, from the same very rare throat cancer that one of our colleagues passed away earlier this year from. And he too had a son by the name of Theodore, I might just mention, as did my father. And so my father passed away at an early age, but I do remember the times growing up, the work that my father was engaged in, and some of those things that he did, what he was called upon to do as a pastor, was obviously to conduct worship services on a Sunday morning for his congregation. And that's something that Section 176 of the Criminal Code clearly identifies as being something that will be protected. But some of the other things he did is when he had parishioners or members in the community who had experienced tragedy in their own lives, who maybe had encountered some personal difficulties, found themselves in the hospital with a debilitating disease or life-threatening disease, or facing death, oftentimes the clergy are called to administer comfort to those individuals. And in my father's case, there was many a time when he was able to share the saving grace and power of the knowledge of knowing Jesus Christ to these individuals that were facing imminent death. And it gave them such reassurance and comfort to know that they could put their faith in Jesus and have security in eternal life. And so these were functions that my father performed on a regular basis. I remember hospital visitation was very important to my father. And Section 176 is something that would provide protection for clergy as they're going to visit their parishioners or members in their community that may be suffering from illness or the illness of a family member, and to make those hospital visits. Something else he did is he conducted marriage ceremonies. And you know, that's an important part of everyday life when a man and woman decide that they are in love with each other and they want to commit to themselves to spend the rest of their lives with each other, and they call a member of their clergy and say, listen, we'd like to get married. And it's an exciting part of life, it's a new part of life, and so the clergy are called upon to perform marriage counseling, which is part of the work that clergy do. They give marriage counseling, very important part of the work of a clergy. And so in the coming and going of their particular duties in performing marriage counseling, but also in performing of the actual ceremony, the criminal code through Section 176 would provide protection. And one would ask, well, how often is that protection really required? And people have been successfully prosecuted under Section 176 as to interfering in a religious or worship service, or also interfering or obstructing in a clergyman in the dispatch of his duties. And I think it's kind of like an insurance policy, Mr. Speaker. You know, the comfort of knowing that it's there to provide the protection for you or your loved ones is very reassuring, even though you obviously hope that you don't need it. And our hope, certainly as Conservatives, would be that we will never have to experience a situation where Section 176 of the Criminal Code is there. But it certainly provides a deterrent for individuals that are seeking to disrupt a clergyman in the dispatch of his duties, to disrupt worship service, to disrupt worshipers, parishioners, as they're in a gathering where they're encouraging one another and where they're also expressing their deeply held faith convictions and worshiping the Creator that they serve. And Mr. Speaker, I think there's just lots of good reasons to support Bill C-51, because the Liberals, through many efforts of Canadians right across our country who made their voices heard and their opinions known to the committee, to the Justice Minister, to the Prime Minister. The Liberals listened. They amended the bill. They're going to keep Section 176 in Bill C-51, and I'm happy to, as a Conservative, to support that bill.
Questions and comments? Question commentaire? The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker, and appreciate the comments from my colleague across the way. And you know, one of the things that our Prime Minister often talks about is the importance of our standing committees. And those standing committees, when they sit down and they get the opportunity to go over legislation, they are afforded the opportunity to listen to witnesses from different regions of our countries. What we saw in this particular standing committee is, I believe, a fairly accurate representation that went across all political party lines as concerns and thoughts were expressed, not only at the committee, but also in members of Parliament's ridings and constituencies. I know I was contacted and had the opportunity to share my concerns in regards to it, and through the committee process, that you had that sense of unanimous support saying that, look, can be improved if, in fact, not only do we repeal it, but they also made an amendment to that aspect of it to expand it, to more modernize. And I'm wondering if my colleague across the way can just maybe provide comment in terms of just to what degree at times we can see good, productive work coming out of the standing committees to the betterment of legislation and all Canadians.
The Honourable Member for Provencher.
Well, I want to thank the member from Winnipeg North for the question. And I think it's a good question because we don't often see what we experienced this time in the Justice Committee, coming out of committees when the Liberals have the majority and dominate every committee and can really do as they please. But in this instance, I want to commend the committee, the Liberal members on the committee, the NDP members, and especially my Conservative colleagues for raising what was a very important issue and concern regarding Section 176 and the importance of keeping 176 in the criminal code. The bill had come to committee recommending that section be deleted from the criminal code. And the committee, with an open mind, listened to witnesses from a variety of faith backgrounds and other expert testimony, and they considered it carefully. They heard from Canadians right across our country, from sea to sea to sea. Canadians responded to this issue. They listened carefully to the issue. They had an open mind, and indeed the Prime Minister gave them the latitude to amend the bill and keep Section 176 in the criminal code.
Questions and comments? Yes, commentaire. The Honourable Member for Mount Royal.
Speaker, and I want to thank my honourable colleague for his speech. I also want to say how moving it was to hear him talk about his father. He obviously loved him very much, and I think what all of the members of the Justice Committee heard in terms of testimony was that people of faith see themselves and see themselves being recognized in the criminal code with this section, which is why I think there was unanimous agreement from all parties to retain that section and to expand it even. So I'd like to thank the honourable member for his participation in that effort. I guess my question to him is, does he agree that the retention of 176 basically is not only symbolic, but it allows faith communities to really see that Canadians value their presence in this country?
The Honourable Member for Provencher.
Thank you, Mr. Speaker, and I want to thank the member from who is the chair of the Standing Committee on Justice and Human Rights, who I was very pleased to serve with as the vice chair for 2 years. And I respect his leadership and his chairmanship of that committee. I think he does an awesome job, and he takes a balanced approach. He's willing to listen, and so I commend him on the role that he's done there. And I was actually happy to participate in the debate on C-51 in his committee, and he gave me the opportunity to ask witnesses questions in regarding to exactly leaving Section 176 in the Criminal Code. I am disappointed that the Justice Minister even brought this bill with the removal of Section 176, even presented it that way. I don't know what in the world they or she was thinking, but it was a disappointment to see it, because when Canadians recognized that it was in there, when we as politicians brought it to their attention, they overwhelmingly responded to the Justice Committee, to the Justice Minister, to the Prime Minister. The committee listened and realized that it's hugely important to Canadians that protection for religious services, protection for clergy, for religious officiants be enshrined in the criminal code. We need that protection. It's important to all Canadians that we have that freedom here, and we want to protect that.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Families, Children and Social Development.
Listen, I've been sitting here listening to this description of omnibus bills, and I have to tell you, when I was on City Council and we heard that the Conservative government of Stephen Harper was passing an omnibus bill, we were thrilled. We thought it was a transit plan. We were wrong. It was not a transit plan. But the comparison of that particular bill to this one is remarkable. This one amends the criminal code. It's all contained within one single ministry. And the changes I'll talk to a little bit later, but just to put it by comparison, C-43, which was close to 600 pages long, and this perhaps helps some of the members of the New Democrats remember what a real omnibus bill looks like if they're new to the legislature. But let me just read some of the acts that were changed by that particular bill. The Income Tax Act, the Child Fitness Tax Credit, the Income Tax Regulations, the Excise Tax, the selected list of financial institutions were impacted. There was the Excise Tax of 2001 that was also hit. There was the Intellectual Property Act, the Industrial Design Act, the amendments to the Act of Exclusive Right. There were also the Patent Act impacted, the Biological Materials Act. There was also the Aeronautics Act. There was the Canadian High Arctic Research Station Act. There was the Enactment Act for that. As well, there was also the Transitional Provisions Act, the Consequential Amendments Act, the Access to Information Act. There was the Financial Administration Act. There was the Privacy Act. There was the Public Service Annuation Act. There was also the Criminal Code, which is what we're dealing with here today, one single act. And then there was, as well to that, also the Federal Provincial Fiscal Arrangements Act. There was also the Radio Communication Act. There was also Administrative Monetary Penalties Act. There was the Revolving Funds Act. There was an amendment to that act as well. There was also, under the Minister of Citizenship and Immigration, another set of acts, and that's when they pulled and later went to court and had to have this pulled out because the Supreme Court, I think it was 9 times they overruled some of their changes to the criminal code. But that was where they pulled medical assistance and health care for refugees. It was one of the cruelest acts of Parliament in the history of this country. That was buried in the middle of this act. And I'm not even halfway through this list of acts that were amended. There was also the Royal Canadian Mint Act that was impacted by this omnibus bill. There was the Investment Canada Act. There were amendments to that act as well. There was also related amendments to the Economic Action Plan. There were also the Broadcasting Act was hit, the Telecommunications Act. There was the amendment to the General Administrative and Monetary Penalties Act. There was also provisions applicable to both the Administrative Monetary Penalties Act and the coordinating amendments. And then it goes on and on and on. The Northwest Territories Act was impacted. The Employment Insurance Act was touched. They even opened up the Canada-Chile Free Trade Agreement. There was the Canada Marine Act. That was where the marine ports were given legislative powers and planning powers that superseded municipalities, and nobody was consulted on that. Not even the Marine Act members were consulted on that. That was one of the most egregious things that government did. It gave power to the port authorities to basically override and ignore local planning authorities and local decisions and local plans we made on any property that they acquired. In other words, they could rezone property retroactively after they purchased it, which meant that they could buy low-income property with very low purchase prices, and then suddenly turn it into something much, much more valuable like residential property in order to turn a profit so they could then fund their programs, because they couldn't actually fund their programs based on the way the Marine Act was configured. This drove cities across the country insane because it was so ill-conceived. It ran so roughshod over local planning and local real estate laws that it was amazing that at the end they had to pull many of those provisions off the table because it was such an egregious piece of legislation. But it goes on. There was also changes to the DNA Identifications Act. There were the Establishment and Contents and the Amendments Act that were related to that. There was the Comparison and Profile of Communication Act. There was also the Removal of Access to Information Act that was changed. It goes on. There was the Public Service Disclosure Protection Act. There was also the Public Health Agency. They split the public health, the chief of the Public Health Agency of this country into 2, one that reported to Cabinet and one that reported directly to them. They even went so far into this act with and this is a budget bill, by the way. This was not, all those acts they just changed were administrative changes they made to very important parts of the department. But one of my favorite ones was they also changed the fees. They reduced the fees for bee breeding. They reduced that, but one of the other things they did in that act was they increased taxes on hospital parking. They thought if you were going to visit your mother in hospital and they could find a way to tax that, they would. That was part of what happened out of the Omnibus Bill Act. What we said in our campaign promise, and it was explicit, was that budget bills would remain budget bills. And much of what the NDP complains about when they talk about omnibus bills are our budget enactment bills, which are omnibus bills by their very nature, but they're exactly the kind we promised to sustain. You don't do budgets one clause at a time. When you change fundamental policies across the breadth of government, it's a coordinated budget, it's a coordinated piece of legislation, and we exempted that from our prohibition on omnibus acts. And in fact, the legislation we introduced to prevent omnibus acts, which the opposition has used effectively in this term of Parliament, it excluded budget acts for the very reason that you've got to pass a budget all at once. Otherwise, you end up with 1,000 votes and 1,000 clauses. And I wait to see an NDP government in BC pass the budget clause by clause. It'll take them 6 years to do that. In my sense, after today's damn decisions, they may not have 6 years. But the issue that we're talking about here today are about the reforms to the criminal code. The reforms to the criminal code are extraordinarily important. Yes, there are some of the elements which are nuisance laws. There used to be a law prohibiting crime comics in this country. That's being taken away. There's some sort of rules and regulations that have sort of existed and been on the books for a number of years, which just don't make any sense anymore. Those are being cleaned up as part of this process. But we're also bringing forth some critically important changes to the way sexual assault is prosecuted in the courts, and we're making steps to protect women and other people and other vulnerable individuals who are sexually assaulted. Those are a comprehensive set of rules and regulations that tie together evidence laws, tie together some of the practices and procedures in the court system, and they need to be brought together in a bill because that's the way you do it. If you're going to make comprehensive change, you have to make comprehensive change, and that means you unite issues and items that are related under a single ministry or a single statute or a single set of laws like the criminal code, and you make those changes as part of a comprehensive process. That's what's happening. This is not an omnibus bill. This is amendments to the criminal code. This is the legal bill coming from the Minister of Justice, and it's an appropriate set of bills. The last thing I want to talk about is the changes that have been made. I was a member of Parliament in the last session and watched as committees refuse to entertain any conversation with anybody. That included not only the opposition, but the witnesses. It also, and there were a number of times when Conservative members would come and say, you know what, there was a mistake made in the drafting of the legislation. I can remember one in particular around pharmacare and pharmacy regulations. And every single witness, the doctors, the hospitals, the patients' rights groups, the medical officials, the science community came forward and said, you've made a small mistake here. And one of the opposition members said, I know we've made that mistake, but we're not allowed to fix it. The Senator said we entertain no motions of change at all, ever. And in fact, you'd be hard-pressed to find an amendment that was made to any bill that was presented at any committee over the last 4 years. What we have in this process is, yes, a piece of legislation was drafted, and through the committee process, with good evidence from Canadians coming forward and listing that evidence, and members of the opposition and members of the government talking about how to make a bill better, which is the committee process, rules were changed. And the law was changed. And that's as it should be. The notion that you can land a piece of legislation perfectly and never make a change to it ever again is absurd. It's the wrong way to approach Parliament. It's the wrong way to approach committees. It doesn't mean that every opposition motion or amendment gets passed. That is that's wishful thinking, quite frankly. But what it does mean is that when a good suggestion comes forward, the committee should take seizure of that issue and the points raised and should modify laws. That's the way good committee process works. That's the way good Parliament works. And we're being told we're weak because we did it, or that we made a mistake because we did it. The arrogance that suggests, as the previous government did, and you saw it time and time again with the Harper government, that when they landed legislation that was perfect and should not be debated in the House, let alone changed in committee, let alone listened to by Canadians, even the Senate, which they had the majority in, they wouldn't entertain motions of change. And so the legislation was paralyzed from the point of introduction to the point of enactment. That's not good democracy. That's not good government. And that certainly isn't good parliamentary process. So yes, a motion was changed. I expect good debate to change motions and to make them better. Because as the Prime Minister often says, better is always possible. And the opposite side often has good ideas. I've sat with them in conversation about a number of different projects and a number of different proposals and asked them to push us and to get us to a better spot. Because as I said, that's the way good legislation emerges. And we're here to listen and to talk. And we're here to debate. But we're also here to have conversations. And when those conversations result in reasonable propositions coming forward that fix legislation that make it better, this government, as a good government, is always going to be there to listen to Canadians, to listen to parliamentarians, to listen to caucus, to listen to differing views on all sides of the issues. And I'm proud to be part of a government that does that. I'm also proud to be part of a government that has put mechanisms in place now for the procedures of this House, that when a complex bill moves forward and the Speaker is asked to rule on whether or not it's an omnibus bill or not, there is a methodology in place now and a process in place that allows that bill to be split so that people can express their votes differently in different parts of the legislation. That's not a bad thing. That's a good thing. It doesn't mean that every one of the bills we present is again, perfect. We're not expecting perfection on any side of the House here. What we are looking for is honest effort, good contributions, solid thinking, wise Canadians being brought to this to Parliament to participate in the committee process so that all Canadians, when they see legislation passed, they can see their voice reflected in it. And I'm going to close by again reminding you that the omnibus legislation that the opposition talks about it's ludicrous to suggest you can't pass a budget unless you do it clause by clause. Budgets are complete sets of expenditures, of programs, of development. And that's how they will be presented. And the opposition can hue and cry about it all they want. They're wrong. They're wrong. And they're wrong on this legislation. And they're wrong to characterize the other complex bills as omnibus just simply because several ideas under a single ministry are brought together as a comprehensive set of reforms. That kind of complaint is really just, well, a former New Democrat in Toronto used to talk about it. When the opposition complains about the process, they've conceded the argument. And all they're trying to do now is just gum you up with a conversation about process. And we've seen that happen a couple of times in the House this session. The reality is that when you bring forth legislation that gives the opposition the right to challenge legislation as omnibus, they can avail themselves of that process. Why aren't they doing it on this bill? Because on this bill, they happen to understand why the bill's being brought into concert. They understand the process it went through as it went through the committee process. And as you hear the opposition talk, they effectively support the bill. What are they talking about when they complain about the bill? They complain about something that was taken out already. In other words, they're complaining about being listened to. And if the opposition is going to be complaining about what they're being listened to, how else are we going to engage with them if they're not going to talk to us anymore? How else can we engage with them? When we listen to them, it's a good thing. They should be thanking us for it. And instead what they try to do is they try to knock us down because of that. That's absurd. So this legislation, which is on its last few hours of debate, is an incredibly important piece of legislation, as I said, for the reform of the way sexual assault is treated through the legal system. It also gets rid of a bunch of laws that really shouldn't be on the books anymore. And every now and then, governments need to do that as part of a criminal code reform. And at the end of the day, it's going to be supported by the bulk of the members in this House, I believe, based on the speeches I've heard today, because it, in fact, did work with consensus and did work with the committee and did work with the committee chair to get the changes that needed to be made. And for that, I'm happy. But if you'd like to go back to debating omnibus bills, I have C-43 in front of me. I also have the other omnibus bills that Conservatives passed. And let me tell you, if you want disconnected pieces of legislation that goes off in all directions at once, sound and fury signifying, unfortunately, too much and too little, you can refer back to the previous Parliament. And you can talk about real omnibus legislation where real changes to fundamental policies that affect Canadians were slipped in. Not mentioned in the budget speech, not printed in the budget book, not brought together as a cohesive or coherent economic argument, but simply added to a budget bill and then made it into a mandatory vote with no changes being proposed at committee. That's what an omnibus bill is. And this is not an omnibus bill under any definition of the word. Thank you.
Questions and comments? Questions and commentaires. The honourable member for Edmonton Strathcona.
Thank you, Mr. Speaker. Mr. Speaker, I had to stand here because of the speech that colleague across the way has just given, talking about how his government is open to amendments proposed by the opposition. So, Mr. Speaker, let me share through you an experience that seems to counter what the member is saying. In my committee, I've brought forward a number of amendments to a bill that the government brought forward, and the amendments that I brought forward were actually amendments that were recommended by the majority Liberal committee. And yet, my committee, which is a majority Liberal committee, has rejected those amendments. So perhaps the member could explain to me what is the purpose of members of the opposition working hard, looking at a bill, looking at what committees were recommended, considering what witnesses have said that have come forward to strengthen a bill, and then just flat out rejecting, presumably because the government of the day doesn't want any amendments.
Honourable Parliamentary Secretary to the Minister of Families and Children.
Well, I'd have to look at the particular amendments that she's speaking to. I know that as a parliamentary secretary, it's expected that I vote with the government each and every single time, but yet I know that I've got the freedom to stand up in this House and support amendments that are tabled, opposition private members' bills. We have much more latitude as a government than I think any other party that has ever ruled this House has ever had the opportunity to have. When it comes to the particular committee and the particular amendments, without being given the exact example, it's hard to comment specifically. What I do know is that in the process of evaluating opposition proposed amendments, consultation happens, and we don't just consult with the people that appear at the committee. We also talk to staff members in departments. We also talk to other members of caucus, and sometimes unintended consequences of proposed legislation gets a reconsideration. What I can say, and I've talked to members of the opposite side, is that fundamentally sound amendments that come forward that we agree with, we will vote and we'll support. And we don't look at the origin of the amendment in order to support it. We take a look at the essence of the amendment, the essence of how that amendment might affect the legislation that's in front of us, and we make a public decision about what we can and can't support. It's a dialogue. I assure the member opposite, reasonable amendments that we agree with. If we disagree, we're not going to support them if we disagree with them, but reasonable amendments where we can come to a consensus, you will get the support of members, and no member of this committee, and I sit as the parliamentary secretary on a committee, I've never told a single member of that committee how to vote.
Questions and comments? The Honourable Member for Cowichan, Malahat, Langford.
Thank you, Mr. Speaker. I have the great honor of serving as one of the vice chairs on the Standing Committee on Justice and Human Rights, and I have to honestly say in this House, like I've been on a few committees, but the Standing Committee on Justice and Human Rights, I have never had a better experience in this Parliament. I think everyone who serves on the committee approaches their job with a lot of care, compassion, and responsibility, and I think it's because of the nature of the subject matter that comes before the committee. And, my experience on that, whether dealing with various studies on access to justice or criminal justice bills, has always been a positive one, and I feel that we always have very good conversations with that respect. And we did make some good amendments that reflected the popular will of the people, notably with Section 176. I myself received an avalanche of correspondence from people all across the country for whom Section 176 had deep symbolic value, and I'm glad that all parties could come to an agreement on leaving that section in. Now, my question, Mr. Speaker, the Minister of Justice has stated many times that criminal justice reform is very important to the Liberal government, and while we have C-51 before us and we're about to send it off to the other place, I was wondering if the Parliamentary Secretary could add some comments on the status of C-39, because that has some incredibly important provisions that need to be amended in the Criminal Code. We've heard reference to the Vader case, an incorrect verdict was rendered because of an obsolete section of the Criminal Code. It also deals with the section that still criminalizes abortion. And I'm just wondering if criminal justice reform is so important to this government, and we are now past the 2-year mark, can he offer any insight as to when we will see further steps in this government's agenda on criminal justice reform? Thank you.
Parliamentary Secretary to the Minister of Families, Children and Social Development.
So, criminal justice reform is, after 10 years of the previous government, badly needed. And you see the impacts of it in the city that I represent daily, monthly, yearly. And so as we move forward with a comprehensive, new approach to criminal justice, you will see collections of bills move forward under the minister with the Minister of Justice. One of the issues that I'm concerned about is the arbitrariness by which judges are being treated, and some of the mandatory minimum sentences which remove the ability of judges to do what they're paid to do, which is to listen to evidence and make decisions based on evidence presented in court and not ideology presented on the floor of Parliament. It doesn't mean that all mandatory sentences are bad. I think in extraordinarily serious cases, we know that there are standards that the society expects us to sustain. But we have in our city a situation where quite often young people who are charged with having a gun are on a 5-year cycle, coming in and out of jail, going into jail and coming out together. And you can almost guess neighborhood by neighborhood, year by year, which community is going to be impacted, because 5 years earlier there is a raid in that community and everyone goes into prison together and everyone comes out of prison together, and there's been very little reform. We also know that in the criminal justice system, a lot of the programs that were present, I mean, it's not just the prison farms that were canceled. A lot of the reform practices inside the Canadian penitentiary system were stripped from as part of budget cuts, and it's left people, prisoners and inmates coming out of prison who have served their time in a horrible state. And we know that it needs to be changed on a whole series of those fronts. We also know that in Ontario in particular, that the incarceration rate for Canadians of African descent, for Black Canadians, is off the charts. Young people in our cities that are of Caribbean descent or African descent or have been here for 200 or 300 years are being charged differently, sentenced differently, and do their time differently. We know that criminal justice needs to be reformed, and so I look forward to the conversations with a committee that is clearly working well. I look forward to the amendments that I know the Justice Minister is working on to bring forward some of these changes to make our criminal justice system protect Canadians, but also reform criminals so we don't have to deal with repeat offenders. We need to make sure we get smart on crime, not just tough on crime. And the previous government was so convinced that it could just punish its way into a safer Canada that I think, quite frankly, it lost sight of the fact that we actually need to reform people who are prisoners to change their behavior because they're getting out at some point. And we need to allow for the way in which the people come through the prison system to also be changed. And that involves not having mandatory minimum sentence necessarily, but having the appropriate sentences with the appropriate reforms, with the appropriate rehabilitation all put in place so that we protect people, but we also protect society in the long run. And when I hear the opposition talking about a collaborative process and a process of consensus, it makes me very happy that the conversations are going to be rich ones, that they're going to bring the full experience of all Canadians to the table when decisions are made. And I look forward to the legislation that he's talking about being further debated, but I also look forward to other changes to the criminal code moving forward as well, because we need, as I said, to get smart on crime, not just tough on crime. We need to make Canada safe, but we also need to make sure we keep Canada safe by making sure the prison system doesn't create more criminals.
Questions and comments? The honourable member for Victoria.
Across the way, I'd like his thoughts on the one part of this bill that is not simply amendments to the criminal code, but rather to the Department of Justice Act, which I guess is why some are calling it an omnibus bill. I don't agree with that. But that this charter statement should accompany every government bill, be it criminal or not criminal law. I wonder if the member could give us his comments on whether he thinks that really adds much value to the way we do business in this House.
Honourable Parliamentary Secretary.
Well, I think it does. I think that when we surface the Charter and the way the Charter frames legislation, I think what it does is it gives us a sense that the laws that have been presented here have been thought in context with the Charter. I think in the previous House, in the previous session of the Parliament, I think we saw bills that were immediately struck down by the Supreme Court. And while the Harper government loved to sort of jump and shout about its wonderful legislation, the reality was it wasn't Charter compliant, and as a result, people's lives were impacted, and a whole lot of time was wasted, quite frankly, because they didn't respect the Charter as they drafted legislation. And so while not every single bill necessarily has a weighty argument attached to it, I think every bill that's drafted and presented as law and presented as government policy should be Charter compliant and should be screened against that. And I think that does add information and context with a bit more than simply guessing at whether it's Charter compliant. You know what the government lawyers and what the departments thought of the legislation as they drafted it. I think it's good information to have. It doesn't mean that it necessarily is Charter compliant. The judges have a role and the judiciary has a role, but I think it's a worthy comparison. I also think in very contentious issues, it's important to start thinking about the Charter at the beginning of the process, not just after the bill's gone through the Senate and gone on to royal assent. So I think it's part of an enriched environment that puts the Charter at the center of what we do here, and that means people's rights are at the center of what we do. And as you can see from our national housing strategy, that's the way this government likes to roll.
Resuming debate, the honourable member for Cowichan, Malahat, Langford.
Well, thank you very much, Mr. Speaker, and it's indeed a great honor to be standing to, I think, be the last speaker today to speak on this particular bill. I think I want to start off by thanking several of my colleagues who had to cover for me in the earlier part of this session when, due to a family situation, I was unable to be here for the first sitting weeks of Parliament and unable to participate in the Standing Committee on Justice and Human Rights. But that was right during the time when C-51 came before the committee, and I just really want to signify my appreciation for the colleagues who did that important work on my behalf. Now, C-51, I have heard comments in this House referring to it as an omnibus bill. I would have to, with respect, disagree with those comments. I think omnibus legislation, the true sense of the word, refers to a bill that amends multiple different federal statutes, whereas with C-51, I think we see all of the amendments are grouped thematically and really centered on cleaning up the criminal code, cleaning up those redundant and obsolete sections, clarifying the language, and also providing some direction to the Minister of Justice in providing a charter statement. There, of course, there are some consequential amendments to other acts and transitional provisions, but I think that on the face of it, C-51 is an appropriate bill, and some may balk at the length of the bill, but I would say to those members that just underlines the state that our criminal code is in. The criminal code, of course, is a very massive federal statute. It's been added on over decades, and it's a section. It's a law that needs a lot of cleanup. In fact, legal scholars have been calling for us to act on these provisions for decades now. They have resulted in some real problems in case law. And the thing about the criminal code is unless Parliament provides for the amendments, the copy of the criminal code gets faithfully reproduced with all of its mistakes year after year. I will say that with respect to the charter statement contained in the bill, that's something that, you know, it is heartening to see. I think that, you know, I will commend the government on starting that process where the government at least puts forward its arguments with respect to why it thinks a particular piece of legislation infringes on the charter and why it thinks it's going to be okay, because I think that is a starting place for us to have a fulsome debate in this place. As to whether we will always agree with it, that of course remains another question, Mr. Speaker. And of course, you know, we are encouraged that the sections that help clarify Canada's sexual assault laws are in there. I think that, you know, when we talk about our sexual assault laws, the big topic of conversation in Canadian political discourse, in our public discourse, is on consent. And I think that we need a lot of education amongst our youth, amongst all members of society, on what consent actually means. It's one thing to codify it in the criminal code, but not many people outside this chamber and outside the court system have the opportunity to read the criminal code. I think we also need to have that robust public education campaign to make sure that everyone in society knows exactly what consent means and what the ramifications are of it. On the sexual assault provisions, Mr. Speaker, I will just go over a few of the things that the legislation is aiming to do. It's aiming to clarify specifically Section 273.1, which is going to reflect the Supreme Court's decision in RVJA, and also amending Section 273.2, which clarifies the defense of a mistaken belief in consent. It's not available if the mistake is based on a mistake of law. So, for example, if an accused believed that the complainant's failure to resist or protest meant that the complainant consented. This, was a pretty heavy part of the committee's study. This part of the bill is quite complex. Where a slight turn of the phrase, a different word use can have certainly some big ramifications. And, when I was on that committee, and of course thanks to my colleagues who took my place during some of the important testimony that we heard, a lot of that testimony really informed some of the amendments that the NDP made at that committee. We made 3 main amendments. Unfortunately, were not passed at the committee, and while I respect my Liberal colleagues' arguments against those provisions, I think the law is an organic thing. We do our best to write the law in this place, but of course it is going to have to withstand the test of time within our courts, and I think ultimately those will be the judge of who was right and who was wrong in this case. But, with respect to the amendments that we tried to move at committee, Mr. Speaker, we tried to amend Clause 10 to basically clean up the language to include the reason that the complainant does not have the capacity to understand the nature of the activity or is not aware that they are obliged to consent to the activity. So we were concerned that the definition of incapacity may not have been entirely clear. There were some questions concerning, over whether the law was relying too heavily on a person being unconscious and not looking at other forms of incapacity, such as being drugged or something like that, because someone may not necessarily be conscious or unconscious, I should say, but could still have the incapacity to consent to the activity that's going on. We also heard the need regarding a complainant's expectation of privacy, so we tried to move an amendment that sort of reflected the fact that the committee had heard that there is a need to clarify the admissibility of a complainant's private records at trial when in the hands of the accused. And so we heard some really great testimony from Professor Emma Cunliffe of the Peter A. Allard School of Law at UBC. So, I was proud to try and move those amendments, Mr. Speaker, and argue as forcefully as I could, but ultimately to no avail. But I still respect the work that we did on that committee. And, we are finally at a stage now where C-51 is on the launching pad and I think ready to go off to the other place. Also, Mr. Speaker, this bill seeks to clarify and amend a number of sections of the Criminal Code which are redundant and obsolete. And of course, some of those sections I can go over. It repeals Section 71, where you could provoking a person to fight in a duel or accepting such a challenge. Of course, in modern Canadian society, that is no longer going on. Advertising a reward for the return of stolen property, no questions asked, under Section 43, and of course the possession of crime comics, which in another age in Canada people thought would corrupt our youth. And of course we know that to be a little bit outdated in this day and age. One of my favorite sections was repealing the section where you were fraudulently pretending to practice witchcraft. I mean, these sections just serve to show how out of date many sections of our criminal code are, and of course why we have need of this particular section. Mr. Speaker, I think I'll end on I think what was one of the most positive parts of our study of this bill, and that has to do with Section 176. When you first read the bill at second reading, Section 176 was just simply a line item that it was going to be repealed. And it became obvious over the summer months that this particular section had deep symbolic value to many religious communities across Canada. And I know that I and many of my colleagues in this chamber received a lot of correspondence from people who felt that that section should be kept in the criminal code because of today's climate of religious intolerance. And I believe that that would have sent the wrong message. So I'm very pleased that we as a committee came together, all parties, to keep that section in, the fact that we reached consensus to modernize the language, and so on and so forth. So I think with that, Mr. Speaker, I will just sort of end on the fact that this bill is an important first step. We in the NDP are eagerly awaiting news from the Liberal government on when it will be moving ahead with Bill C-39, because that includes some very important provisions of the criminal code that need to be dealt with. And I hope that this government, with its emphasis on criminal justice reform, heeds those requests and moves forward with that particular bill. And with that, Mr. Speaker, I will conclude my speech, and I appreciate this opportunity to speak on this bill. Thank you very much.
Questions and comments? Question commentaire, the honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I do agree with my friend that this bill is moving forward and removing things that are archaic. I wonder why, though, we have not dealt with something called the Zero Tolerance for Barbaric Cultural Practices Act from the last Parliament, which made illegal things that are already illegal, like killing someone because they marry outside the family's wishes, or forcing someone into an illegal marriage. All of these things were already illegal, and I believe the Zero Tolerance for Barbaric Cultural Practices Act belongs in the same category as banning witchcraft.
The honourable member for Cowichan-Malahat Langford.
I thank my colleague from Saanich Gulf Islands for the question. I think her question illustrates, of course, the work that the comprehensive reform that is needed with respect to the criminal code, and I am in complete agreement with her. While I was not fortunate enough to sit in the previous parliament, I did work for the great Gene Crowder, and of course we were opposed to that particular motive of the government to lump those kind of crimes in, and I think that absolutely that is a section that needs to be looked at. Again, I'll have to go back to my comments on C39. We hope that with this government being serious or purporting to be serious about criminal justice reform, that we get to see some movement on those important bills coming in the near future.
Questions and comments? Yes, commentaire. I do think we have time for one more question at least. I'm sure that some honourable member may have a question. The honourable member, no? Questions and comments? Resuming debate. Reprise de débat. La Chambre est-elle prête à se prononcer?
Is the House ready for the question?
Yes? The question is as follows. Ms. Wilson-Raybould, seconded by Mr. Sajjan, moved that Bill C-51, an act to amend the Criminal Code and the Department of Justice Act, and to make consequential amendments to another act, be now read a third time and do pass. Is it the pleasure of the House to adopt the motion? Yes? Yes? Yes. Carried.
Third reading of this bill, troisième lecture de ce projet de loi.
Order. It being perilously close to 6:30 p.m., pursuant to an order made on Thursday, December 7, 2017, the House will now proceed to the taking of the deferred recorded division on the motion at report stage of Bill C-24. Call in the members.
Order. The question is on motion number 1. A vote on this motion also applies to motions numbers 2 to 4.
Ms. Bergen, seconded by Ms. Boucher, moved that Bill C-24 be amended by deleting Clause 1. All those in favor of the motion will please rise.
Ms. Bergen.
Ms. Bergen.
Mr. Nicholson.
Mr. Nicholson.
Ms. Finley.
Ms. Finley.
Mr. Blaney Berchas Levy.
Mr. Blaney Berchas Levy.
Mr. Allison.
Mr. Allison.
Mr. Kent.
Mr. Kent.
Mr. Poiliev.
Mr. Poiliev.
Mr. Fast.
Mr. Fast.
Mr. Bernier.
Mr. Bernier.
Mrs. McLeod Campbell Thompson Caribou.
Mrs. McLeod Campbell Thompson Caribou.
Mrs. Block.
Mrs. Block.
Mr. Clement.
Mr. Clement.
Mr. Van Loan.
Mr. Van Loan.
Mr. Albus.
Mr. Albus.
Mr. Doherty.
Mr. Doherty.
Mr. Polius.
Mr. Polius.
Mr. Barlow.
Mr. Barlow.
Mr. Bertod.
Mr. Bertol.
Mr. Deltel.
Mr. Deltel.
Mr. Chong.
Mr. Chong.
Mr. Reed.
Mr. Reed.
Mr. Workington.
Mr. Workington.
Mr. Strahl.
Mr. Strahl.
Mrs. Stubbs.
Mrs. Stubbs.
Mrs. Vecchio.
Mrs. Vecchio.
Mr. Abutayev.
Mr. Abutayev.
Mr. Kelly.
Mr. Kelly.
Ms. Gladue.
Ms. Gladue.
Mr. McColman.
Mr. McColman.
Mr. Tilson.
Mr. Tilson.
Mr. Warwa.
Mr. Warwa.
Mr. Sopak.
Mr. Sopak.
Mr. Sorensen.
Mr. Sorensen.
Mr. Miller, Bruce Gray, Owen Sound.
Mr. Miller, Bruce Gray, Owen Sound.
Mr. Brown.
Mr. Brown.
Mr. Richards.
Mr. Richards.
Mr. Nader.
Mr. Nader.
Mr. Brassard.
Mr. Brassard.
Mr. Generou.
Mr. General.
Mr. Anderson.
Mr. Anderson.
Mr. Soroya.
Mr. Soroya.
Madame Boucher.
Madame Boucher.
Mrs. Gallant.
Mrs. Gallant.
Mr. Falk.
Mr. Falk.
Mr. Genereux.
Mr. General.
Mr. Gould.
Mr. Gould.
Mr. Shipley.
Mr. Shipley.
Mr. Van Kesteren.
Mr. Van Kesteren.
Mr. Lake.
Mr. Lake.
Ms. Leach.
Ms. Leach.
Mr. Jennis.
Mr. Jennis.
Mr. Lobb.
Mr. Lobb.
Mr. Albrecht.
Mr. Albrecht.
Mr. Dreeshen.
Mr. Dreeshen.
Mr. Zimmer.
Mr. Zimmer.
Mr. McGuire.
Mr. McGuire.
Mr. Cooper.
Mr. Cooper.
Monsieur Clark.
Mr. Clark.
Mr. Godin.
Mr. Godin.
Mr. Arnold.
Mr. Arnold.
Mr. Lozan, Stormont, Dundas, South Glengarry.
Mr. Lozan, Stormont, Dundas, South Glengarry.
Mr. McKenzie.
Mr. McKenzie.
Mr. Urdega.
Mr. Odega.
Mr. Iglinski.
Mr. Iglinski.
Mr. Diot.
Mr. Diat.
Mr. Kitchen.
Mr. Kitchen.
Mr. Calkins.
Mr. Colkin.
Mr. Liepert.
Mr. Liepert.
Mr. Schmale.
Mr. Schmale.
Mr. Macaulay, Edmonton West.
Mr. Macaulay, Edmonton West.
Mr. Shields.
Mr. Shields.
Mr. Vierson.
Mr. Vierson.
Mr. Waugh.
Mr. Waugh.
Mr. Weber.
Mr. Weber.
Mr. Mott.
Mr. Mott.
Mr. Benson.
Mr. Benson.
Mr. Lloyd.
Mr. Lloyd.
Mr. Carroll.
Mr. Carroll.
Mr. Julian.
Mr. Julian.
Ms. Matheson.
Ms. Matheson.
Ms. Duncan, Edmonton, Strathcona.
Ms. Duncan, Edmonton, Strathcona.
Mr. Christopherson.
Mr. Christopherson.
Madame Laverdière.
Madame Laverdière.
Mr. Cullen.
Mr. Cullen.
Mr. Garrison.
Mr. Garrison.
Madame Boutin-Suite.
Madame Boutin-Suite.
Monsieur Dubé.
Mr. Dubé.
Madame Brosseau.
Madame Brosseau.
Mr. Rankin.
Mr. Rankin.
Mr. Davies.
Mr. Davies.
Monsieur Dussault.
Mr. Dussault.
Madame Moore.
Madame Moore.
Ms. Kwan.
Ms. Kwang.
Monsieur Aubin.
Mr. Aubin.
Monsieur Nantel.
Mr. Nantel.
Madame Quash.
Madame Quash.
Mr. Blakey.
Mr. Blakey.
Madame Sansouci.
Madame Sansouci.
Monsieur Choquette.
Mr. Choquette.
Madame Trudel.
Madame Trudel.
Mr. Weir.
Mr. Weir.
Mr. Duval.
Mr. Duval.
Mr. Cannings.
Mr. Cannings.
Mr. Johns.
Mr. Johns.
Mr. McGregor.
Mr. McGregor.
Ms. Ramsey.
Ms. Ramsey.
Ms. Malcolmson.
Ms. Malcolmson.
Ms. Hardcastle.
Ms. Hardcastle.
Madame Hughes.
Madame Hughes.
Monsieur Barcelou Duval.
Mr. Barcelou Duval.
Monsieur Plamondon.
Mr. Plamondon.
Monsieur Sainte-Marie.
Mr. Saint-Marie.
Monsieur Marcel.
Mr. Marcel.
Madame Posé.
Madame Posé.
Monsieur Fortin.
Monsieur Fortin.
Monsieur Thériault.
Monsieur Thériault.
Monsieur Beaulieu.
Monsieur Beaulieu.
All those opposed to the motion will please rise.
Mr. Trudeau.
Mr. Trudeau.
Mr. Hare.
Mr. Hare.
Mr. O'Regan.
Mr. O'Regan.
Mr. Sargent.
Mr. Sargent.
Mr. Goodale.
Mr. Goodale.
Madame Joly.
Madame Joly.
Ms. Freeland.
Ms. Freeland.
Ms. Chager.
Ms. Chager.
Ms. Qualtrough.
Ms. Qualtrough.
Mr. Bryson.
Mr. Bryson.
Ms. Wilson-Raybould.
Ms. Wilson-Raybould.
Mr. Macaulay Cardigan.
Mr. Macaulay Cardigan.
Madame Leboutillier.
Madame Leboutillier.
Madame Bibot.
Madame Bibot.
Mr. Hussein.
Mr. Hussein.
Mr. Baines.
Mr. Baines.
Ms. Haidu.
Ms. Haidu.
Ms. Bennett.
Ms. Bennett.
Mrs. Philpott.
Mrs. Philpott.
Mr. Casey Cumberland Colchester.
Mr. Casey Cumberland Colchester.
Mr. Easter.
Mr. Easter.
Mr. McKay.
Mr. McKay.
Mr. Nault.
Mr. Nault.
Ms. Scrow.
Ms. Scrow.
Mr. Lausanne Argentin, La Petite Nation.
Mr. Alonso, Argentin, La Petite Nation.
Mrs. Romanato.
Mrs. Romanato.
Monsieur Rioux.
Monsieur Rioux.
Mr. Blair.
Mr. Blair.
Mr. Casey Charlottetown.
Mr. Casey Charlottetown.
Mr. Carr.
Mr. Carr.
Ms. Monsef.
Ms. Monsef.
Monsieur Rodriguez.
Mr. Rodriguez.
Mr. Sohi.
Mr. Ho Sohi.
Monsieur Garneau.
Mr. Garneau.
Ms. Duncan, Etobicoke North.
Mrs. Duncan, Etobicoke North.
Monsieur Duclos.
Mr. Duclos.
Ms. Murray.
Ms. Murray.
Ms. Cara.
Ms. Cara.
Mrs. Cesar Chavans.
Mrs. Cesar Chavans.
Monsieur Cormier.
Mr. Cormier.
Mr. Wilkinson.
Mr. Wilkinson.
Monsieur Lemetti.
Mr. Lemetti.
Mr. Cusner.
Mr. Cusner.
Ms. Jones.
Ms. Jones.
Mr. Rusnak.
Mr. Rusnak.
Mr. Eiking.
Mr. Eiking.
Mr. Bagnall.
Mr. Bagnall.
Monsieur Paradis.
Mr. Paradis.
Mr. McGinty.
Mr. McGinty.
Mr. Scarpellegia.
Mr. Scarpellegia.
Mr. Sims.
Mr. Sims.
Mr. Tansey.
Mr. Tansey.
Mr. Shifke.
Mr. Shifke.
Mr. Varani.
Mr. Varani.
Ms. Goldsmith-Jones.
Ms. Goldsmith-Jones.
Fillmore.
Mr. Fillmore.
Mr. Algabra.
Mr. Algabra.
Mr. DeCourcy.
Mr. Corsi.
Ms. Rudd.
Ms. Rudd.
Mr. Duguid.
Mr. Duguid.
Mr. Miller, Ville-Marie, le Sud-Ouest, Île des Sœurs.
Mr. Miller, Ville-Marie, le Sud-Est, Île des Sœurs.
Mr. Lamoureux.
Mr. Lamoureux.
Mr. McKinnon-Gatineau.
Mr. McKinnon-Gatineau.
Mrs. McCrimmon.
Mrs. McCrimmon.
Mr. Lightbound.
Mr. Lightbound.
Mr. Vaughn.
Mr. Vaughn.
Mr. Mendocino.
Mendocino.
Mr. Poisson.
Mr. Poisson.
Mrs. Lockhart.
Mrs. Lockhart.
Ms. Young.
Ms. Young.
Mr. Jesnevsky.
Mr. Jesnevsky.
Mr. Dollywall.
Mr. Dollywall.
Mr. Pesky-Solido.
Mr. Pesky-Solido.
Madame Mendez.
Madame Mendez.
Mr. Oliphant.
Mr. Oliphant.
Mr. Dubourg.
Mr. Dubourg.
Mr. Alday.
Mr. Alday.
Mr. Amos.
Mr. Amos.
Mr. Anand de Sangri.
Mr. Anis de Sangari.
Mr. Arsenault.
Mr. Arsenault.
Mr. Aria.
Mr. Aria.
Mr. Ayoub.
Mr. Ayoub.
Mr. Badaway.
Mr. Badaway.
Mr. Bayless.
Mr. Bayless.
Mr. Boissonneau.
Mr. Bossino.
Mr. Bossio.
Mr. Bossio.
Mr. Bertina.
Mr. Bertina.
Mr. Breton.
Mr. Breton.
Mr. Chen.
Mr. Chen.
Mr. Bruson.
Mr. Bruson.
Ms. DeMoff.
Ms. DeMoff.
Ms. Dillon.
Ms. Dillon.
Mr. Biddle.
Mr. Biddle.
Ms. Tassi.
Ms. Tassi.
Mr. Drouin.
Mr. Drouin.
Ms. Zerowitz.
Ms. Zerowitz.
Mr. Assassi.
Mr. Assassi.
Mr. Elkouri.
Mr. Alkouri.
Mr. Ellis.
Mr. Ellis.
Mr. Erskine Smith.
Mr. Erskine Smith.
Mr. Aelson.
Mr. Ailson.
Mr. Fergus.
Mr. Fergus.
Mr. Finnegan.
Mr. Finnegan.
Mr. Fisher.
Mr. Fisher.
Mr. Fonseca.
Mr. Fonseca.
Mr. Fragascatos.
Mr. Fragasatos.
Mr. Fraser West Nova.
Mr. Fraser West Nova.
Mr. Fraser Central Nova.
Mr. Fraser Central Nova.
Mr. Fuhr.
Mr. Fuhrer.
Mr. Garrettson.
Mr. Garrettson.
Mr. Graham.
Mr. Graham.
Mr. Gurwal.
Mr. Gowal.
Mr. Hardy.
Mr. Hardy.
Mr. Harvey.
Mr. Harvey.
Mr. Housefather.
Mr. Housefather.
Ms. Hutchings.
Ms. Hutchins.
Mr. Yacono.
Mr. Yacono.
Mrs. Jordan.
Mrs. Jordan.
Mr. Johari.
Mr. Jahari.
Madame Ms. Khalid.
Ms. Khalid.
Madame Lapointe.
Madame Lapointe.
Monsieur Lefebvre.
Mr. Lefebvre.
Mr. Levitt.
Mr. Levitt.
Mr. Long.
Mr. Long.
Mr. Longfield.
Longfield.
Ms. Ludwig.
Ms. Ludwig.
Mr. Maloney.
Mr. Maloney.
Monsieur Massé, Avignon, le Métis, Matane, Matapédia.
Mr. Massé, Avignon, Le Métis, Matane, Matapédia.
Mr. May Cambridge.
Mr. May Cambridge.
Mr. McDonald.
Mr. McDonald.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. McLeod, Northwest Territories.
Mr. McLeod, Northwest Territories.
Mr. Morrissey.
Mr. Morrissey.
Madame Nessif.
Madame Nessif.
Ms. O'Connell.
Mr. O'Connell.
Mr. Oliver.
Mr. Oliver.
Mr. Willett.
Mr. Willett.
Mr. Peterson.
Mr. Peterson.
Mr. Picard.
Mr. Picard.
Mr. Robillard.
Mr. Robillard.
Mr. Rumi.
Mr. Rumi.
Mr. Hota.
Mr. Hota.
Mr. Saini.
Mr. Saini.
Mr. Sanson.
Mr. Sanson.
Mr. Senga.
Mr. Senga.
Mr. Sarai.
Mr. Sarai.
Mrs. Schultz.
Mr. Schultz.
Mr. Seri.
Mr. Seri.
Madame Shanahan.
Mr. Shanahan.
Mr. Sheehan.
Mr. Sheehan.
Mr. Sidu Mission, Mascui, Fraser Canyon.
Mr. Cedar Mission, Masquerades, Fraser Canyon.
Ms. Sidu, Brampton South.
Mrs. Studio, Brampton South.
Mr. Secan.
Mr. Scan.
Mr. Sorbera.
Sorbera.
Mr. Spengeman.
Mr. Spengeman.
Mr. Tabera.
Mr. Tabera.
Mr. Tan.
Mr. Tan.
Mr. Vandal.
Mr. Vandal.
Ms. Vandenbeld.
Ms. Vanderbilt.
Mr. Whalen.
Mr. Whalen.
Mrs. Zaid.
Mrs. Zaid.
Madame Fortier.
Madame Fortier.
Madame Lambropoulos.
Madame Lambropoulos.
Ms. Ing.
Ms. Ing.
Monsieur Hébert.
Monsieur Hébert.
Ms. May, Sandwich Gulf Islands.
Ms. May, Sandwich Gulf Islands.
Mr. Tutu.
Mr. Tutu.
Mr. Kong.
Mr. Kong.
Yeas pour, 117, 117. Nays contre, 168, 168.
I declare the motion defeated. I therefore declare motion numbers 2 to 4 also defeated. Madame Shager, appuyez par...
Ms. Shaker, seconded by Mr. Bryson, moves that Bill C-24, an act to amend the Salaries Act and to make consequential amendments to the Financial Administration Act, be concurred in at report stage with amendments. Is it the pleasure of the House to adopt this motion? All those in favor of the motion will please say yea. All those opposed to the motion will please say nay. In my opinion, the yeas have it.
All those in favor of the motion will please rise.
Mr. Trudeau.
Mr. Trudeau.
Mr. Hare.
Mr. Hare.
Mr. O'Regan.
Mr. O'Regan.
Mr. Sajan.
Mrs. Sajan.
Mr. Goodale.
Mr. Goodale.
Madame Joly.
Madame Joly.
Ms. Freeland.
Ms. Freeland.
Ms. Chager.
Ms. Chager.
Ms. Qualtrough.
Ms. Qualtrough.
Mr. Bryson.
Mr. Bryson.
Ms. Wilson-Raybould.
Ms. Wilson-Raybould.
Mr. Macaulay-Cardigan.
Mr. Macaulay-Cardigan.
Madame Leboutier.
Madame Leboutier.
Madame Bibeau.
Madame Bibeau.
Mr. Hussain.
Mr. Hussain.
Mr. Baines.
Mr. Baines.
Ms. Haidu.
Ms. Haidu.
Ms. Bennett.
Ms. Bennett.
Mrs. Philpott.
Mrs. Philpott.
Mr. Casey Cumberland Colchester.
Mr. Casey Cumberland Colchester.
Mr. Easter.
Mr. Easter.
Mr. McKay.
Mr. McKay.
Mr. Nault.
Mr. Nault.
Ms. Scroll.
Ms. Scroll.
Mr. Lausanne-Argentin, La Petite Nation.
Mr. Lausanne, Argentin, La Petite Nation.
Mrs. Romanato.
Mrs. Romanato.
Mr. Rioux.
Mr. Rioux.
Mr. Blair.
Mr. Blair.
Mr. Casey Charlottetown.
Mr. Casey Charlottetown.
Mr. Carr.
Mr. Carr.
Ms. Monsef.
Ms. Monsef.
Monsieur Rodriguez.
Monsieur Rodriguez.
Mr. Sohi.
Mr. Sohi.
Mr. Garneau.
Mr. Garneau.
Ms. Duncan, Etobicoke North.
Ms. Duncan, Etobicoke North.
Mr. Duclos.
Mr. Duclos.
Ms. Murray.
Ms. Murray.
Ms. Cara.
Ms. Cara.
Mrs. Cesar Chavans.
Mrs. Cesar Chavin.
Mr. Cormier.
Mr. Cormier.
Mr. Wilkinson.
Mr. Wilkinson.
Mr. Lemetti.
Mr. Lemetti.
Mr. Kuzner.
Mr. Kuzner.
Ms. Jones.
Ms. Jones.
Mr. Rusnak.
Mr. Rusnak.
Mr. Eiking.
Mr. Eiking.
Mr. Bagnall.
Mr. Bagnall.
Mr. Paradis.
Mr. Paradis.
Mr. McGinty.
Mr. McGinty.
Mr. Scarpalagia.
Scarpalagia.
Mr. Sims.
Mr. Sims.
Mr. Tansey.
Mr. Tansey.
Mr. Shifke.
Mr. Shifke.
Mr. Varani.
Mr. Varani.
Ms. Goldsmith-Jones.
Ms. Goldsmith-Jones.
Mr. Fillmore.
Mr. Fillmore.
Mr. Algabra.
Mr. Algabra.
Mr. DeCourcy.
Mr. DeCourcy.
Ms. Rudd.
Ms. Rudd.
Mr. Duguid.
Mr. Duguid.
Mr. Miller, Ville-Marie, le Sud-Ouest et des Sœurs.
Mr. Miller, Ville-Marie, le Sud-Est, Île-des-Sœurs.
Mr. Lamoureux.
Mr. Lamoureux.
Mr. McKinnon-Gatineau.
Mr. McKinnon, Gatineau.
Mrs. McCrimmon.
Mrs. McCrimmon.
Mr. Lightbound.
Mr. Lightbound.
Mr. Vaughan.
Mr. Vaughan.
Mr. Mendocino.
Mr. Mendocino.
Mr. Poisson.
Mr. Poisson.
Mrs. Lockhart.
Mrs. Lockhart.
Ms. Young.
Ms. Young.
Mr. Jesnevsky.
Mr. Jesnevsky.
Mr. Dollywall.
Mr. Dollywall.
Mr. Pesky-Salido.
Mr. Pesky-Salido.
Madame Mendez.
Madame Mendez.
Mr. Oliphant.
Mr. Oliphant.
Mr. Dubourg.
Mr. Dubourg.
Mr. Alday.
Mr. Alday.
Mr. Amos.
Mr. Amos.
Mr. Anand Sangri.
Mr. Anand Sangari.
Mr. Arsenault.
Mr. Arsenault.
Mr. Aria.
Mr. Aria.
Mr. Ayoub.
Mr. Ayoub.
Mr. Badaway.
Mr. Badaway.
Mr. Bayless.
Mr. Bayless.
Mr. Boissonneau.
Mr. Bossino.
Mr. Bossio.
Mr. Bossio.
Mr. Bertina.
Mr. Bertina.
Mr. Breton.
Mr. Breton.
Mr. Chen.
Mr. Chen.
Mr. Bruson.
Mr. Bruce.
Mr. Moff.
Mr. Moff.
Ms. Dillon.
Ms. Dillon.
Mr. Biddle.
Mr. Biddle.
Ms. Tassie.
Ms. Tassie.
Mr. Drouin.
Mr. Drouin.
Ms. Zerowitz.
Mr. Zerowitz.
Mr. Assassi.
Mr. Assassi.
Mr. Elkouri.
Mr. Alkouri.
Mr. Ellis.
Mr. Ellis.
Mr. Erskine Smith.
Mr. Erskine Smith.
Mr. Ailson.
Mr. Ailson.
Mr. Fergus.
Mr. Fergus.
Mr. Finnegan.
Mr. Finnegan.
Mr. Fisher.
Mr. Fisher.
Mr. Fonseca.
Mr. Fonseca.
Mr. Fragascatos.
Mr. Fragascatos.
Fraser West Nova.
Mr. Fraser West Nova.
Mr. Fraser Central Nova.
Mr. Fraser Central Nova.
Mr. Fuhrer.
Mr. Fuhrer.
Mr. Garrettson.
Mr. Garrettson.
Mr. Graham.
Mr. Graham.
Mr. Greywall.
Mr. Greywall.
Mr. Hardy.
Mr. Hardy.
Mr. Harvey.
Mr. Harvey.
Mr. Housefather.
Mr. Housefather.
Ms. Hutchings.
Ms. Hutchings.
Mr. Yakino.
Mr. Yakino.
Mrs. Jordan.
Mrs. Jordan.
Mr. Johari.
Mr. Johari.
Ms. Khalid.
Ms. Khalid.
Madame Lapointe.
Madame Lapointe.
Monsieur Lefebvre.
Mr. Lefebvre.
Mr. Levitt.
Mr. Levitt.
Mr. Long.
Mr. Long.
Mr. Longfield.
Mr. Longfield.
Ms. Ludwig.
Ms. Ludwig.
Mr. Maloney.
Mr. Maloney.
Monsieur Massé, Avignon, Métis, Matane, Matapédia.
Mr. Massé, Avignon, le Métis, Matane, Matapédia.
Mr. May Cambridge.
Mr. May Cambridge.
Mr. McDonald.
Mr. McDonald.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. McLeod, Northwest Territories.
Mr. McLeod, Northwest Territories.
Mr. Morrissey.
Mr. Morrissey.
Madame Nessif.
Madame Nessif.
Ms. O'Connell.
Ms. O'Connell.
Mr. Oliver.
Mr. Oliver.
Mr. Willett.
Mr. Willett.
Mr. Peterson.
Mr. Peterson.
Mr. Picard.
Picard.
Mr. Robillard.
Mr. Robillard.
Mr. Rumi.
Mr. Rumi.
Mr. Hota.
Mr. Hota.
Mr. Saini.
Mr. Saini.
Mr. Sanson.
Mr. Sanson.
Mr. Sanga.
Mr. Sanga.
Mr. Sarai.
Mr. Sarai.
Mrs. Schultz.
Mrs. Schultz.
Mr. Seri.
Mr. Seri.
Madame Shanahan.
Madame Shanahan.
Mr. Sheehan.
Mr. Sheehan.
Mr. Sidhu Mission Masque Fraser Canyon.
Mr. Sidhu Mission Masquerade Fraser Canyon.
Mr. Sidhu Brampton South.
Mr. Sidhu Brampton South.
Mr. Secan.
Mr. Secan.
Mr. Sorbera.
Sabera.
Mr. Spengeman.
Mr. Spengeman.
Mr. Tabera.
Mr. Tabera.
Mr. Tan.
Mr. Tan.
Mr. Van Dav.
Mr. Van Dahl.
Ms. Vandenbeld.
Mr. Vandenberg.
Mr. Whalen.
Mr. Whalen.
Mrs. Zaid.
Mrs. Zaid.
Madame Fortier.
Madame Fortier.
Madame Lambropoulos.
Madame Lambropoulos.
Ms. Ing.
Ms. Ing.
Monsieur Hébert.
Monsieur Hébert.
Ms. May Sandwich Gulf Islands.
Miss May Sandwich Gulf Islands.
Mr. Tutu.
Mr. Tutu.
Mr. Kong.
Mr. Kong.
Tous ceux qui s'opposent à la motion veuillent bien.
All those opposed to the motion will please rise.
Miss Bergen.
Mr. Nicholson.
Mr. Nicholson.
Ms. Finley.
Miss Finley.
Mr. Blaney Belchas, Les Etamé Lévy.
Mr. Blaney Belchas, Les Humaines Lévy.
Mr. Allison.
Mr. Allison.
Mr. Kent.
Mr. Kent.
Mr. Poiliev.
Mr. Poliev.
Mr. Fast.
Mr. Fast.
Mr. Bernier.
Mr. Bernier.
Mrs. McLeod, Campbell, Thompson, Caribou.
Mrs. McLeod, Cameron, Thompson, Caribou.
Mrs. Block.
Mrs. Block.
Mr. Clement.
Mr. Clement.
Mr. Van Loan.
Mr. Van Loan.
Mr. Albus.
Mr. Albus.
Mr. Doherty.
Mr. Doherty.
Mr. Polius.
Mr. Polius.
Mr. Barlow.
Mr. Barlow.
Mr. Bertot.
Mr. Bertot.
Mr. Deadtel.
Mr. Deadtel.
Mr. Chong.
Mr. Chong.
Mr. Reed.
Mr. Reed.
Mr. Workington.
Mr. Workington.
Mr. Straw.
Mr. Straw.
Mrs. Stubbs.
Mrs. Stubbs.
Mrs. Vecchio.
Mrs. Vecchio.
Mr. Abu Taif.
Mr. Abu Tayyip.
Mr. Kelly.
Mr. Kelly.
Ms. Gladue.
Ms. Gladue.
Mr. McColman.
Mr. McColman.
Mr. Tilson.
Mr. Tilson.
Mr. Warwa.
Mr. Warwa.
Mr. Sopak.
Mr. Sopak.
Mr. Sorensen.
Mr. Sorensen.
Mr. Miller, Bruce Gray, Owen Sound.
Mr. Miller, Bruce Gray, Owen Sound.
Mr. Brown.
Mr. Brown.
Mr. Richards.
Mr. Richards.
Mr. Nader.
Mr. Nader.
Mr. Broussard.
Mr. Broussard.
Mr. Generou.
Mr. General.
Mr. Anderson.
Mr. Anderson.
Mr. Soroya.
Mr. Soroya.
Madame Boucher.
Madame Boucher.
Mr. Mr. Trost.
Mr. Trost.
Mrs. Gallant.
Mrs. Gallant.
Mr. Falk.
Mr. Falk.
Mr. Generer.
Mr. General.
Mr. Gould.
Mr. Gould.
Mr. Shipley.
Mr. Shipley.
Mr. Van Kesteren.
Mr. Van Kesteren.
Mr. Lake.
Mr. Lake.
Ms. Leach.
Ms. Leach.
Mr. Jennis.
Mr. Jennis.
Mr. Laub.
Mr. Law.
Mr. Albrecht.
Mr. Albrecht.
Mr. Dreesen.
Mr. Dreesen.
Mr. Zimmer.
Mr. Zimmer.
Mr. McGuire.
Mr. McGuire.
Mr. Cooper.
Mr. Cooper.
Mr. Clark.
Mr. Clark.
Mr. Godin.
Mr. Goodin.
Mr. Arnold.
Mr. Arnold.
Mr. Lozan Storman Dundas South Glengarry.
Mr. Lomans Lausanne Stormont Dundas Glengarry.
Mr. McKenzie.
Mr. McKenzie.
Mr. Yordega.
Mr. Ordega.
Mr. Glinsky.
Mr. Glinsky.
Mr. Diop.
Mr. Diop.
Mr. Kitchen.
Mr. Kitchens.
Mr. Calkins.
Mr. Calkins.
Mr. Leipert.
Mr. Leipert.
Mr. Schmale.
Mr. Schmale.
Mr. Macaulay Edmonton West.
Mr. Macaulay Edmonton West.
Mr. Shields.
Mr. Shields.
Mr. Vierson.
Mr. Vierson.
Mr. Waugh.
Mr. Waugh.
Mr. Weber.
Mr. Weber.
Mr. Motz.
Motz.
Mr. Benzin.
Mr. Benzin.
Mr. Lloyd.
Mr. Lloyd.
Mr. Caron.
Mr. Carroll.
Mr. Julian.
Mr. Julian.
Ms. Matheson.
Ms. Matheson.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan Edmonton Strathcona.
Mr. Christopherson.
Mr. Christopherson.
Madame Laverdière.
Madame Laverdière.
Mr. Cullen.
Mr. Cullen.
Mr. Garrison.
Mr. Garrison.
Madame Boutin-Suite.
Madame Boutin-Suite.
Mr. Dubé.
Mr. Dubé.
Madame Brosseau.
Madame Brosseau.
Mr. Rankin.
Mr. Rankin.
Mr. Davies.
Mr. Davies.
Monsieur Dussault.
Mr. Dussault.
Madame Moore.
Madame Moore.
Ms. Kwan.
Ms. Kwang.
Monsieur Aubin.
Mr. Aubin.
Monsieur Nantel.
Mr. Nantel.
Madame Quach.
Madame Quach.
Mr. Blakey.
Mr. Blakey.
Madame Sansouci.
Madame Sansouci.
Monsieur Choquette.
Mr. Choquette.
Madame Trudel.
Madame Trudel.
Mr. Weir.
Mr. Weir.
Mr. Duval.
Mr. Duval.
Mr. Cannings.
Mr. Cannings.
Mr. Johns.
Mr. Johns.
Mr. McGregor.
Mr. McGregor.
Ms. Ramsey.
Ms. Ramsey.
Ms. Malcolmson.
Ms. Malcolmson.
Ms. Hardcastle.
Ms. Hardcastle.
Madame Hughes.
Madame Hughes.
Monsieur Barcelou-Duval.
Mr. Barcelou Duval.
Monsieur Plamondon.
Mr. Plamondon.
Monsieur Sainte-Marie.
Mr. Saint-Marie.
Monsieur Marcel.
Mr. Marcel.
Madame Posé.
Madame Posé.
Monsieur Fortin.
Mr. Fortin.
Monsieur Thériault.
Mr. Thériault.
Monsieur Beaulieu.
Mr. Beaulieu.
Yeas pour 168, 168. Nays contre 118, 118.
Je déclare la motion adoptée.
I declare the motion carried.
Et quand ce projet de loi sera-t-il
When shall the bill be read a third time?
à la prochaine séance de la...
At the next sitting of the House.
Maintenant, à ce moment-ci, conformément à...
Now, pursuant to Standing Order 38, a motion to adjourn the House is deemed to have been moved and seconded at this time. Therefore, the question is that this House do now adjourn.
Order. Allowed.
Order.
And aux honorables députés.
I would urge honorable members who wanted to continue their conversations to take them out of the House and into their respective lobbies.
Nous allons procéder.
We are going to proceed with the adjournment debate.
For Edmonton Strathcona.
Thank you, Mr. Speaker. Mr. Speaker, on Monday, September 25th of this year, I raised this concern that while the government claims it's seeking inclusion of strong environment and climate provisions in a modernized NAFTA, no such measures have been publicly revealed, and no environment advisors have been appointed to the Council advising the Minister of Foreign Affairs, who is leading negotiations on NAFTA. Only at the 11th hour has the Minister of Environment and Climate Change announced she has now formed a NAFTA subgroup. None of the recommendations have been made public, nor has it been revealed whether their proposals have even been tabled in the negotiations. Mr. Speaker, how can Canadians have faith that the Liberals are strengthening environment and trade deals without transparency? And when will the minister reveal to Canadians what the Liberals are actually seeking for the environment at the negotiation table? The Americans at the onset of the negotiations publicly released their proposals for environmental provisions of a revised NAFTA. So where, Mr. Speaker, is this oft-touted Liberal government's openness, transparency, and accountability? Here are some important questions requiring an answer. Is Canada proposing to shut down the Independent Commission for Environmental Cooperation based in Montreal, created under the current NAFTA? Is Canada proposing to reduce senior-level oversight over commitments for effective environmental enforcement and not to downgrade environmental laws by replacing authority vested in the Council of Ministers with instead junior-level bureaucrats? And is this government recommending shutting down the Secretariat, thereby ending any independent reviews and reports on allegations of failed enforcement? And finally, Mr. Speaker, what is the baseline for Canadian environmental law? Is it the yet-to-be-strengthened laws eviscerated by the Harper government?
Well, Parliamentary Secretary to the Minister of the Environment and Climate Change.
Mr. Speaker, Canada is firmly committed to the principle that trade and investment liberalization and environmental protection go hand in hand and is advancing a progressive approach to trade. Canada believes that commitments to high levels of environmental protection are an important part of all trade agreements, including NAFTA. Such commitments to good environmental governance in our trade agreements can help improve conditions for Canadian investment by promoting stable, predictable, and transparent environmental regulatory frameworks and institutions in partner countries. L'accord nord-américain de...
The North American Agreement on the Environment under NAFTA clearly reflects the importance Canada places and has placed for a long time in environmental provisions. Since 1994, the agreement has served as an important mechanism to guarantee our strong and firm commitments to high levels of environmental protection and offer a forum for governmental cooperation.
Move towards modernizing NAFTA, we see an opportunity to strengthen the environmental provisions under the agreement to ensure that environmental standards continue to be upheld as part of our trade and investment relationship. One of Canada's core objectives for these negotiations is that NAFTA can be made more progressive. This includes integrating high ambition and enforceable environmental provisions into NAFTA, which fully supports efforts to address climate change and other global environmental challenges. Canada is seeking commitments for NAFTA countries to maintain high levels of environmental protection, as well as provisions to ensure that domestic environmental laws are both effectively enforced and not weakened to encourage trade and investment. Canada is seeking to secure progressive elements such as those achieved in the Canada-European Union Comprehensive Economic and Trade Agreement, including provisions that seek to reaffirm the state's right to regulate in the public interest and provisions promoting the trade in environmental goods and services. We have announced the establishment of the NAFTA Advisory Council on the Environment last August. The 10-member council brings together prominent Canadians with a variety of backgrounds, including in politics, law, environment, and Indigenous groups. This expert council includes former Quebec Premier Pierre-Marc Johnson, former British Columbia Premier Gordon Campbell, former Saskatchewan NDP Finance Minister Janice McKinnon, and Inuit Virsat Kanatami President Natan Obed. The council members are supporting the advancement of our government's progressive trade agenda by serving in their personal capacity to advise the Minister of Environment and Climate Change Canada as Canada looks to strengthen environmental protections in a modernized NAFTA.
Honourable Member for Edmonton Strathcona.
Thank you, Mr. Speaker. Well, in follow-up, I'm disappointed that I didn't obtain answers to any of the questions that I put. In all of the trade deals that were negotiated under the Conservative government and now by this government, they have not rechained the provisions that are in the side agreement to NAFTA, and that is an independent council, an independent secretariat, and high-level oversight over decisions on whether or not trade deals or business is actually undermining environmental protection. So my clear answer is, is this government proposing at the table? Will they let the public know what they're proposing at the table? And is it their intention to retain these very important measures that have actually delivered a lot? I had the privilege of working with the Secretariat. We delivered a lot of very good work. There's been a lot of good work dealt by the Independent Secretariat on reviewing submissions claiming failed enforcement. But what has failed is the response by governments to those reports. So my clear question is, when is this government going to finally reveal to the public what they are bringing forward at the table so that we can know whether or not this future NAFTA, in fact, will be a stronger or will it be weaker?
The Honourable Parliamentary Secretary to the Minister of the Environment.
Thank you, Mr. Speaker. I think I was pretty clear that the focus of this government is on enhancing and raising the environmental bar with respect to the provisions, the environmental provisions of NAFTA. And I think, one needs to look at the track record. Canada has successfully included provisions on climate change in recent agreements, such as CETA, recognizing the need to cooperate amongst trading partners and the important role the trade agreements play in facilitating market access. So, the focus for us is ensuring that the environment is robustly considered in the context of all trade agreements going forward. We're raising the environmental bar, and that's a good thing for Canada.
The Honourable Member for Peace River Westlock.
Mr. Speaker, earlier this month, I highlighted the fact that every year, hundreds of young Canadian women, girls and boys are lured into the vicious cycle of sex trafficking. I asked when the Liberal government would start fighting this horrific form of modern-day slavery. This is not the first time I've raised this issue of sex trafficking and the lack of action by this government. In fact, exactly 1 year ago, I stood here raising the same issue during an adjournment, and in the past 12 months, this government has done nothing. In fact, since coming to power, the Liberals have allowed the fight against human trafficking to languish. The Liberals allowed the National Action Plan to combat human trafficking to expire. They ended funding for NGOs. They've blocked important tools for police that were adopted by this House over 4 years ago. And then the Liberals introduced legislation, Bill C-38, to lighten sentences for sex traffickers. A week ago, the Parliamentary Secretary to the Minister of Public Safety, in his response to my question during question period, claimed the government's Bill C-38 would give police and prosecutors new tools to investigate human trafficking. Now, I would never suggest that the member was misleading the House, but I would rather give the member the benefit of the doubt that he may not have read Bill C-38 in answering the question. Because if he had read it, he would know that Bill C-38 is only one paragraph and does not have any provisions whatsoever that give police, peace, or prosecutors new tools to investigate human trafficking. Even the Minister for Justice, when she introduced Bill C-38 last February, wrongly claimed that C-38 had tools for police and prosecutors to combat human trafficking. However, the tools they pretend are in C-38 were in fact unanimously adopted by this House 4 years ago in an NDP private member's bill, C-452, which was supported by a Conservative government and voted on by the current Prime Minister. It was C-452 that created the presumption with respect to the exploitation of one person by another, added the offence of trafficking in persons to the list of offences to which the reverse onus forfeiture of proceeds of crime provisions would apply, corrected a technical discrepancy, and included a provision of human trafficking sentence would be served consecutively. Bill C-452 received royal assent in June 2015. Then the Liberal government came into power and has since blocked Bill C-452 from coming into force. Why? Because the Liberals don't like the idea that sex traffickers might face consecutive sentences. They feel that it's too harsh to expect that a child trafficker should serve a long sentence for exploiting a minor in sex slavery. All Bill C-38 does is prevent sex traffickers from receiving consecutive sentences. That's it. Nothing more. It certainly doesn't help the police. Mr. Speaker, 80% of victims of sex trafficking have never come forward out of fear. All of the human traffickers investigators who have testified on Bill C-452 welcomed the consecutive sentencing and highlighted that it was long sentences give victims the confidence to come forward and testify. They also point out that without consecutive sentencing, a pimp who traffics only one minor will receive the same sentence as a pimp who traffics 5 or 10 minors. Consecutive sentencing allows for punishments that better reflect the gravity of the situation. So, Mr. Speaker, when will this government stop misleading the public about C-38? When will they stop blocking important tools for the police? And when will the Liberals stand up for the victims of sex trafficking instead of blocking tougher sentences for those who enslave them? Thank you, Mr. Speaker.
The Honourable Parliamentary Secretary to the Minister of Justice.
Well, thank you, Mr. Speaker. And, you know, it's regrettable to hear that kind of hyperbole and that kind of rhetoric from my honourable colleague who is, you know, would be more appropriate to hear that from his usual seat in the House. I noticed that he's come on this side of the aisle. And on this side of the aisle, we actually are quite proud of our record when it comes to human trafficking. And I'll get to that in just a moment, Mr. Speaker, but I would point out that maybe it wasn't my honourable colleague, but certainly the last Conservative government cut close to $1 billion from the public safety portfolio, including from the CBSA, from the RCMP, and all of that undermines many of the gross assertions that he just made. But now returning to the question at hand, human trafficking is a heinous crime and a human rights offence. In collaboration with provinces and territories, Indigenous communities, law enforcement and community organizations, as well as international partners, we are using a wide variety of measures to combat human trafficking, to support victims and potential victims, and to ensure that perpetrators are brought to justice. Indeed, the National Action Plan to Combat Human Trafficking was a 4-year initiative that ran until last year. Since then, Public Safety Canada has been leading a formal evaluation of the action plan to help inform how we move forward on this important issue. While that evaluation has been going on, federal departments and agencies have continued to combat human trafficking through a full range of initiatives. We have, for example, and my honourable colleague referred to it, introduced Bill C-38. And contrary to what he said, this House has debated and thoughtfully had a discourse about reversing some of the presumptions or easing some of the presumptions when it comes to the burden of proof so that prosecutors can ensure that offenders who participate in human trafficking are held to account. And unlike the last Conservative government, we believe that we have an appropriate sentencing regime where we place faith in our judiciary. That means not supporting unconstitutional mandatory minimums like the last Conservative government introduced and which have been struck down by the Supreme Court of Canada. That means ensuring that we have an appropriate mandatory minimum sentencing regime, one that is evidence-based. But let me just continue for a moment. In addition to Bill C-38, we've also introduced Bill C-21, which will be an important new tool to help combat cross-border crimes. The RCMP has several initiatives that target human trafficking. Their Human Trafficking National Coordination Centre conducts public awareness campaigns, training, and awareness sessions for law enforcement and stakeholders, as well as national threat assessments on human trafficking. And this past October, the RCMP partnered with police agencies and community organizations across Canada in a coordinated anti-trafficking effort called Operation Spotlight. There was also Project Protect, a joint initiative between the Government of Canada and the private sector. It allows Canadian financial institutions to report transactions that are suspected of money laundering related to trafficking in persons for sexual exploitation. The impact of Project Protect on identifying suspicious transactions linking money laundering to human trafficking has been phenomenal. In 2015, prior to Project Protect, there were 19 such disclosures. In 2016-2017, the government made over $21 million available to provinces, territories, and non-governmental organizations through the Federal Victims Fund. And in Budget 2017, Mr. Speaker, you will recall that the government allocated $100.9 million over 5 years to establish a national strategy on gender-based violence, which obviously overlaps with human trafficking. The point being, Mr. Speaker, that on this side of the House, contrary to where my honourable colleague is currently sitting, we believe in evidence-based policy making. We believe in supporting our law enforcement branches to ensure that women and girls are protected as part of our overall national plan when it comes to human trafficking. Thank you, Mr. Speaker.
Honourable Member for Peace River, Westlock.
Well, Mr. Speaker, if the Liberals were investing in fighting sex trafficking, why did they allow the National Action Plan and its funding to expire a year ago? They had a whole year to get their plan in place, and now we're one of the only countries in the Western world that does not have any strategy to combat human trafficking. In 2011, the Conservatives were the first and only political party in Canadian history to make human trafficking an election promise. 12 months later, in 2012, the Conservatives fulfilled their promise and launched the 4-year action plan to combat human trafficking. This plan included funding for survivors and law enforcement and focused on 4 areas: to protect, to prosecute, prevent, and partnerships. A year later, the Conservative government launched a special RCMP enforcement combat human trafficking team force, and this led initiatives to combat human trafficking at the UN. Mr. Speaker, it's been 2 years since the Liberals were elected and no action to combat human trafficking. Will this government commit to developing a new action plan to combat human trafficking and restore the support for victims of sex trafficking and law enforcement? Will this government work with the opposition to fight modern-day slavery together?
Honourable Parliamentary Secretary.
Mr. Speaker, I want to assure my colleague that we have been evaluating the National Action Plan in order to ensure that we can make Canada's efforts to combat human trafficking stronger and more effective. And as I outlined, that evaluation has been happening simultaneously with a comprehensive suite of measures both within Canada and on an international scale. Canada continues to work with international partners and agencies such as the United Nations Office on Drugs and Crime, the International Office for Migration, and Interpol, among others, to fight against human trafficking and provide technical assistance and capacity building, enabling the global effort to successfully address trafficking in persons. And we engage regularly with the United States and Mexico through the Trilateral Working Group on Trafficking in Persons. The fight against human trafficking, both at home and internationally, is a moral imperative, and it is of the utmost importance for our government. I would urge my honourable colleague, since he's sitting on this side of this House, to support this side of the House's important work on this important file. Thank you, Mr. Speaker.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 10 a.m. pursuant to Standing Order 24-1.